I declare open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the oversight of ASIC, the Takeovers panel and the corporations legislation. I begin today by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land on which we meet, and pay my respects to the elders past and present, and I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via video teleconference. These are also public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It's also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind any committee members and witnesses who are appearing via video teleconference to mute their microphones when they are not speaking. Before we commence, Mr Powell, can we just confirm who's with us?
It's just the committee members in the room so far. We've got Senator Hume, Senator Sharma by video, and that's the current.
Thank you very much. I might just get my colleagues in the room now to introduce themselves.
Madonna Jarrett, member for Brisbane.
Ellie Whittaker, Senator for Western Australia.
Tanya Lawrence, member for Hasler from Western Australia.
Deborah O'Neill, Senator for New South Wales.
Barbara Pocock, Green Senator for South Australia.
And Senator Hume.
Yes, hi, Senator Hume from Victoria.
Senator Sharma.
Yeah, hello, Dave Sharma, New South Wales.
Thank you very much. I now welcome representatives from the Australian Securities and Investments Commission. I understand information on parliamentary privilege and the protection of witnesses giving evidence at Senate committees has been provided to all of you. For the Hansard record, will you please state your full names and the capacities in which you appear today? We might start with you, Mr Longo.
Good morning, Chair. Name Joseph Longo, Chair of ASIC. I'd like us to get up and down the table, and then I can start my opening remarks.
Yeah, perhaps we start with Mr Gregson.
Thank you, Chair. My name is Scott Gregson. I'm the Chief Executive Officer of ASIC.
Simone Constant, a Commissioner with ASIC.
Sarah Court, Deputy Chair of ASIC.
Kate O'Rourke, Commissioner.
Chris Savundra, Executive Director of Enforcement and Compliance at ASIC.
Thank you very, very much. I now invite you to make an opening statement, Mr Longo, Chair Longo, and at the conclusion of any remarks, I will invite members of the committee to ask questions. My intention, colleagues, as this is the first time that we have gathered as the new Parliamentary Joint Committee for Corporations and Financial Services in the 48th Parliament, is to commence with questions as the Chair. Normally I would go to the Deputy Chair. Sadly, he's an apology today. And then I will seek to share the call amongst my colleagues and continue in that fashion throughout the day. Mr Longo, Chair Longo, you have the call.
Thank you, Chair O'Neill. Thank you, Senator. Just a couple of other aspects about who's here and who isn't here. Commissioner Alan Kirkland, who would normally be here, is an apology due to being on leave. I just thought otherwise he would have been here. And we're also joined by Senior Executive Leader Leah Shucker, who's just sitting behind me, who may also be called upon to assist depending on where the questions might go. The committee would have seen that we provided a submission, but I'll make some short introductory remarks now, as has become customary over a long period. From the day I took this job, I wanted ASIC to be a modern, confident and ambitious regulator. The strategies and structures we have put in place over the past 5 years are delivering on this stated objective. We are taking a more proactive approach to regulatory problems of the day. And as a law enforcement agency, we are taking more strategic and a more bold approach in the matters we choose to investigate, addressing the most pressing harms in our regulatory environment. We'll be happy to discuss both areas, obviously, in detail today. The transformation of our agency has helped to deliver a 50% increase in investigations and a nearly 20% increase in new civil enforcement proceedings in the past year. In the first 6 months of 2025, we commenced 132 new investigations, compared to 63 investigations in the same period last year. Can I just pause there when we talk about investigations, we're talking about a fully resourced matter where the full range of ASIC's compulsory information gathering powers, search warrants and the like are used. These are very resource intensive and require a lot of skill to execute on. 23 new court actions compared to 12 new actions in the same period last year. In the last 6 months, we also secured 6 criminal convictions and $57.5 million in civil penalties. You might wonder why it's only 57.5 in light of the announcement we made a few days ago. It's because the court hasn't imposed those penalties yet. ASIC and ANZ will be, as I'll come to in a moment, will be asking the court in a joint submission to impose those penalties. We, of course, don't have the power to unilaterally impose penalties. You will have noted this week the significant actions ASIC took concerning ANZ. Our actions reflect our serious and ongoing concerns about ANZ's conduct over many years and its failure to manage non-financial risk. Reflecting the seriousness of these matters, ASIC and ANZ will ask the Federal Court to impose penalties totalling $240 million in relation to 4 proceedings that were filed last weekend. ANZ has admitted to engaging in unconscionable conduct in services it provided to the Australian government, incorrectly reporting its bond trading data to the Australian government, that's the AOFM, the Australian Office of Financial Management, by overstating the volumes by tens of billions of dollars, and to widespread misconduct across products and services impacting nearly 65,000 customers. We are significantly invested in enforcement action relating to high-risk super switching. ASIC has focused heavily on protective measures, including consumer education and warning campaigns, calling on Australians to be on red alert for high-pressure sales tactics, clickbait advertising and promises of unrealistic returns. Our first priority has been to preserve any remaining assets of the schemes to the extent they are available, so that they can be recovered for investors. We are also actively exploring avenues for compensation for victims. We are also concerned about the adequacy of due diligence and monitoring of high-risk products by superannuation trustees. We recently commenced landmark court action against Equity Trustees Superannuation Limited, alleging failures in its due diligence concerning the Shield Master Fund. In addition, we have cancelled the AFS licence of MWL Financial Services and taken Feras Merhi to court over his conduct. We've been in court more than 40 times already. 40 times. Executed search warrants, frozen assets and cancelled the licences of advisors. Further action is not just possible, it is increasingly likely as we continue with these investigations. Our investigations into these high-risk super investment matters, I have to tell this committee very frankly, are complex, very resource intensive, and they're ongoing. They include numerous lines of inquiry and a large number of entities and individuals, including lead generators, financial advisors, advice licensees, superannuation trustees, the research houses, auditors and the managed investment schemes. As Deputy Chair Court has said, this is misconduct on an industrial scale and it's requiring a lot of our resources to get a grip on the whole situation. While our first priority has been preserving assets for the benefit of investors, the next phase will be about holding key players to account. We have and continue to be active in significant work from launching an inquiry into ASX, our groundbreaking work in identifying issues in public and private markets, and issuing reports on death benefits and better banking and beyond, with consequential redress for consumers, often in vulnerable situations. Our proactive work to identify ways we can simplify the experience stakeholders have in engaging with ASIC has been well received. So, while we are now positioned more strongly to respond to issues in our regulatory environment than we were 5 years ago, challenges remain. ASIC is not a complaint handling body, nor are we resourced to investigate and litigate every instance of alleged misconduct that comes to our attention. This means we must make careful and often difficult choices about where we direct our attention and where we deploy our resources. Our ability to detect and respond to misconduct is increasingly strained by the exponential amount of data being provided to us and the progressively sophisticated technologies of our regulated population. We continue to invest in our legacy technologies and measures to uplift our data capabilities. So that's us investing in old technologies, trying to uplift them to modernise them. But like many public sector organisations, we are facing growing demands on our resources. Underinvestment in ASIC poses a risk to our regulatory work. Significant investment in digital technologies is needed to prevent misconduct. As we continue on our journey of transformation, we will continue to focus on investing in data, systems and technology to protect Australians and reduce the regulatory burden on business. We stand ready to assist the committee, Chair, with its inquiries, and we are happy to provide further detailed briefings around areas of interest for the committee. Thank you. We look forward to a productive conversation today.
Thank you very much, Chair Longo. And I might commence with just a couple of lines of questioning, which I'm sure we'll return to over the course of the day. I note your submission to this committee. Thank you for that. It has become the practice of the committee in recent years to provide the opportunity for ASIC to give us a clear briefing on matters. One of our key responsibilities is oversight of ASIC, and that is our statutory responsibility. So this is vital work for the committee. Hopefully you find it helpful. We certainly endeavour to do our best in the national interest. So can I just observe that you indicated in your report that there were 45 appearances before court with regard to First Guardian and Shield. And for people who are following along at home, this is people's superannuation, right? So very proud to be a Labor senator, part of the team that envisioned this for Australia now at a point where we've got $4 trillion under management. It is important for us to continue to fortify that system to make sure it delivers for Australians, and certainly there have been a lot of problems. 45 appearances to try and get money from First Guardian and Shield to get back to the people who were ripped off, and I'm going to just call it what it was, ripped off. That's how Australians will be talking about this. 40 of your staff working on this project, according to your submission. How many Australians were affected by this, Chair Longo?
We think many thousands. The two funds, I think the numbers are between 10 and 15,000. I could stand to be corrected. But I regret to inform the committee it's even more than that, because there are a range of funds that we're looking at, a range of investigations we're looking at, and the number of investors who have been affected by this conduct is, I would have thought, closer to 25 or 30,000. But certainly for Shield and First Guardian, it's in the order of 10 to 15,000.
It is.
Yeah, Sarah?
The number, Senator, it's 11,000 consumers who have invested approximately $1.1 billion through the Shield Master Fund and the First Guardian Master Fund.
And I want to express thanks that the action is being taken, and it's being taken so seriously, but you'd be well aware of concerns about the time it took to get things up and running, and the opportunity for people to flee with the money or to secure Australians' dollars overseas. That's part of what's going on here. So I want to take the opportunity of having you here today for public education, and I mean in the broadest sense of the word. If you're an Australian, you're of working age and you have superannuation, if somebody rings you up and says, I can get you more money using your superannuation, trust me, because that's it in a nutshell, you should hang up. Is that the message, Mr Longo? Do not speak to people on the telephone about moving your superannuation. It is too risky.
Well, essentially what happened here is too many people were convinced to move their super from what I would call a relatively safe, conventional environment major superannuation fund.
So what does that mean? You go to work, you put your money into, somebody tells you where's a good, safe place to put it.
Yeah, a well-known superannuation fund.
It could be a retail fund. It could be an industry fund. And people would hear names like, Host Plus or,
UniSuper and Aussie Super.
Macquarie Bank aligned super. They think all of these things are very safe, and usually it's their employer that sets them up, right? And people are in.
Yeah. What differentiates this situation is it's hard to get away from the phrase industrial scale. This is a very sophisticated, coordinated series of players who have coordinated their activities in a way to persuade people to move their money from one place to another. And and they've been sort of tricked into thinking that they can get better returns either through starting up a self-managed superannuation fund. That's part of the story here, but most of the money went into managed investment schemes or products that were hosted on the platforms of superannuation trustees. And they were persuaded to do this by, as in my opening remarks say, through a combination of responding to something they've read. They get called by a lead generator, someone who excites further their interest. They then get connected with a licensed financial advisor, and it goes on from there.
So before we go too far, Chair Longo, often in these places, because we have erudite witnesses, it doesn't translate into a very digestible message at 10 o'clock on a Friday night in a pub where the discussion might come up. But the person at 10 o'clock in the pub who's having a conversation about their superannuation is the prime target for this industrial attack on their superannuation.
I think the message is incredibly simple and powerful. And the message is, you're talking about your life savings. Don't move them until you are morally certain that they're going to a better place than they are at the moment.
So the safe harbours for people's superannuation are the retail funds and the big retail funds.
The example I've given in speeches, and I know Deputy Chair Court has come up with examples as well, that the sort of thought that you put into buying a house, or indeed to selling a house, or into saving for a house, people really think very long and hard, don't they, before they invest. That's the major investment for most Australians is buying a house. So my message is, someone calls you up and says, we want you to move your 250,000 or 500,000 from one place to another, stop. Like, that's very nice, thank you for that message. What's your number? I'll call you back if I'm interested. Then sleep on it. There's no rush. This is superannuation money. You can't get access to it anyway until you're 70 or something. So there's no rush here. There's no urgency to move your money from one place to another if it's superannuation money. That's the whole point of superannuation. You don't get access to it until, you retire, or whatever the word is these days.
Thank you for the clarity of that message, because that is part of the
And the real
challenge.
tragedy here is and I'd like Deputy Chair Court to talk about this because she's actually listened to some of the transcripts. It's a very slick operation, isn't it?
But let's hear, if people are listening, ordinary Australians, how do these scammers, how do these criminals manage to get under people's gaze, establish the trust, and then take their money from them in a single phone call even? Right. How on earth is that happening? What techniques are they using? Thank you.
I might hand that one over to... Could you've actually listened to the transcript? Yeah.
No, thanks, Senator. And I have listened to some of the telephone calls. And as Mr Longo says, these are very sophisticated operations. The way that the system or that these incidents work typically is that somebody is on a social media feed, and an advertisement of some sort pops up on that feed with a heading something like "Do a super health check, compare your super." So one of those kind of phrases. And I think many Australians they know superannuation is important. They know they should be shopping around to get good returns. They think I should do the responsible thing and check that. They then complete their details on the social media advertisement, and then shortly afterwards they get a telephone call. One of the issues, and I think we spoke about this when we last met, Senator, one of the laws that model gets around is the anti-hawking laws, because those laws prohibit unsolicited contact. Because the superannuant has put in his or her details, that's a solicited contact.
Okay, so there's the con. So let's be clear about it.
That's one issue. Yeah.
As soon as you get a feed,
yes,
there's no benefit, there's no better return on your superannuation if it's all been ripped off by somebody, right? So if somebody says, let me do a health check for you, that's your first warning. You stop then and go, not interested, I'm going to ring up somebody that I trust. By my own choice, I'm not going to wait for this information, because the minute you put your information into their website, they say, but you gave us permission to do this.
To contact you.
And now we can get around all the laws that are set to protect you, because we're going to put somebody on a phone, which is what you're calling hawking. So they're getting somebody on the phone to try and sell you, and their clear intention is to get their hands on your money.
Yes. Well, they can't get around all the laws that are set to protect people, and the numerous court actions that Mr Longo has referred to are many examples of a range of laws that ASIC is seeking to enforce on these issues, and we can talk about those more, Senator. But at the beginning of this chain, absolutely, the fact that the superannuant has solicited the contact gets around the anti-hawking laws, and that's one of the issues that we're giving deep thought to and working with Treasury on. The telephone call then starts, and as Mr Longo says, it is a very sophisticated conversation. The ones I've listened to, it doesn't appear like a hard sell. It appears like a soft sell, if you like.
Somebody's friendly who's here to help you. That's the way it comes across.
Exactly. They're not initially. There's no pressure. There's no. You're not rushed. It's not the kind of call I think that you would instinctively think, oh, I should hang up. This is a bad thing. The calls go on for a very long time, and they solicit more and more information about the person's superannuation, more and more details, and it's at that stage, and sometimes these calls go for hours, that the person gets slowly worn down. And of course, I think I mentioned 11,000 consumers. Each and every one of their experience is slightly different, so each one of them deals with a different lead generator and then a different advisor. One of the problems or things that we're most concerned about is in the course of the telephone call, at some stage, the investor or the superannuation member decides that, yes, they will get some financial advice. The advisor, the lead generator, then switches them through to the financial advisor in the course of the same telephone call. Often, and this is where there is an issue in terms of this is unlawful for there to be cookie-cutter, perfunctory financial advice, but these are licensed financial advisors that are advising the superannuation member to move their super from one of the funds we were talking about earlier.
And who are they licensed by?
So they are licensed by ASIC, and one of the things of the myriad of issues we've been doing is banning and investigating. In fact, I think we had a paper at the one of our commission meetings yesterday where there are 140 individuals that we are in the process of looking at. 20 of those have already had court action, 50 of them are current investigations, and 70 more we have got on the list. Now, I just want
to... So these are financial advisors that you're referring to?
These are licensed financial advisors. And, Senator, it's important to make the point that every single one of those investigations is a resource-intensive full investigation where we are having to examine the nature of the advice given on an individual basis. So these are not things that ASIC can go, okay, we think you're a bad advisor, so we're taking your licence away. We have to do a full investigation. We have to get investor evidence as to what they were told. We have to review the statements of advice that were given. We then have a delegate within ASIC that makes a decision. It's obviously a very serious decision to take someone's ability to earn their income away. It's not something we can do lightly. And then the financial advisor has the opportunity to appeal to the Administrative Review Tribunal. And in many of these cases, there have been those appeals. So that's another huge part of resourcing for us in our administrative law team, is now having to fight multiple different matters in the ART as well. So I can keep going about the chain, Senator, but feel free to...
There's no disincentive there for dodgy people, though. If they think that they can continue, they can keep making the money in the meantime.
Jump in there, Senator. The other point that Deputy Chair Court's making, this is very lucrative business. And so a lot of the individuals, well, all of the individuals and businesses, they've all made a lot of money.
Yes.
And so they're well resourced.
Yes.
And so I really want to be quite plain.
11,000 people.
I really want to be quite plain about this. We're dealing with, lawyers. They're all lawyered up. There's not a lot of cooperation happening here. We can talk about some of the major players, but the people that are actually put people into these investments, the individuals, the businesses that Deputy Chair Court are referring to, they're lawyered up. They're not cooperating with us.
No.
So
that's another warning signal for everybody as well, right? There's a lot of talk about financial advisors, and they put a lot of effort into talking to all of us. And there's an assumption that they are professionals and that they will do the right thing and act in the interest of the person they're advising.
Yeah.
But there's enough there, Mr. Chair Longo, there is enough there who are looking at a very lucrative business model by ripping off their fellow Australians. They are licensed by you, and it seems to me, representing Australian people, that they have too much free rein, that they have had an opportunity to fleece at least 11 to 15,000 in the case of Shield and First Guardian, another 10,000 that you mentioned in your first remarks in response to me might be at risk. And we've got millions of Australians who might get a feed in their social media tonight, put their information in, and by tomorrow morning have lost their superannuation, right? So this is because there's a hawker who's gone on, somebody's chased them down because they gave permission by filling in the form. Then somewhere in the middle of the call, as you're saying, Ms Court, they get a financial advisor, and I use the term very loosely, a financial crook, comes on the line, takes their money from them and sets them up to lose their superannuation knowingly.
Senator, I wouldn't want to demonise all financial advisors.
But there's enough there, Mr Longo, to be concerning.
Well, there's a lot of blame to go around here. So the superannuation trustees themselves are hosting a number of managed investment schemes that are high-risk products.
And I want to come to that, but let's just stick with the financial advisors, because my goal at the end of today is, with this august group of people who are here representing Australians, is to have no doubt in the public place that if you fill in a form online and you get a phone call from somebody, you do not move your superannuation. That is my goal at the end of the day, because there needs to be self-protection in addition to what ASIC is doing retrospectively to try and hold these people to account, which you have indicated is expensive, highly resource intensive, and I appreciate that you're doing that, and I'm sure that the people who get any of their money back will appreciate that end game. But in the meantime, what's the prophylactic? What's the prevention? It's got to be education. So if I could just go back to Ms Court before I start to share the call.
Sure.
Can you finish the process of the rip-off agents? What do they do after they get your details, get around the anti-hawking, get you on the phone for a long time, transfer you at some point to a financial advisor?
Yes.
Then what happens?
Yeah. Can I just take one moment, Senator, and I note your point about financial advisors. I think, though, it is important to say, as Mr Longo has, there are obviously a lot of good financial advisors out there, and one of our messages has to be here, as you say, if you get a phone call trying to sell you to switch your super, you should hang up. Absolutely, that's our first and most important message. Good. But secondly, if you're thinking about moving your superannuation, and we have a system that does encourage people to compare returns and shop around and do well with their superannuation, I think, a really important message is to get independent financial advice, and that's where this was different. These advisors were all connected in the chain, and as Mr Longo said, we're doing very handsomely out of it. So our second message would be, when you're making serious financial decisions, get independent advice from an advisor that has no relationship or involvement with the people that are ringing you up or with the funds that you're going to. So I just wanted to make that important point. And the other thing I think I should say is that we do rely on the industry associations like the FAAA and others to refer the so-called bad apples to us. We need them out on the ground because they see, obviously, the relics or, what has happened as a result of some of these issues. So I just wanted to put that importantly on the record. Once they're moving to the next link in the chain, Senator, quickly, we have the funds themselves. We have these two particular funds that we're talking about this morning, the Shield Master Fund and the First Guardian Master Fund.
So just go back one step for people who might get this call.
Yes.
In the next couple of days. Hopefully it slows down a little.
Hopefully they won't be, Senator, but...
They are told, great, you've got, let's say $250,000. What's the average amount for most people? Have you got an average number?
I think it's in the... I'm speculating. Perhaps I can get the number. I think it would be in about the 160.
Okay, so let's go with that. Say 160,000.
Yes.
You've worked and you've saved it and you've got it to that point. Now you could be, younger. You might be older. You might be closer to retirement, or there'll be a range of different people. But they get that. I've got that 160. Now the hawker tells me it's a great thing for me to get a better deal.
Yes.
What's the next bit of advice? Do they tell me then, it'd be great if you set up a self-managed super fund? Is that the most common path, or are there other paths that they use? What do they do next? What's the next bit they say?
The most common path is to invest on a superannuation trustee platform. So some of the superannuation funds, and the Macquarie fund or the Macquarie platform is one that we've been talking about a little bit because it had the highest number of investors in the Shield Master Fund on its platform, but there are a number of other trustees involved, Equity, Diversa and Netwealth.
Okay, so for people who don't understand...
Yes.
What is a platform? Because it sounds like it could be a place, but it isn't really, is it?
No, it's a platform is a place that a trustee either hosts or enables a superannuation member to choose the fund where they want to put their money.
Okay, and the trustee is the person who's the boss of your money?
The trustee is the superannuation trustee.
Yeah.
So again, in the Shield Master Fund, there were 2 superannuation trustees involved. Equity Trustees was one, and Macquarie Superannuation was one.
And for people who don't get this, again, I'm just trying to break it down into,
I understand.
The sort of questions that would be asked if I was at school teaching a class and they were going, well, what does that mean? So a trustee has got the word trust in it, and it's basically a person who knows a lot about superannuation is saying, trust me, I am looking after your money. So they're trust me's, not just trustees. Trust me, that's the thing that you're doing. You're trusting them, and they're saying, we've got a range of different things that you can buy in our shop that we think are good for you to invest in. Is that a good comparison or correct it?
Not quite, Senator, and I appreciate that the effort that you're making to put this in plain English terms that people can understand. I have to step back a little bit and be a legal regulator in terms of what I say, so forgive me, I'm trying to make it as straightforward as I can. The superannuation trustee in these circumstances offers a range of different funds. The only way to access those funds is through financial advice. So the superannuation trustees say, we are not choosing the fund to put you in. What they will say to you and what they say to us is that the financial advisor that the superannuation member has got advice from has recommended or advised them to move their money into the Shield Master Fund or the First Guardian Master Fund that sits on one of these trustee platforms. In ASIC's view, the superannuation trustees owe those superannuation members a range of duties, and we are of the view that the trustees may have failed in those duties, and you may be aware we've taken court proceedings in the last few weeks against one of those trustees, Equity Trustees, and we are alleging that it has breached the duties that it owed as a superannuation trustee to those people that were able to invest through its platform or through the platform it made accessible. Now, that matters before the court and being defended, but we are of the view that the trustees have an obligation to protect the members' funds and to act in the members' best interests.
So the part of the responsibility that they have is if this is a shop where a financial advisor can send you to buy different things, the trustee's role is to say, all the products we're selling here are safe. They're okay. There's no major risk here.
That's right.
Is that
think of it as a supermarket.
Great. Now, if I was going to buy a cot for my grandchild today, there would be restrictions around what sort of cot I can buy, because people in that whole chain would be responsible for making sure that there's safe product available.
So the superannuation trustees, these obligations are all in the legislation, but they've never been tested. And so what Deputy Chair Court is saying in the proceedings we've already commenced, and there may very well be more proceedings coming, is that we're testing the standards of diligence that the superannuation trustee has to discharge before putting anything on their platform. And so the supermarket analogy is sort of helpful, I think, because the trustee can't be putting products there that aren't suitable for investment. But what's happened here is that a lot of investment opportunities have turned out to be very high risk property investments in the main that aren't really suitable for people for their superannuation money.
Thank you very much. Now, colleagues, it's taken half an hour. I hope you feel that that's been an investment of time in terms of public education that explains things, because Ms Court, you're in a remarkable position in terms of public communication about how this scam is operating. So
it's a very important part of the work we're trying to do, Senator.
So hopefully there'll be a bit of prevention. I have 3 very short questions. Hopefully you'll be able to help. On what date did ASIC agree the terms of with ANZ on the details of the settlement over the various historical matters?
Well, the investigation took nearly 2 years, and towards the end of that period, it became clear that ANZ were interested in making admissions, as we foreshadowed proceedings against a range of matters, and so the finalisation of those documents to support those admissions occurred at the time of filing, late last week, I think would be. I'm looking. So for those of us who've been burdened with looking at all these documents, they're very complex, heavily thought through. So the admissions that were made in the agreed statement of facts and in the agreed contraventions, we didn't file till that was done. So I think the answer is late last week. But I think it's important we were talking about public education. We're not doing deals here. That this is not a deal. What's happened here with ANZ is that a number of teams at ASIC laboured heavily over a long period of time and uncovered and dealt with a wide range of misconduct, which has been getting some publicity this week. We were ready to file proceedings in connection with all that misconduct. The ANZ chose to make admissions in all those proceedings, and in doing so also wanted to work with ASIC to come up with a joint submission around penalty. But there should be no misapprehension that had those admissions not been made, those proceedings would have been filed and served on Monday, and we'd be having a different conversation today.
Okay, so the strength of ASIC's investigation has led to the admission and then a joint submission for the amount of, what was it, 240 million?
Yeah, so there are 4 proceedings, and each proceeding a joint submission will be made to the federal court as to what the penalty should be. So when we made the announcement on Monday, we were able to tell the public what that joint submission would be as to penalty to the court. When it comes to the court, there will be a joint submission. That document
That's already agreed.
Yeah, but that document hasn't been published, but there will be a joint submission to the court based on the facts that are in the public domain, the statement of facts that were published as part of the proceedings that were commenced over the weekend, last weekend. I hope that makes sense, Senator.
So just in terms of timing, 2 years, last week, at the end of the week, do you know what day?
Last Friday, yeah.
Friday, there was an agreement with ANZ on the details of this settlement that you put.
Made admissions, yeah.
Admissions and then agreement?
Yeah. Well, I think I want to labour that a little bit because I don't want the impression left that some sort of deal was done. We made a series of very serious allegations in the material. The statement of facts, for example, which happens to be agreed, on the pre-hedge trading, the most serious part of it, the 80 million, when that goes on for 50, 60 pages.
Did you have dates set
That's
for
not a
the
deal.
court
That's
hearings?
what we say the facts are,
Yep.
and they admitted to those facts.
Were there dates set for the court hearings?
I beg your pardon?
Were there dates set for the court hearings?
No.
No. Could I also just ask, was the timing of your announcement, the agreement was reached on Friday, the announcement was made on Monday, is that correct?
Yes, well, the way it works is this particular announcement was particularly complicated because of 4 sets of proceedings that we commenced at the same time, and it took until the end of last week to get all the documentation finalised and filed. So where were you heading?
So Monday,
Sorry.
the 8th of September, was the announcement.
I remember now what I wanted to say. So for a publicly listed company like ANZ, we need to be very careful as to when we announce.
Okay.
And in the case of ANZ, they're listed in New Zealand.
Yep.
And so if the entity is only listed in Australia, our practice is to make announcements before trading begins, and that's usually around 8:30 in the morning, something like that. Varies by a few minutes one way or the other, but the whole idea is that you don't make announcements like that to the market except well before trading starts, so it gives the market time to absorb the information. In ANZ's case, we made the announcement even earlier in the day because its securities are traded in New Zealand and because of the time zone differences.
So the announcement was made what time?
7:30 a.m. on Monday
7:30 a.m.
morning.
Australia on Monday the 8th. And then later in the day, ANZ announced 3,500 jobs cuts. Is that correct?
Sorry, Senator, I was just going to correct, with respect, Mr Longo's answer. So the documents were filed in the Federal Court on the 12th of September, last Friday, and then the announcement was made on the 15th of September, which was Monday of this week.
Yeah, so the announcement is first thing Monday morning, but the proceedings, as I said earlier, were filed over the weekend.
So after the job cut announcements by ANZ?
That's unrelated to these matters.
Okay.
It's unrelated, as far as ASIC's concerned, it's unrelated to these matters.
Yes, I just wanted to get the sequencing on the record. Thank you very much. I'll go to Senator Hume, and we might proceed in lots of 15 minutes.
Thanks, Chair. That would be terrific. Thank you very much, everybody from ASIC, for being here. Can I ask about the Guardian and Shield Master Funds first? When were they first registered by ASIC? What was that date?
Just bear with me, Senator Hume, and I'll try to bring up the precise dates. My recollection is, and Mr Savandra might be able to correct me if I'm wrong, 2019 for First Guardian is my recollection.
Yeah, the Shield Master Fund was registered in 2021. I can get you a precise date, Senator.
Okay, no, that's all right. If you could do that on notice, I would appreciate it.
Yes, I'm sure we could.
That would be sorry. Thanks. When did ASIC first record any sort of internal intelligence on Shield and First Guardian compared to when action was actually taken?
Yeah, so our first, the first time ASIC heard of the reference to First Guardian, as I recall it, was in, and again I'm looking at Mr Savandra here, 2020 or 2021?
2020.
2020. And that was in relation, Senator, to concerns that were being raised about the model of selling. So we got a couple of reports about this cold calling or lead generation nature of selling First Guardian together with a range of other funds. And the other issue that we had raised with us once or twice was the issue of sort of so-called cookie-cutter financial advice. So there were a couple of times, as I say, around 2020, 2021, where First Guardian and a range of other funds were referred to, not in the context of any problem with the fund or funds themselves, but really focusing on the lead generation aspect of conduct and the nature of the financial advice that might be involved.
Senator, sorry to interrupt, Senator, but just to answer your questions, and I think it is helpful when we're discussing this to keep Shield and First Guardian quite separate, as in when did we know what about Shield and when did we know what about First Guardian. In terms of First Guardian, it was registered on the 23rd of August 2019 and Shield was the 24th of May 2021.
Right. And, well, then can we also then be very specific about when you first heard when you first had any intelligence that there was potential misconduct for both First Guardian and for Shield?
Senator, so when we talk about misconduct, I think it's helpful to talk about misconduct with respect to the selling practices. So that's cold calling, lead generation, financial advice, possibly defective offer documents in one category, and then misconduct with respect to the funds themselves. So misappropriation of money within the funds we became aware of much, much later.
I've actually got sorry, Senator, it's Deputy Chair Court, the document I was looking for earlier. My apologies for that delay. So just to be completely clear, yes, First Guardian Master Fund was registered in 2019, as Mr Savandra said. We received some reports of misconduct in 2020 about selling practices, so the lead generation that Mr Savandra was referring to. Then in relation to Shield, registered in 2021. 2022, we received reports of misconduct again about these selling practices. And then in 2023, we received the first report of misconduct in relation to the running of the fund itself that gave us concerns about the fund. We started our investigation soon after that. And in relation to First Guardian, our concerns about that fund arose as part of our investigation into Shield, because what we ascertained was that there were significant flows of money going into the Shield Master Fund, and we became aware as a result of that investigation that there were significant flows of money going into another fund called First Guardian, and that's what prompted us then to start looking very closely at the First Guardian Master Fund. That wasn't until 2024, early 24.
Right. So at what point of the timeline did you know that the funds were at risk of collapse?
Well, I suppose putting it in those terms, at risk of collapse, is at the beginning, Senator, what we're looking at is something going on here? Why are all these funds going into here? Let's have a look at the financials. So we started looking closely at Shield, as I say, in 2023. We commenced our preliminary investigation in relation to Shield in April of 2023. We issued notices to Macquarie in May 2023 to say, look, what's going on with this fund? Tell us about the financials of this fund. We're worried about it. There's so much money going into it. Macquarie then off-boarded the Shield Master Fund the next month from its platform.
There's been reports that some of the platforms declined to put Shield and First Guardian on in the first place.
Yes.
Due to concerns about them. Did that sort of, I suppose they don't necessarily, those platforms don't necessarily have to inform ASIC that they have chosen not to put a fund on their platform, but did any of them highlight to you or send ASIC a message of some sort expressing their concerns about these funds?
Senator, not that I'm aware. I've seen some of those media reports as well, and I think one of those platforms, I think I've seen a media report that platform said, well, no, we did not notify ASIC of our concerns, but certainly not that I'm aware that any platform that had refused to put on either of these funds onto their platforms notified ASIC of their concerns.
Right. And no platform that had First Guardian or Shield on their platforms notified you and said, hey, there seems to be a strange amount of money going into these.
I don't think any of... Well, sorry, I think Mr Savundra might be going to talk to me, not that I'm aware of, sitting here, but Mr Savundra?
Senator, I'll come back to... so equity trustees raise concerns with ASIC about Venture Egg and Interprac. That was more about, again, Venture Egg and Interprac are the financial planners or advisors, right, as opposed to the funds themselves. Going back to your original question, it's a different task. So concerns about misappropriation or misuse of investor funds is not the reason we criticise trustees for putting on or failing to put on, for putting on products onto their platforms. What we say is that these funds had no track record, the individuals had no track record, so they were high risk. The assets were illiquid, high risk. Looking at it through that risk lens, the assessment should have been done. I don't believe trustees were not putting Shield or First Guardian on their platform because they were aware that investor funds were being misused or misappropriated. And to my knowledge, and I'll double check to be sure, but to my knowledge, no trustee raised those concerns with us. Those were ascertained through our investigative work.
So I'm trying to work out where the red flags were and what ASIC's response was to those red flags. There was 3 months after Equity Trustees, October 2023. When was the interim stop order on Shield? But I haven't quite worked out the timeline between those.
Yes, that was the stop order on Shield was February 2024. You might be referring to, Senator, Equity Trustees made contact with ASIC in November of 2023 in relation to Venture Egg.
October of 2023.
No, this is November. October or November of 2023 in relation to Venture Egg. So Venture Egg being, as Mr Savundra said, the financial advice firm, but certainly there was no reference in that communication about the Shield Master Fund or the First Guardian Master Fund.
What about the Macquarie closed Shield to new investors, to new members in June 2023?
Yes, after ASIC served it with a notice asking for information about it.
Right. Okay. But the First Guardian formal investigation was opened in September 2024. That seems like a long time between the Macquarie closing Shield and the First Guardian investigation.
Yes, Senator, I understand the point that you are putting to us. I first need to say they're two completely separate investigations. So the Shield Master Fund was made available on the Macquarie platform and through the Equity Trustees platform. First Guardian Master Fund was made available on the Diversa platform, the net wealth platform, and also on equity trustees. So equity trustees unfortunately elected to host both the Shield Master Fund and the First Guardian Master Fund. As I think I outlined in my evidence to Senator O'Neill earlier, ASIC started investigating the Shield Master Fund in April of 2023. In the course of that investigation, we became concerned about recognising the complexity of the investigation, we were looking in part at financial advisors. We became aware in the course of that investigation that in addition to advisors referring large numbers of superannuation members to invest in the Shield Master Fund, they were also advising large numbers of superannuation members to invest in something called the First Guardian Master Fund. We became concerned about that. We had concerns about conduct in the Shield Master Fund. We became concerned about what might be behind the First Guardian Master Fund. We commenced a preliminary investigation into the First Guardian Master Fund in February of 2024. And again, the date that you're referring to, which is later in 2024, I think is explained by a sense, and it's been reported in the press as well, that when ASIC commences, and I apologise if this sounds overly technical, but when we commence a Section 13 investigation, that's what we refer to as a formal investigation, which enables the use of various powers. We do a lot of we do a lot of work before we open a formal Section 13 investigation, and we only open one of those investigations if we are of the view that there are likely or suspected contraventions of the law. So in relation to First Guardian, as I say, the Shield work tipped us off to potential concerns. We started looking at it in February of 2024, and we formally started our investigation later in that year, but we had already used compulsory powers and got a whole lot of information in relation to First Guardian at that time.
Senator Hume, there's a time for one more question. You've got about a minute to go. And just for those who might be watching and following on, in addition, as part of their submission to the committee, there is in Appendix 1 a clear outline of these key dates, which I'm sure that Senator Hume is further investigating. But for people who have interest in this matter, it is documented in the appendix, which will help those who have interest to locate the information. Senator Hume, one more question.
Thank you. I actually want to ask about the ratings houses because I read somewhere in the press that one of the ratings houses had only just removed their 5-star or 5 crowns or whatever it was rating from a First Guardian investment option in July this year. So that was 5 months after the federal court froze its assets. Now, does ASIC have jurisdiction over ratings houses?
I can confirm, Senator, that we are certainly investigating at least one of the ratings houses that we are concerned had the Shield Master Fund rated as of investment grade or words to that effect. And indeed, one of the challenges with these matters is that, in a sense, everybody is pointing fingers at everyone else. So, for example, the financial advisors are saying to us, well, look, you can't hold us accountable for this ASIC because, look, the ratings house had rated these funds, or at least the Shield Master Fund, as of investment grade. Superannuation trustees are telling us the same thing. They're saying, well, we relied on the ratings houses, or we relied on the fact that these superannuation members had financial advice. So one of the challenges here is trying to pull all of this apart and work out, well, where does liability lie? Our own view is that there are significant failures and likely contraventions of the law, certainly ones that we are proposing to take forward in every link of this long chain that I took the committee through earlier.
Thank you. Thank you, Chair.
Thank you, Senator Hume. We'll return as everyone else gets a turn. Can I now give the call to Senator Pocock?
Thank you. Thanks so much for being here. I would like to go in my first 15 minutes to ANZ and I'd like to begin with the definition of what they did wrong. And if I look to your media release, the language, and I know it's common in the financial world, to talk about failure to manage non-financial risk across the bank. That strikes me as an extremely coy phrase for what ordinary Australians might understand to be really serious misdemeanours. Can you turn that phrase into language which conveys to the Australian public exactly what those misdemeanours are in plain English?
Just stepping back, most businesses and certainly most banks are good at bookkeeping. We'll call that financial risk.
So, Commissioner Longo.
Financial risk, running their P&L, so profit and liability. So that's the financial risk. So what this case is all about is non-financial risk, which is everything else. So put financial risk to one side. That's the accounts of the bank and its bookkeeping and whether it's making a profit. All of that is not what this case is about. When we talk about non-financial risk, we talk about everything else. Talk about cyber resilience, operational risk, reputational risk, how they use their data, systems, processes, customer service, everything else. And so the modern challenge for the big banks is getting a grip on non-financial risk. And that's where ASIC's particularly interested because we're a conduct regulator. And so bringing that back to this matter, what's a little bit unusual about this matter is the breadth and depth of the misconduct that we've litigated in one series of proceedings, 4 sets of proceedings. So probably the most serious part of the proceedings is the way ANZ went about providing a service to the Commonwealth to manage interest rates. So I was asked about this earlier in the week, and so a lot of people have mortgages, they borrow money in one form or another, and everyone knows when you borrow money you've got to pay interest. And so the job of ANZ was to, and there's a technical name for it, duration manager. And the idea was that the Commonwealth decided it wanted to borrow $14 billion. That's a lot of money. And you can imagine that over a period of time, that amount of money will generate a lot of interest rate burden, just to keep it broad. And so the job of ANZ was, at the time these instruments are sold to investors, the interest rate has to be hedged and fixed so that when investors buy these bonds, they know what interest they're going to get and what interest the Commonwealth has to pay over I think they were 10-year bonds, weren't they? Yeah. Price for 10 years. And so that's what we're talking about. So when you buy a house, for example... That's one
of the misdemeanours we're talking about.
But that's a big deal. That's a $14 billion transaction. As duration manager, we say and they've admitted they failed to discharge their obligations. Now, related to that was that over almost a 2-year period, ANZ misled AOFM about its trading activity in the market. And that's sort of pretty important here because being a duration manager for one of these big bond deals for the Commonwealth is a prestigious mandate.
And very profitable.
Yes. Well, it can be. And
in
one
this case it was.
We can come back to that, Senator. But one of the reasons ANZ won this mandate was because AOFM had an understanding of their presence and activity in the market, and it gave the Commonwealth confidence that they were the right bank to choose to be duration manager. But as things turned out, our investigation showed that the data they were giving AOFM about their bond trading activity in the market was incorrect by quite materially. So that's what that is all about. And then the other matters...
Sorry, Chair Longo, if we go on. What does that mean? Like in normal, does that mean they lied?
I'm trying to get there.
Yeah, thank you.
Well, it's misleading and deceptive. Yeah, it's misleading conduct.
It's lying. It's lying to the government of the country in a way which benefits the corporation and costs the Australian public. I'm using this language because I feel angry about what happened.
Among lawyers, lying means intentional.
But I want Australians to understand that the word risk here is used in a way that creates a cover story for demeanours which most Australians would think were utterly unacceptable and would never commit themselves. They would never lie to the Australian government for 2 years about their activity in order to create commercial advantage. They would never create a bond sale structure in a way that increased the cost to the public sector and increased the profit to the bank. Is that what we're talking about here? Crudely, in my language. Am I wrong in what I've said?
One word I would not use, and was not admitted by ANZ, was that it was intentional conduct.
I want to come to intentionality. Yeah. Let's come to that later.
But there's no,
I think that's
when you step back and you look at the facts, I mean, I've used the word grubby several times this week. In terms of the trading before the bonds were priced, there's a whole lot of ways ANZ let the Commonwealth down. We can come back to that. In terms of the reporting over that 2-year period, for whatever reason, they misled the Commonwealth.
Isn't the reason...
They didn't complete the template properly, but through a failure, I think a combination of incompetence, poor systems and processes. It's all there in the statement of facts, but they did not admit to doing it intentionally. Consequently, they did not admit to lying.
Well,
so I have to make that clear.
Of course they didn't admit it, Mr Longo. Of course they didn't admit it. But did they not make an enormous amount of money out of acts that they committed? And we can see the individuals that committed those acts. They were all beneficial in their consequence for ANZ. None of them were negative in their financial impact. And that suggests intentionality. I'm not saying it wasn't denied. ANZ have denied it clearly.
Yeah.
You have accepted that. I think it's unacceptable. I think many Australians would find the notion that ANZ made a lot of money out of all 4 sets of misdemeanors and to let them off. And it's very important because, of course, it goes to the level of agreed payment. I don't know what the terminology is. You don't use it, but the $240 million payment. The size of the punishment.
Yeah, I hope, Senator, my job's to be objective about what's been admitted to and what hasn't been admitted to. Certainly the conduct that's been admitted to is extremely serious. I'm not going to...
grubby, as you said.
Yeah, and it's going to cost ANZ. We're going to submit to the court that their behaviour as a duration manager is an $80 million pecuniary penalty. Now, the... ANZ have been very firm. We disagree with them, but they've been very firm that they didn't cause any loss to the Commonwealth. But in the agreed statement of facts, ASIC's position is very clear. We think the loss is in the order of $26 million. But for the purposes of the proceedings, that wasn't the subject of a definitive calculated amount. So we can have a discussion about that. But clearly their misconduct in misleading AOFM about its degree of activity in the market and its activity in the hedging the futures in order to deal with the interest rate exposure, it was clearly very serious. It was grubby. It was unacceptable.
So to be clear,
and extremely profitable, if I can go on. If I look at ANZ's profit...
Well, they were acting in their own interest, sure. They were expecting to make a profit.
And particular individuals manipulated, for example, the way in which the bond sale proceeded to the very considerable advantage, the bottom line. And in your calculation of a $26 million loss to government, do you want to say a little more about how you arrived at that?
That's per basis point.
And if you can, talk about the $80 million that you mentioned as well in relation to that 26, just so it's clearly on the record, Mr Longo.
There's something else to say. I'm sorry to be so... but these matters were very serious. In these proceedings that we commenced last Friday night and announced Thursday, Monday morning, there was no allegation of market manipulation. I just want to make that very clear. After the very exhaustive investigation, ASIC came to the view that there was unconscionable conduct, and we can go into the details of what that means. Market manipulation is a term of art. It's a different part of the Corporations Act. We can talk about that if we like, but we're not alleging market manipulation in this matter. As far as loss to the Commonwealth is concerned, when you go to the agreed statement of facts, these matters are very technical. I find them technical anyway. And so the way we came up with the 26 million, when you go to the agreed statement of facts, each basis point that affected the price of the futures was about 13 million. And so we calculate there are a couple of basis points that went the wrong way for the Commonwealth. Had they gone the right way, the Commonwealth would have been paying $26 million less in terms of the cost of issuing these bonds. That's putting it if I may say so as simply as I can, but there's a difference of view about this. ANZ have not conceded, they have not admitted that they've caused the Commonwealth any loss. They've made it clear publicly they're prepared to hand back the revenue they earned on trading the futures. Just one more point about that. They were entitled to do that. They were entitled to trade as principal. As duration manager, they're allowed to make a profit. Everyone knew ANZ was in the market to provide that service. They were allowed to make a profit. What went wrong here is that they mishandled the inherent conflicts of interest that mandate required, and they mishandled that in a number of ways that we can talk about.
And why do you say that mishandling, which proved to be very profitable to the bank and very expensive to the public, Australian public, why do you say that was unintentional? I would think if something was unintentional, it might occasionally cause a cost to the bad actor or the actor who's making the misdemeanors. Why do you use the language of not intentional?
Well, as a matter of law, intentional behaviour has its own meaning. Here, what we say is that ANZ failed to follow its own policies and procedures. It failed to keep AOFM informed of what was going on in the market as it was trading. It didn't treat ANZ fairly as it was required to do. It departed from industry best practice, as a practice that ANZ said it would follow. As a matter of law, these proceedings did not allege that all this behaviour was intentional, but that's certainly what they've accepted that they did.
So, leaving aside the technical definitions of intentionality, the Australian public would be quite within its a fair definition of moral behaviour to conclude that it had not followed its own procedures, that it has acted deceitfully to the public sector,
that's right,
and that it has profited from its misbehaviour.
Well, that's what unconscionable conduct is. It's offensive against commercial conscience. Yeah. So it's a concept that is a very important part of our jurisprudence.
Before we move off this, can I just ask you to address the 80 million? And Senator, you've got another 3 minutes.
Great.
Thanks. So the 80 million, you mentioned that in relation to the 26. Are those two things interlinked?
Well, ANZ might say that they didn't cause a loss to the Commonwealth, but they've agreed to pay an $80 million pecuniary penalty. So I think that says it all.
Yeah, it says it all, as you said. I want to go to ANZ's form. I want to go back to the Haynes Royal Commission and the record of ANZ behaviour over time, because most Australians are living their lives out there, managing their bank account and trying to do the right thing and pay the mortgage, and they don't remember everything that happened in Haynes Royal Commission. But ANZ has, as your statements show, got quite some form, and these misdemeanors have occurred over some years. So I want to go to social licence and the history of behaviour. If I go to a Royal Commission documentation from 2018, 13th of March, the record speaks about ANZ's submissions and its misconduct, conduct falling short of community standards in relation to home loans, credit cards, processing errors, car finance, and over 5 years, up to 2018, at least 20 events of misconduct, conduct failing below community standards, including, at paragraph 25 of this document, customers being charged incorrect fees or interest amounts, customers accessing inflated redraw balances, and failures to send hardship notices to applicable customers within the 21-day. So these are about hardship, about misleading in relation to interest rates. This is years ago, 6 years ago, 7 years ago, and here we are back again with very similar misdemeanors. We've got form here. What's your commentary about that? Repetitive form.
Well, we made it clear that the time and time again, it's your point, Senator, but and in the material we published on Monday, there are 6 or 7 other matters where we've taken action against ANZ before the proceedings.
11 civil penalties since 2016, yeah?
And so the part of the seriousness and part of the reason the penalties on Monday are so large is a reflection of that history that you've quite properly summarised. Sarah, do you want to add to that?
No, just to say, Senator, that we completely agree with you. We're now more than 5 years post the Royal Commission. The kind of issues that we dealt with, in addition to the bond trading matter and the misreporting that Mr Longo's been talking about, are what we consider to be really basic banking fundamentals. You know, getting the interest rate right. You promised customers you'd pay them, dealing with financial hardship notices on time, within the time that's required by law, not charging deceased estates when a customer of yours has died. You know, these are things that we've seen, unfortunately, with far too much frequency. And as Mr Longo said, one of the reasons, you've talked about the $80 million penalty in relation to the unconscionable conduct, in relation to these, what we've called sort of broadly retail matters or customer-facing matters. The penalties of those 3 sets of proceedings combined, if the court chooses to or determines to order them, are in the order of $115 million. Now, that is a very significant, but that is a real ratcheting up of penalties for these kind of matters if the court agrees to make them. And our reasoning for that, Senator, is because we have been here time and time again. We've had ANZ paid penalties of $5 million in 2018, $10 million in 2020, $25 million in 2022, $15 million in 2023, $10 million in 2023 also. And we looked at all of that and we said, well, what will it take to send a clear deterrent message, both to ANZ itself but also to the sector more broadly, that you cannot continue treating customers in this way, having these impacts on individuals. So the size of the penalties, if the court decides to make them, is for that very reason that you have just outlined. We need to get boards and senior executives sitting up and recognising the serious impact of the conduct, and in our view, high penalties are the most appropriate way to do that.
So if we look, can I just make one final comment? Yes. If you look at the profit of ANZ to the 6 months of March this year, it's $3.6 billion, I think, from memory. These are trivial amounts relative to their profit and certainly relative to their revenue. Aren't they making a judgment? This is just the cost of doing business and taking us all for a ride. And what confidence do you have that we won't be back here next year or in 5 years with exactly the same misdemeanours because they are trivial relative to their profit?
I think I'd say in response to that, Senator, these are the most significant penalty figures that have been imposed. If the court, again, I have to keep caving that, if the court imposes these penalties, these are by far the highest penalty figures to be imposed on a financial institution in an ASIC-related suite of matters. In our view, and indeed in relation to the unconscionable conduct, again, if the court imposes $80 million, that is that's a record penalty. That would be a record penalty for an ASIC-related unconscionable conduct matter. I think, you know, in addition to the penalties, the reputational impact on ANZ from these suite of matters, from having the highest unconscionable conduct penalty imposed, if that's where the court ends up, you know, that's why we're taking these matters. And look, if ANZ comes back and we're seeing the same set of issues or similar issues in the future, then we will be back in there, Senator, holding ANZ to account until we get to penalties of the size that really force a change in culture, a change in compliance. That's our job. We feel that we've been holding ANZ to account time and time and time again, and that the matters we instituted this week really ratcheted things up to a whole new level, and that was our intent to do so.
Time will tell.
Time will tell.
I'll thank you very much, Senator Pocock. I'll give the call now to Senator Sharma for 15 minutes, and then I'll go to Ms Lawrence. Senator Sharma.
Thanks so much, Chair, and thanks to all the ASIC guests that are there today. I just wanted to go back, if I could, to the First Guardian and Shield matters and just understand the timeline a little bit better. I know Senator Hume pursued this as well. I've got the annex, I think, which you attached to the ASIC submission here in front of me. But I just wanted to understand, I think you were saying earlier that there's sort of two strands of concern. The first was the selling practices, but then the second was the actual management of the funds themselves. But would you mind just elaborating on that a little bit?
Yes, I can, Senator Sharma. So we have been concerned about or aware at ASIC for quite some time about the risks of cold calling, if you like, in relation to the selling or persuading to switch superannuation funds. We've done a range of surveillances, thematic surveillances over many years, but certainly from 2020, 2021. And we have had it brought to our attention by, financial advisors and others that there are people, I don't know how best to describe them, that, people out there that are making these kind of calls, trying to persuade people to move their monies. And we've also, frequently over the years, not in relation to these funds, but I'm talking at a more broad level, had concerns raised with us about things like, cookie cutter financial advice. And so that's long been part of ASIC's concern, jurisdiction, part of the bread and butter of our work. So when we were, Mr Savandra and I were differentiating between selling practices, if you like, and the conduct that sits or problems with the fund itself, that's the differential that we were alluding to. That we are, there are, as I say, there's the anti-hawking provisions which we police. There is, some of these lead generators or people on the phone might be giving unlicensed financial advice, for example, so we might look at it through that kind of context. Separately to that, and the other kind of conduct is where we have, concerns about conduct associated with the running of a fund itself, whether it be conflicts of interest or potential misappropriation of funds, those kind of things. So we separate the two.
Okay. And it was the selling practices, as I understand it, that first drew ASIC's attention to First Guardian Master Fund and Shield Master Fund, according to your timeline. That's why when they first came onto your radar, it was because of the selling practices associated with them?
In relation to, and again, it's hard because they were two very different sets of investigation. Sure. So I'm sorry to
let's do one.
Keep
one
being
Yeah.
pedantic about that. So again, as I said to Senator Hume, we received some reports of misconduct about selling practices. So the front end, if I could use that description, about a number of funds, including First Guardian, was one of many, or one of several referred to in 2020. And we took a range of action about lead generation and cold calling misconduct at around that time, Senator, and afterwards in relation to a range of other entities. In 2022, we received for the first time reports of misconduct about the selling practices of the Shield Master Fund, which was registered later, and again, that's the front end, the front end side of that. It was in 2023 that we first received reports of misconduct about the fund itself, sorry, the Shield Master Fund itself. So that was in early 2023, and that's when we commenced looking closely at the Shield Master Fund. So that preliminary investigation started, as I said to Senator Hume, in April of 2023. It was in the course of that investigation into the Shield Master Fund, looking at the advisors involved, where the funds were being advised to go, where investors were being advised to move their funds to, that we became concerned in the course of that investigation. So not immediately, as Mr Longo outlined, these are complicated, complex investigations. We use a range of statutory and compulsory powers in relation to them. In the course of investigating Shield, we became concerned about significant amounts of money being directed towards the First Guardian Master Fund. That was a red flag for us because we had concerns about what was going on at Shield, and we thought, oh, okay, look, could there be something else going on with First Guardian? We started looking closely at the First Guardian Fund itself in February of 2024.
Okay. And just in terms of Shield, so you commenced that preliminary investigation into the Shield Master Fund in April 2023, you mentioned. I understand, according to your timeline, you issued a notice to Macquarie in relation to the Shield Master Fund in May 2023. I think I've got this right, though, that the assets of Shield were only frozen in June 2024. Is that right? Just along your chronology. So I'm just, does it take that long to get an order to freeze the assets? Were investors, was the money of investors, did that enjoy any level of protection between April 2023 when you commenced the investigation and the freezing of assets in June 2024?
Yes, well, the first thing that happened, so the Shield Master Fund sat on the Macquarie platform and on the equity trustees, was made available through the equity trustees platform. Macquarie then off-boarded Shield in June of 2023, so the next month. So Macquarie stopped taking in. So Macquarie still had those investors who had invested in the fund up until that date remained on its platform, but it took no new investors could go onto its platform from that time. And we issued a stop order, I think, as you say, it was in February 2024, once we'd got to the bottom of what was going on in the Shield Master Fund. So, and one of the things I think, Senator, is important to understand is while we get reports of misconduct or investors raising things with us, we have to investigate the issues, and these are complex tracing exercises. So we stand up teams of investigators, we have external lawyers on board, we have forensic accountants on board, and the nature of these funds are they have a number of different levels. So you might have a registered managed investment scheme sitting at the top of it, but those funds, you can imagine, go everywhere. They go offshore, they stay onshore, they're in high-risk property schemes. We're frequently told that the property investment schemes are going to be profitable if ASIC will just get out of the way and let people run the fund in the way that they want to. So we're constantly having to make judgment calls about, when do we intervene, when do we seek to have liquidators appointed, when do we seek to have funds wound up. And sometimes, or often, it's in the face of concern or resistance from the very investors that we're trying to protect, because they are concerned that our intervention is in effect going to have an impact on their investment. So these are difficult judgment calls that we're making on a daily basis.
No, I understand that. I appreciate the explanation. Just when you mentioned earlier that you issued stop orders on the Shield Master Fund on product disclosure statements, I think that's February 2024 in your timeline there. Does that just mean that they can't take on any new customers, but it doesn't stop the activities of the fund from continuing to operate and them being able to deal with their assets? It's a little like the Macquarie offboarding that basically shuts the channel to new customers.
That's right.
Okay, but it's only when you actually get the order to freeze the assets in June 2024 that the fund can no longer deal with investor assets. Is that? I'm just trying to understand, just I guess from what date are investors knowing that their assets are no longer under the management of the fund, and that's June 2024, I think.
That's right. So as soon as we felt we had sufficient information to form a view that there were serious problems or likely deficiencies in terms of the funds that were being held, the investor funds that were being held, that's when we obtained orders from the Federal Court in June of 2024 to freeze the assets of the Shield Master Fund, and also to get a travel restraint against the key director that we were concerned about might be involved. In relation to the Shield Master Fund, ASIC's action to freeze those assets will hopefully mean that there is some return to investors there.
Yeah.
There were hundreds of millions of dollars that we were able to freeze at that time. Now, the liquidator is currently going through the process of working out, what assets there are and what there might be to be returned to investors. And everything that ASIC's been doing in these matters, front and centre or first and foremost, has been what assets can we freeze, what actions can we take to make sure there's as big a pool as possible to return to investors. I think, as we spoke last time, the second very important part of our work is holding a whole range of individuals that we consider are responsible for where we've ended up here to account. So that work is all continuing, but our primary focus has just been to make sure we keep as many assets as we can frozen and that we restrict the movement of those people that we consider have been involved in what's gone on here.
Yeah, I understand. Thank you. You mentioned then a figure, and if you want to come back on notice on this, but hundreds of millions of dollars that were frozen, that were in Shield Master Fund at the time the assets were frozen. Is that right? Hundreds of millions?
Yes, I think, again, Mr Savander will correct me if I'm wrong, I think it's in the order of 200 million that's a very broad figure, Senator Sharma, but it's in the order of around 200 million. But the liquidators are continuing to do their work, obviously, and we are continuing to take action to try to freeze the assets of any other, both companies and individuals that we think may have been involved in this misconduct. So some of the matters that Mr Longo talked about, the 45 different court actions or activities ASIC has had underway, a number of those actions have been seeking to preserve or freeze assets to make them available ultimately to the investors.
Okay. And is there a similar figure for First Guardian? Because the assets for First Guardian were frozen February 2025, is that right, or early this year?
Unfortunately, the circumstances of First Guardian are less positive than that. So, again, the liquidator is continuing to do its work and trying to call in any assets that it can. But certainly the preliminary views of the liquidator, I think there was a report of the liquidator issued in early July that showed there was very little assets left in First Guardian. Okay.
And just finally, because I'm conscious I've probably used most of my time, Chair, when you just, as someone who's not particularly familiar with your work, when you receive, what does a report of misconduct look like? So you mentioned a few times you have a report of misconduct. Is that a trader, a broker, someone in the industry, a consumer, an investor? Like, how do these reports of misconduct come into ASIC, and what are the normal channels through which you receive them?
It's a very good question, Senator, and we use the word report of misconduct in quite a broad way to almost refer to anything that comes into ASIC through any channel. We call it a report of misconduct, so that can come absolutely from members of the public, and we get somewhere in the order of 11, 12, 13,000 reports of misconduct a year that come into our general area that receives the reports of misconduct. They can also be, for example, emails that are sent to myself or Mr Longo or commissioners or other ASIC staff. They can be media referrals that come in and say, look, ASIC, you should have a look at this. I've seen this happening over there. They can be from industry associations, and certainly in these matters we had some early communication from one of the industry associations, as we talked about earlier, about some of these selling practices that they were seeing going on. So, Senator, all of those reports come into a central area within ASIC. They are all looked at manually still at the moment. Like a human eye looks at looks at all of these matters. They get triaged and dealt with. So when we say, so when we're looking at an issue like this, and we understand, people are saying, well, look, has ASIC missed any red flags here? Was there anything that we could or should have done earlier? So we've taken a very close look at all of the reports of misconduct that may have referred to either First Guardian or Shield, and that's why I'm able to explain to you what the results of that work have shown. So it's a broad term, and things come to our attention in a range of different ways.
Okay. Thank you so much, and thank you, Chair. I'm probably used my time now.
Yeah, perfectly timed, Senator Sharma. We were actually to take a break at 10:30, so we will take that break now and resume at 10:50 with Ms Jarrett. Thanks.
Thank you.
Committee will resume, and I give the call to Ms Jarrett.
Thank you, Senator. Hello, everybody. Can I just first thank you for everything that you do? Obviously, the remit of ASIC is extremely broad, covering a lot of areas, and the important role you play in helping protect mums, dads, everyday people in terms of their investments and their, the protection of their money. So thank you. But I do want to focus on, again, along the theme of people being ripped off, unfortunately, and my line of questioning goes to scams. And I note that, and this was before my time, as you all know, I'm a newbie, but I understand that you did some reviews into the banks in relation to the prevention, detection and responding to scams, and the last one being in 2024. And I read with some interest some of the points that came out of those reports, and I actually will use the words from the report, or as close to as I can, because a number of people in the Brisbane electorate, and I'm sure around Australia, people in Brisbane have come to me in relation to scams and talking about how particularly older people are targeted. And the findings of your previous reports have found bank customers are overwhelmingly the bearer of scam losses. Compensation rates varied but were as low as 2 to 5%. The overall approach to scam strategy and governance was highly variable and overall less mature than expected. Scam victims were not always supported by their banks, and I hear that a lot when people come and complain to me. And there were gaps and inconsistencies in the abilities of the banks to detect and stop scams. So with that, a couple of questions really. Do we really know what the financial value is, the dollar value is of the losses to consumers through scams, even if it's just through those, I believe it was the 4 big banks that you reviewed? And if you redid that review this year, and I don't know whether you are, maybe you are, would we see the same outcomes? So I'll start there and we'll go from there.
Yeah, thank you, Ms Jarrett. I can take that question for you. So, yes, you're quite right. Firstly, we do a lot of work. There's a whole range of areas that we work in relation to scams. And I should also say that we're one of several regulators that does so. So the government did establish the National Anti-Scam Centre that sits within the ACCC. So the ACCC has a lead role in relation to scams, and ASIC and the ACMA, the Australian Communications and Media Authority, are regulators that are also very involved. In relation to the piece of work that you were referring to, in April 2023, we did release a report where we had done what we described at the time as a deep dive into the practices of the 4 major banks in relation to scams, and at a very high level, and you've drawn our attention to some of those findings, but we found that the overall approach was variable, and this is back in April 2023, so a couple of years ago now, and overall it was less mature than we expected. We did revisit those findings the following year in August 2024. There's another report where we did a similar deep dive into the anti-scam practices of 15 other institutions, but we also went back and had a look at what the 4 major banks had done in response to our report, and we did find that there had been some quite significant uplift, I think it's fair to say, and I also think it's fair to say that the banks, particularly the 4 major banks, in the last year or two since ASIC released that report, there have been some notable changes in scams, prevention, detection, disruption and the like. I'm not saying there's not work to be done. I think there always is work to be done, and unfortunately the amounts of money lost to scams, continue to be eye-watering. So the ACCC releases a targeting scams report every year that does, and that is, if you like, the source of truth for scams losses that are reported through to ScamWatch in Australia. So in 2020, I'm just looking at the numbers that I've got here. So in 2025, the report was $2 billion that were lost. There had been, though, a decrease in to losses reported from the previous year. So there is a little bit of good news in the sense that reported scam losses are decreasing, and that's at the same time as the numbers of scams being reported are increasing. So what we are hoping, without wanting to be complacent at all, but what we are hoping is that the combined efforts of a range of entities and industry together, government entities, regulators, the NASC and industry practices, are making people more willing to report scams, but they're less likely to become victim to them. And if you'd like me to, I can also give you some of the other work that we're doing within ASIC in relation to scams.
Sure. Okay. Actually, yeah, please do.
Would you like me to
maybe elaborate a little bit, because we do know that we've got the SPF that's coming in, and obviously ASIC will be getting ready for that in some way. Yeah, that'd be great.
Yes. We very much welcome the scams prevention framework that commenced earlier this year, and we're working closely with Treasury in relation to try to work out what the policy settings should be and how to, if you like, take the next steps in relation to the scams prevention framework, and Treasury would be able to talk more about process with that. One of the things that we have taken on ourselves to do, recognising that traditional enforcement methods for scams are not particularly effective, is to work out how do we disrupt scams, how do we put frictions in the process to try to protect people. So two of the significant initiatives that we've been working on over the last couple of years, firstly is that we have established what we call a takedown service. Mm-hmm. So when Australians come across a potential scam, so a potential false website or a phishing website, for example, particularly an investment scam website, because I perhaps should have been clearer earlier. So our jurisdiction is really about investment scams, as opposed, there's such a plethora of different kind of scams, but at ASIC we're really focused on investment scams. And investment scams are important because that's where people lose the most money on average. So it's a really important part of the overall framework. So we have a takedown service where if someone refers to us and says, look, have a look at this, we think this is a scam, we've got a very fast internal capacity now to have a look at that website. We form a view as to whether or not it's problematic. If we think it is problematic, we refer it to a third-party provider who are a global cyber firm, and they can take it down for us.
Is that the Netcraft?
That's right. That's the Netcraft function.
Yep.
On average, we're taking down 130 or so sites every week, and the other part of that service is that they also keep a watching eye on the site that we've taken down to make sure that it doesn't sort of re-establish itself immediately or pop up somewhere else immediately in another guise. The second one, so we've got the takedown service, we've taken down thousands of these sites. The other thing that we have reinvigorated in the last 12 months or so is our investor alert list. So we now have, through the MoneySmart website that ASIC runs, we have an investor alert list. So if we become aware of an individual or a particular firm or someone who claims to have a financial services licence that we think doesn't, we again have a series of checks and balances, and then we put the name of the potential site or investment opportunity up on our investor alert list, and we're putting more and more companies onto that list, and that's another way that consumers and investors can use to protect themselves. So we try to say, if you're thinking about making an investment, have a look at this list first. It's not going to have every single bad investment opportunity of it, and obviously we're playing a bit of a whack-a-mole game here, but at least it gives people some additional, an additional source of information. And finally, I should say, just swinging back to enforcement, we also did take, and if you think about what role should banks take, we also took court proceedings against HSBC a year or so ago, and that was because we are concerned that HSBC were on notice that a number of their customers were being subjected to scams that related to impersonation of HSBC, and that they didn't respond to that appropriately and didn't take appropriate steps to protect their customers or consumers from that. Now, that is being defended and is still in the court, but that's another lens, if you like, through which you can look at our scams work.
Yeah, okay, thank you. And on the rates of reimbursement, like,
yes,
they are very low, aren't they? I mean, how does that compare to elsewhere? Like 2 to 5% seems extremely low, right? And what do we like? How do we fix that? How do we change that? Or what's the cause of it?
Yes, well, those were the figures, as I say, some 2.5 years ago now that we reported in April 2023. And the issue about rates of reimbursement and liability has been a vexed policy question, and one of the things that the Scams Prevention Framework has been grappling with. So I think the answer, Ms. Jarrett, to the question is that these issues will be dealt with, and I know the consumer groups are very concerned about issues about liability, remediation, compensation for scams, but it is one of the issues that will be resolved, I'm hoping, in due course through the Scams Prevention Framework being implemented, because we need the next step in that framework is for there to be codes developed for each of the covered sectors. So they are anticipated to be banking, telecommunications and digital platforms. And the banks, not that I normally talk on behalf of the banks, but one of the things the banks will say is that they're very concerned about the role of digital platforms in facilitating scams, and a large number of scams, including investment scams, are first made available to consumers through digital platforms and those social media feeds. So one of the things the Scams Prevention Framework is trying to deal with is, how do you form liability or attribute liability as between a digital platform and or a bank and or a telecommunication company. So there's a lot of deep thinking going on about that, but as I say, Treasury is probably more appropriately placed to talk about those policy issues. Yeah, but I guess you as the regulators of the banks clearly have skin in the game here. Yes, we do. That's for sure. Are there practices overseas that we can draw on and we can look to in this space? Because I'm assuming, given the number of players that are going to have to come together to help protect consumers and protect the residents of Brisbane, if I can be a little selfish here, there has to be a lot of...
Good enough that you won State of Origin. You want to...
Yeah, so there obviously has to be a lot of cooperation. Maybe you could elaborate on that too, and how that's moving forward and where you see your role there. Yeah, well, certainly. So, I mean, one thing I am, reasonably proud to say is I think Australia is actually leading to some extent in relation to scams, certainly in relation to the Scams Prevention Framework. There is a legislative position in the UK that is often pointed to, and one of the, again, I'm slightly uncomfortable, Ms. Jarrett, only because I'm talking about policy and I'm not supposed to because I'm but a regulator, but one of the issues that's being grappled with is this whole issue of liability remediation, the position that's taken in the UK, should that be brought in here. The decision of the government was that we would not be adopting the same framework as in the UK. And I think what we're really focusing on is trying to disrupt these losses and put in the frictions in the first place. With the Scams Prevention Framework, though, as I understand it, there will be particular obligations, quite granular obligations set out in each of the codes, so those 3 codes that I talked about. So there will be as I understand it, there will be a banking code that will set out a series of quite specific obligations, and that if a financial institution complies with those obligations, then it won't have a liability for losses. But if the bank or the financial institution has failed in any way to comply with these quite specific granular obligations that are designed, of course, to prevent the losses in the first place, that if the bank has not complied, then there will be some compensation or liability. But I suppose the other thing I should say is certainly you're quite right, these are global issues. Obviously, a large number of scams come into Australia from overseas. I know that there is a lot of work being done by IOSCO that Mr Longo is involved with, bringing together all of the different learnings and understandings
practices that can help prevent consumers across the globe in scams. And you're quite right, there's a lot of work being done between jurisdictions on the issues.
Okay, thank you. Yes, I guess it's my time.
Thank you very much. It is. And I'll give the call now to Mr Moncrieff.
Thank you, Chair. I'll just echo Ms Jarrett's comments, and thank you, first of all, for coming in, and secondly, for the work that you do. I've got a financial regulation background, so very grateful for all the professionalism shown by our financial regulators. I just wanted to briefly raise, so ASIC's taken on some enforcement actions relating to businesses on the Centre Pay business register, and these were businesses that were targeting First Nations consumers. I just wanted to get a bit more information around that process, around, similar to what we were saying with some of the other entities, around when those red flags were coming up and what ASIC's approach was in terms of finding those issues there.
Thank you, Mr Moncrieff. If you just bear with me, I'll just try to find some of those. Unfortunately, our Commissioner that deals with these issues is not here today.
Okay.
So
No
Commissioner O'Rourke and I will just try to find some of those. But you're quite right. We've taken a range of matters that relate to First Nations consumers, and indeed we have as one of our enduring enforcement priorities is conduct that has the potential to impact particularly on First Nations communities and First Nations consumers. Have you got any?
Thank you, Mr Moncrieff. So I think I might start by just acknowledging, I think the wider question you pose is how we find out about issues and how we are aware, and I wanted to draw to your attention our consumer consultative panel that ASIC hosts, which, as well as having more formal meetings very regularly with consumer organisations, we have a lot of informal and great communications and relationships with people to hear about problems that as they're emerging, and an opportunity to hear some of the impact of those as well. So we do want to pay credit to our consumer organisation colleagues who are very active in relation to issues, whether they be impacting First Nations or other vulnerable consumers, and helping ASIC and other regulators understand that impact properly, and particularly as early as possible, to see if there are things that we can do. So in relation to the particular investigations, I think the one that might be of most interest is Coral Coast Distribution Proprietary Limited, and that was an entity that was trading as Urban Rampage. And that was one of the entities that was on the Services Australia Centre Pay Business Register. So by virtue of being on that register, that permitted customers to use their Centre Pay payments being deducted directly when making purchases in stores like that. Obviously a very significant advantage for stores who have that capacity, because they have access to those consumers' funds immediately. And so we detected, including through information provided to us, as I described before, some real problems that were occurring in the practices, the pricing and some of the activities of that entity, that caused us both to take action in relation to that particular entity in terms of a stop order on their what we call their target market determination, in how they provide finance associated with the purchasing of goods. So, we don't regulate the sale of goods themselves, but finance associated with them, including this deduction mechanism, is something that ASIC has jurisdiction over. So it's like a debt facility, in effect, that we had a capacity to take action. And so we did take that action. And beyond that, though, we did take the chance to think beyond the action for there. What does this mean for the Services Australia process, and which entities are there, and how are they there, and what sort of review processes? So obviously a matter for Services Australia and something that they've been thinking about, but by having particular examples, whether it be this one or more widely, we've had constructive discussion with Services Australia, which has quite significantly changed. It's both, I think, their process for bringing entities onto their register, but also which ones are on there.
So you had discussions with Services Australia raising those concerns, and they changed their processes following those guys? Is that sort of the order?
Yes, but I wouldn't want it to be considered a single causation.
Yeah.
They've got their own process, which was already pre-existing in terms of having a review mechanism. It wasn't like it was not something. But yes, we did participate through regular engagement with Services Australia, an opportunity they've open to hearing insights, to hearing about experiences from whether it be ASIC or indeed from others as part of that process. So that included a public consultation process conducted by Services Australia, and they were really looking carefully at the objective of the mechanism that I described earlier and making sure that that works well for the consumers that Services Australia are working for. I understand their centre pay reforms were announced reasonably recently. It was on the 3rd of September 2025, and they take effect in early November. Around 250 businesses have been removed or proposed to be removed from the scheme that provide high-risk goods and services.
So do you think that's... is that a change in the process of... Is that a change in the process? I know this is largely a question for Services Australia, but if they're changing their processes around how people are getting led on to that list of businesses that are on there, or have they just found these bad actors as a result of people like ASIC finding these bad actors and they've just taken them haphazard individually? And do you think that there needs to be a more holistic approach to making sure that there is a process in place to ensure that these actors don't get onto Services Australia, I think, from a financial perspective?
My understanding of the consultation process that was administered by Services Australia was that it looked both at the wider process and the outcomes of the process, namely the particular businesses that were chosen. And so it was the specifics of who's on there changed, the 250 that I referred to, but I understand that some process changes as well as that were made, mandating end date for deductions, mandating businesses set target amounts. But I do think Services Australia would be able to assist with more details about that process if that would.
For sure.
Yeah.
But you would have had those discussions with Services Australia before all this consultations come out around ASIC's perspective?
Our engagement with them is ongoing.
Yeah,
so I referred to a particular public consultation process that they ran, but yes, we've had discussions preceding that and ongoing engagement with Services Australia, which has been constructive.
Fantastic.
Mr Moncrief, I just should also add, sorry for the Hansard, Commissioner Constant, because it's the first time I've been called upon. I'd just also add, Commissioner O'Rourke acknowledged our panel and some of the folks who come forward to give us this sort of information, because you started your question with how do we learn about these things. I think we should particularly recognise the work of some of the financial counsellors as well, who there's some individual groups and some individual financial counsellors who are really a great source of information and insight into what First Nations in particular might be experiencing in financial services.
And how does ASIC engage with those financial counsellors? Is that something that you have ongoing?
There's a range of approaches. So as, and any of my colleagues can speak to this, so there is the Consumer Consultative Panel, which has been mentioned, but also, for example, in the regulatory and supervision areas, which is where my predominant focus is, we have the Indigenous Outreach Program, which Commissioner Kirkland would speak to if he were here, which creates connections, but in the different areas, we engage with the different groups and different financial counsellors with a focus. Say, for example, MobStrong is one who that we engage with in the super sector to understand what are the challenges that are facing First Nations consumers, super members that are particular, and that was they were a really important voice in our work on our death benefits review. We're going to be coming forward with some work on retirement over the next couple of months. They've been a really important voice here in understanding the different challenges there. So I just thought it was important to recognise them.
Great, thank you. I just wanted to change direction a bit. So you mentioned, Chair, in your opening comments around the legacy technology that you've got in place around that you're continuing to invest in, and that there's a need for significant investment in digital technologies to prevent misconduct. Could you outline what technologies you might be referring to? Is that sort of ones that entities are using to report to you? Is that internal technologies that you're using to analyse data? I know you've mentioned around the resources required to get this exponential amount of data that you're getting. Could you just elaborate a bit more on which technologies you're investing in and what you, where the lags are?
It's a big subject. Just stepping back, there's a whole range of investment going on at the moment in a program we call Registry Connect, and I'll be asking Commissioner O'Rourke to speak about that. That's just taking a moment on that. In April 2021, all the business and professional registers went to the ATO. This is all history. Went to the ATO as part of what was then called the Modern Business Register program. That 3 years went by and a decision was taken for those registries to come back to ASIC. By that time, they were in great need. There was a report by a gentleman called Mr. Rees, and it laid out a series of options. This is a public report, I might add, that was commissioned by Treasury, by the then Assistant Treasurer. So that brings us to April 2024, and under a machinery of government mechanism, the registries and the relevant staff at the ATO came back to ASIC. And really the fundamental theme there, and I really want Commissioner O'Rourke to talk about this because it's become a major piece of our work, is what we would call the stabilisation and uplift of those registers. So that's the first big example of, I think it's objectively true to say, of underinvestment. For whatever reason, over the years, there was an underinvestment in those registers. And so we've been funded, for example, to deal with cyber risk issues coming out of that. And we're doing very significant range of investments to uplift and stabilise and modernise those registers. And that's a multi-year program that is really significant. It's all about how you file forms with us and incorporate a company, register a company, a whole range of interactions day to day by small business and directors. But it's critical economic infrastructure. So I'm going to ask Kate O'Rourke to talk about that in a moment. The other big area is it's a strategic imperative for ASIC to be digitally enabled. And that's where we're looking for a bit more funding there. I've been pressing for it for my whole time as ASIC Chair, and if I may be forgiven by the committee, I'm going to keep banging on about it for as long as I can. We're underfunded in that area. So earlier today, we heard about data, and Deputy Chair Court talked about the 10 or 12,000 ROMs we get a year, reports of misconduct. Well, that's sort of like tip of the iceberg, really, because we get thousands of reportable situations, for example. Under the Corporations Act, we get data from the Australian Financial Complaints Authority, we get data from internal dispute resolution schemes, external dispute resolution schemes. We get data from multiple sources. And attached to that is an expectation of ASIC, which ASIC has of itself, to use AI technologies. Well, I think there's one thing we all know about AI, and that it feeds off data. So we're underinvested in that area. So I'm going to just stop there. That's a big picture response to your question. I'm going to ask Kate to talk about the registries where a lot of excellent work is going on, and perhaps I could ask Kate to give some examples of, where our interventions have an impact on people's personal lives and with domestic violence and the abuse of the corporate form.
Yeah, no, thank you. So as Chair Longo said, the digital foundations in ASIC do span different areas, and in having responsibility come back to us for the registers, that's a particular area which we have needed and have been given some funding for that. So the registers are for companies, business names and professional registers. The Director ID and Australian Business Names Register remain at the ATO, so they've got investments associated with those. In relation to companies, business name and professional registers, they rest on very old legacy technology. So our immediate actions have been to stabilise that so that they remain available. People need to be able to get a business name and they need to register a company and get their professional registers. Our whole economy rests on these as kind of corporate form, and we're really creaking, and so stabilisation has been the goal. We've called our program Registry Connect because we are kind of looking at it more on a piecemeal basis rather than the Big Bang Modernising Business Register program that was discontinued. And we call it Registry Connect not only because we're doing our own work internally on those different ones, but also so that we effectively connect, for example, to the ones at the ATO. So we've got Director ID, a really important piece of information, and we need to be able to connect that to the companies that people are the directors of. Otherwise, tracing them and their activities becomes more difficult. But back to the technology investment, rather than a big dollar amount for the whole thing with grand plans, we've been much more tranched and given more specific goals year by year. So we have done we've completed the first tranche of our stabilisation, very strong emphasis on stabilisation and cyber, as our chair said. But we have done a little bit of uplift, so that was 24-25. Service stabilisation, maintaining our performance of this old legacy data, cybersecurity measures to be improved. We've had new call centre technology. We get tens of thousands of calls for people needing assistance with their forms, their companies and their business names. We've done a major uplift of the ASIC website, and that included a lot of work that we have been proud to showcase through our simplification work, but in relation to registry content particularly, we've really simplified the materials and tried to make it more accessible. We've got a new licensing portal for financial services, so that's one of the professional registers, and a professional registers search function. And then we've been doing a lot of design work. So that's been tranche 1. Tranche 2, sorry, I'll just finish this bit, is a 2 of 3 years we've been given $207 million to continue those efforts to stabilise and uplift. So there's a lot of efforts being got. All systems go on that work currently, and we'll be looking then to the 3rd year of the tranche and then a tranche 3 to really properly stabilise and uplift and make sure this economic infrastructure is really working for the economy.
Yeah. Can I ask, so you mentioned briefly around your discussions with ATO around some of that synchronicity. Are you talking to the other financial regulators around how you can avoid double-ups of reporting and things like that?
Yeah, thank you. It's an interesting one, and we've been very closely following some of the outworkings of the productivity and economic reform roundtable and some of the discussions there around reducing regulatory burden, sharing data, sharing information where available, because we think that that's something. In relation to the business registers, the main ones, we do have a business registers interagency liaison committee. I'm sure you'd all like to come along when we have those meetings. So we do have there the ATO, ASIC, ACNC, the charities regulator, DISA, Department of Industry, Science and Resources, because they run businesses.gov.au. We've recently included ORIC because they have a register of Indigenous organisations. So that's more data about registration of corporate entities. I think your point's a wider one, which is about, well, what about other data, regulatory data? And I think we're using Council of Financial Regulators and other forums to start thinking about how we can do that well as the mechanisms that are already there around registration data. I mean, I think there are some limitations that we're exploring around easily sharing information, if there's an address update or something. But like I said earlier, the idea of it being called Registry Connect is to do our best under the constraints that are there to make it as efficient for people who are just trying to do something in their day-to-day business activities as possible.
Cool. Thank you.
Thank you. And I'll now give the call to Senator Whittaker.
Thank you, Chair, and thanks for the very comprehensive briefing that you gave us ahead of today. It's been really useful and lots of interesting reading.
So just for the record, the committee had a private briefing to make sure that everybody was familiar with, and I think perhaps Ms Court you might have referred to when we last met a couple of times. It wasn't a public briefing, it was a private briefing because it was the first time that the committee had a chance to get across all the issues. So just for translation, that's what's going on, and transparency.
Yes.
Over to you, Ms Whittaker.
Yes, although just for clarity, I was referring to the written briefing that you prepared for this, but yes, good clarification. So I have a few questions about the first Guardian and Shield scheme. Sorry to jump around a little bit. I know you addressed that previously, but some of the information you provided to questions from some of my colleagues has been really interesting, particularly in relation to how the schemes operate. And what really stands out to me is that there are quite a number of steps involved, but I think in my mind that also presents perhaps multiple opportunities to intervene and to prevent these kinds of schemes from harming people. And so I'm interested in your views about how we might do that better. And I've got two examples that I'm thinking about. So you mentioned that there are a number of platforms who decided against listing these two funds on their platforms. And so is there more that could be done to put some burden, some pressure on those platforms to more proactively engage with you in that work that they're doing? And then another opportunity that I see perhaps is for super funds, the major super funds that, you know, largely do operate in the way that we would expect them to, at the point at which one of their customers seeks to withdraw a significant amount of funds, surely that must be a flag to that super fund. I'm sure they don't want to lose them as a customer, but also in terms of more broadly preventing these kinds of schemes from affecting people in the future. Is there a role for both those super funds and the platforms to play in identifying when these funds are operating and potentially stopping them from harming?
Multifaceted question. I'm going to give you some broad observations, and then I'm going to go to Mr. Savundra, some combination of Mr. Savundra, Deputy Chair Court, and Simone Constant. We're in the middle of trying to resolve a really complicated situation, and I just want to remind everyone our major priority at the moment is trying to get money back for investors and hold people accountable. But I would invite government to sort of step back and say, well, what can we learn from what's happened here? And your question, I think, touches on a range of points. One of them, which I'll ask Simone Constant in due course to comment on, is whether we should introduce a friction, of my word, so that when you move money from a major super fund, the words I used earlier, sort of a conventional safe environment like a major retail fund or a major industry fund, is there something we can do there to slow people down?
Yes. Yep.
And that's complicated. Secondly, a lot of the investments, and this is an issue I have to say the system's been grappling with for many years, a lot of the managed investment scheme products that are sitting on these platforms, they really the point I want to make there is we have a pretty permissive regime in Australia. And so with the managed investment schemes, with retail managed investment schemes, the underlying investment can be anything. So in a recent speech, I talk about alpacas, meme coins, it can be anything. Now, that in and of itself is, I think, a legitimate issue. And for so long as we have such a permissive regime with managed investment schemes, then I can tell you now with moral certainty there will continue to be losses as the years go by, because history will just keep repeating itself. I just want to make that absolutely clear. Now, bringing this back to what we're dealing with here, the superannuation trustees, the equity trustees and the acquirers of this world, they have certain obligations and responsibilities under the current legislation. Those responsibilities and duties haven't been tested before. They just haven't. It's a critical part of our system, but just haven't. So this whole saga is shining a light on what can we expect of those trustees, and we'll have to see how that goes. Now, I think maybe Chris Savundra or Sarah could give us a bit more insight as to what is happening there. So they were the two key parts of your question, weren't they? So yes. I might ask Sarah or Chris, and then I'll go to Simone.
Thanks, Senator. Yeah. I can be quick. I think, as Mr Longo said, you had two questions. So firstly, what about the obligations of the trustees and the platforms? And the second piece was, should there be some friction introduced in transferring funds out? So on the second point, I'll pass to Commissioner Constant. On the first point, I'll just perhaps restate what I said earlier. So superannuation trustees under the current law have obligations about investment due diligence, and that's in a variety of different pieces of legislation. The Superannuation Industry Supervision Act, the Corps Act, and APRA, one of our fellow regulators, has its own prudential standards. The action that we took recently against Equity Trustees Superannuation Limited has alleged failures in due diligence in relation to onboarding the Shield Master Fund. So that is the first time this will be tested. We think those obligations are there, and we have got investigations, as I mentioned earlier, in relation to the other trustees as well. But that is the first time that we have sought to test, what are the obligations of a superannuation trustee when it chooses to make funds of the calibre of the Shield Master Fund and or the First Guardian Master Fund available on its platform, available to members that it has these fiduciary obligations in relation to. So we think the law is there now, and we're certainly testing that. So that's on, I think, your first point, Senator. But on the second point, which is a very good question to ask, I'll pass to Commissioner Constant.
Thank you very much, Deputy Chair. And yes, so just to extend on that, what you're sort of bringing forth is some of our reg and supervision work in the area as well. So you've heard a lot today about the enforcement work in recent times, recent years. The companion piece is the regulatory and supervision work, which goes to the prophylactic comment I think that the Chair opened with today. I would say frictions is a word you can use. We tend to just talk about the responsibilities of the trustees. The obligations are there. So some of the work we've done in this regard to remind them of their responsibilities and obligations. And it's not just trustees, as has come up today. This is an ecosystem. So there are multiple touch points, which does mean on one hand we've talked about different people pointing different fingers. It also means as ASIC we need to keep on top of everyone understanding their place in this chain. There are some pieces of work that I could refer the committee to that we've done over the past 12 to 18 months that might be useful. So one is Report 779. So that was released, we released that, and I spoke a little to it in February last year. That was about exactly these sorts of themes, super choice products on platforms in super funds and offered through that system. And just to sort of read from that to be really clear, we open with trustees are the gatekeepers of the options made available in any product they offer. They set the criteria for inclusion on the investment menu and can restrict access or remove options from the menu if they are not meeting investment objectives. And we also then went and looked at advisors and advice licensees, and this was off the back of some very detailed surveillance of 10 trustees. And what this calls out, and we can continue to call out, is that trustees have a responsibility to review those products they offer on their platform. Now, our responsibility as ASIC is around the conduct and disclosure. We have our sister regulator in APRA who obviously do an excellent job when it comes to investment governance and the standards, and Deputy Chair Court mentioned that. But this report, and in our commentary and our statement since, about the requirement to have trustees not just look at fees when they're deciding whether to have something on the platform. Are they meeting the investment objectives? So checking, are they performing? So that's the first piece, and whether they're meeting the objectives that they're being provided for. A second piece in terms of our work that I could refer you to is Report 781, which was mid-last year, again, observing these practices in this ecosystem, some work that was done, some surveillance and a report about trustee oversight of advice deductions. Because, of course, as you've heard today, the folks that we've been talking about earlier have been advised into these products. So in order that a trustee release the funds to pay for that advice and support that part of the system, and advice is a very important part of the system, and ASIC continues to say that, we did remind advisors in that report that they have, again, to read from the report, the legal obligations relating to oversight of advice fee deductions, but also to ensure that the services that are being delivered consistent with what you'd expect of the advice and efficient, honestly and fairly. So
trustees are specifically instructed to move all of the members' funds from one fund to another.
Correct.
Can they stop that?
Yes. So
just answer that.
So the specific question about whether they can stop that, they can't stop that, but they can take the risk-based approach. So you need to respond to the members' direction, but our call to them is to operate that risk-based approach. So if you see, for example, the advice, so in sampling the advice is not meeting the standards, then notify ASIC, which we continue to call out and called out in that report. If you see... Could
you just state the number of the report again? Was it 181?
So reports are 779, which is about the choice products responsibilities, and 781 about oversight of advice deductions. And in the same way, we call on trustees to operate a risk-based approach to scams. Observe if somebody is withdrawing money and it seems that they're withdrawing the whole amount and wanting to do something that seems unusual, that should be a red flag. Ask the member, why are you wanting to do that? What's this about? So it's not to interfere with their responsibilities to pay that money across, but it is to have that risk-based approach. So these are the sorts of calls to action that we have talked about with trustees and put into our work, and we continue to reinforce those messages.
I guess following to that though, could there be a more explicit warning? If I think about how banks have begun, particularly recently, to be much more specific in saying to people, every time I log into my banking app, it tells me that that you might be being scammed. It's really quite explicit in the work that they do. And I think that's a really good thing. And I wonder if that is something that perhaps, rather than just asking some questions that are a little bit, that are kind of more general in nature about why you're doing this, or could they just be really explicit that, people are essentially being scammed here, and we've seen the kind of collapse of some of these funds. People have lost significant amounts of money. Be careful.
Yeah, so I can answer part of that, and I think the Chair would like to, or the Deputy Chair might like to circle back to the responsibilities ultimately that trustees have in terms of it is members' money and the ability to move funds. And there's an APRA element to that as well in terms of the time and the ability to roll out and release. That said, we have in our work on scams, so we put out a piece and I wrote a letter under my name to trustees earlier this year about scams and the investment that can be made into observing where there might be a scam based on their behaviour and actually putting those warnings in place and including in that digital format that you've talked to and using that same risk-based approach, whether it's sampling advice in the oversight of advice deductions that's part of this ecosystem, or seeing if funds are being moved to, there's a particular advisor moving funds to a particular place, for example, do you get correlation? Not just asking the right questions of the members whether they've got unusual activity, but also notifying us. That's been one of our calls, and I'll refer to my colleagues.
Yeah, it's a really fundamental question. It's a step back. In my view, the superannuation trustees, the big superannuation funds, have to start behaving in a more bank-like manner. That's the way I would put it. And secondly, what's happened is we credit where credit's due. The superannuation sector has done a terrific job at what's called accumulation and investing funds. And so that we're not talking about that. What we're now talking about is this growing pot of money that they're managing and they're beginning to pay out. And so a lot of ASIC's priorities now is around member services and customer responses, a whole range of things. I won't go over them. But the key point is that I think the superannuation trustees are beginning to appreciate that they have to be more bank-like and invest in technology, systems and processes where their data is, have a more service-oriented mentality. And so we're in the middle of a big transition. As the sector matures and gets bigger and bigger, these expectations, some of them are based in law, others are just expectations, are going to have to be addressed and debated. But to me, I've always felt that was a good way of thinking about it, because you've got a major amount of money in super that you're not going to get access to till later in life. But a lot can go wrong, as we all know, as that happens. And then you've got day-to-day banking, which is another set of issues.
And it depends on the bank, based on what we were hearing earlier, whether they're actually doing the right investment in terms of risk and have the right culture. I mean, it's okay to say be like a bank, but I won't say which bank.
Bank-like in the sense, I think the Senator gave some examples around scams, warnings. It's a more proactive mentality, if I can put it that way. While a superannuation fund, historically, it's been an accumulation mentality. It hasn't been very proactive in terms of all these other issues we now have and expectations. Now, how that looks, how we regulatory and prudential settings around that, I think is a work in progress. But as we all know, superannuation has become such a major part of our economy and also in the lives of every Australian. So I think this is a good discussion to have.
The risk will grow, and again, just out of interest, with the pieces of work I can refer you to, so Report 761 and Report 790, that they address in obviously more detail what I've spoken to here, which is, what we asked of trustees at the beginning of this year, and as I said, I reinforced it in a letter to trustees, to review their anti-scam and anti-fraud measures, to understand the weaknesses, and to think about some of these sort of technologies and risk-based approach. I'm very mindful, as the Chair has said, that these are not banks in terms of the payment responsibilities, but nevertheless increasingly important, second largest, if not the largest investment an individual has. The risk will only grow. And I think if any trustee were sitting here today, they would acknowledge the same.
Thank you. And then my final question on this goes to some of the education work that you've talked very briefly about. Can you give us a bit of a summary of what that work looks like and whether there are any particular groups or demographics that you're targeting in that work? I guess, are there particular demographics that you think are particularly vulnerable to this and particularly being targeted by these schemes?
I'm at open with it's multifaceted because, as I said, this is an ecosystem. If he were here today, Commissioner Kirkland would talk about, for example, the Just Hang Up campaign. And one of my colleagues who's here today, who could give more detail, although we'll probably run out of time, was very involved in that, and that's Ms Shakat behind me. So that was about that education coming forward a little over a year ago, which was about if you get these sorts of calls and it feels like this, as the Chair has said, you wouldn't buy a house just on the phone overnight, right, in the moment. Do your due diligence and understand. The second part would be both the education on the super side, so the responsibilities of the trustees themselves, both the work we've done with those reports last year, which really said, and deep messaging about these are your responsibilities, here's some better practice, some ways to go about these red flags, notifying us, having that risk-based approach where there might be problems, but also to the members themselves. So I'll speak to the members themselves component. We've been, for the past year, had a consumer-focused, and again, Money Smart is something, hopefully that you're becoming familiar with, a Money Smart style campaign to members, to Australians, to engage with your super just the way you do with your banking services. Now, in part, we're saying to them, call on your fund to make sure your services are meeting the requirements and the obligations. But it's also simple things like, on one hand, because you're talking to scams, as well as this sort of fraud and mismanagement of money, to say, keep on top of your balance, right? You probably look at your bank balance every day. Make sure you got, download the digital app if you're able to have the digital app. Check your details are there. Check what your balance is and keep on top of it. Right through to then when you're making decisions, that call, that education call to when you're making these decisions, this is increasingly the most, could be the most important asset you have. Take the time, do your due diligence. This is what that looks like. This is how you get access to advice. So it's been multifaceted in terms of the ecosystem, but also in the audience, both the trustees themselves, the advisor network, which Commissioner Kirkland can talk to in more detail, but the advisors reminding their obligations, but also the members. And we're actually continuing with that. We've got a campaign at the moment about engaging members in the different age groups as well. Right. And final thing I'd say is the risk grows not just because the pot of superannuation grows, because of the retirement phase. As the Chair has mentioned, as people we know from our data and from other data, as people approach retirement, they engage more with their super, which is great, but it may also mean they are more prone to things like switching. And so we're trying to communicate and understand younger demographics, even the language is different, to communicate with them about understanding their super and their engagement. We're trying to actually segment on that basis as well and understand the different vulnerabilities and the way they want to be communicated with.
Thank you. I guess one of the things that we've seen in the public place is a lot of let's talk about fees, let's talk about fees, let's talk about fees. If that becomes a wedge, it's a dangerous one. If the fees are less but you lose all of your money, that's not a good deal. So fees as the engagement device is a risk point as well. I think we're all maturing, I guess, in how we speak about post-accumulation or even in the accumulation phase, our capacity as a nation to have the financial literacy to figure out, you might save 2 cents a month on fees. But if you switch out of one of the big funds where there's a lot of protection and a lot of security to a more high-risk vehicle, that there is a huge loss potentially right on the horizon, even if the fees are lower. And I don't know that we've had that public conversation to the point where people really understand that, and that's just more ammunition for these dodgy financial crooks to use to exploit our fellow Australians. So it's going to be a very interesting time going forward. And I'll put a question on notice about interruption points and education points that expands further on the excellent line of questioning from Senator Whittaker. I'll move now to questions from Ms Lawrence.
Thank you. I will, in another section, go back to ANZ in particular. But for the moment, the Prime Minister and the Minister for Climate Change, Chris Bowen, will be shortly announcing Australia's 2035 target for climate action. And to that end, I just want to pivot to greenwashing. And I know it is one of your 12 priority areas. So a couple of years back, I think ASIC reflected that 80% of global GDP is subject to a net zero target, and that there was a forecast of around 70% of ASX 200 companies are themselves subject to that target. And a third of assets under management by 2035 will be ESG assets, environmental social governance assets, or around $53 trillion globally. And I appreciate you might wish to update those numbers. But they're significant regardless. I can't imagine there'd be huge variance. It will be a massive need for that disclosure and integrity around marketing of how companies will reach their own targets, particularly across the financial products. So I was just wondering if perhaps you could speak to that. Obviously, we've had the Chubb review. So just any updates that you can provide and any advice you can give to companies who will be listening to the new targets set for 2035.
Yeah, no, thank you. I'm pleased to contribute to this and acknowledge your point that this is a much wider discussion, and there's aspects of it that are clearly economy-wide or for the government and this week, and then there's aspects of it that are more directly within ASIC's we contribute more directly to. So the two areas that we can directly contribute to is the climate disclosures, so financial disclosures of climate information, and secondly the greenwashing work that you mentioned as well. So in relation to the first one, Australia has got a really new and important set of requirements on companies to disclose information about their climate, so the strategy, the risks, the opportunities, as well as the metrics associated with climate risk as it affects them as a company, and that's something that's just taken effect, and we're the organisation that administers those reporting requirements. So they took effect from the beginning of this year, and so we're expecting to receive the first official formal reports, climate reports, from March next year. So people who have a calendar year end will are preparing those reports, and now the ones that have a 30 June one do as well. So those reports are in preparation. I think your question alluded to the fact that actually a lot of people have already been preparing reports, and that so that's been more not against the required standards, but the prior ones, which is the TCFD, the Task Force for Climate Financial Disclosures. And so we do have a lot of information in the economy, particularly from our bigger companies and our internationally oriented companies. And some of that does include the transition plan, information, I think you referred to as well. So the requirements that have now become mandatory on companies and are coming in phases, they don't mandate companies have to take particular climate action or strategies or have particular transition plans, but they have to be honest about what they do have. So if they don't have one, they need to be clear about it. If they do, they need to have the foundation and the metrics to give it a basis, the reasonable basis, so investors and people in the community can look at those reports and assess that company's position in relation to decisions it's making about transition, but also the risks, even if it doesn't have a transition plan. What risks are they subject to that are climate risks? or what opportunities do they have if they're in a business that is looking to take advantage of opportunities that exist. So we do have those reports. Like I say, lots of them are already in the market. They're based on some of the older foundations but are becoming uplifted to match the new ones. And then we do look forward to getting those ones that are lodged with us from next year. We've already been doing a lot of work to support companies make that transition. We've got web content that has, because they're difficult and challenging to meet, but I think we've also been trying to give feedback to people on those voluntarily prepared reports as well, including on some of the areas that you've mentioned. So there's that available. Separately, I think you mentioned as well greenwashing. So that is action that ASIC has taken where we've been concerned that green-related statements that people have made, in our case predominantly about investments. The ACCC administers green statements about products and services, but we're about investments. And where we've been concerned is that if they've been, back to misleading and deceptive, whether we think that someone has been, an entity about an investment decision or proposal has been misleading and deceptive. And so our greenwashing work is not about those new provisions that I referred to. It's about really long-standing Corporations Act provisions about and ASIC Act provisions. You shouldn't mislead people. If you're going to offer them an investment opportunity and if you're going to make claims about it being green or net zero or one of the other claims that it's made, or indeed wider than climate if it's about guns or other ESG-related things, it's got to have a foundation, and it shouldn't be misleading and deceptive. So we've had as an enforcement priority that idea of greenwashing for a number of years, and have had some significant cases where we've had quite, I think, significant penalties attached to outcomes where there has been a finding of misleading and deceptive conduct in relation to those sorts of claims.
And just to that, so I understand last year the Federal Court handed down ASIC's first greenwashing civil penalty to Mercer Superannuation, $11.3 million penalty. The Federal Court ordered Vanguard Investments to pay $12.9 million, and then a further $10.5 million against LGSS Pty Limited, and that they had the Act of Super contravened the law when it invested in various securities that it claimed were eliminated or restricted by its ESG investments screens. So what change have you seen, particularly in these high-stake investments, to this? How have they responded to these court findings? Because otherwise, it just sounds like it's like whack-a-mole. We're trying to play catch-up, and as opposed to actually seeing cultural change, structural change, if necessary, legal change. So these sort of things are not happening at all.
I'm happy to step in there. Ms. Norris, just on those enforcement outcomes. So as you say, we had those three very significant greenwashing outcomes, and just stepping back for a moment at a high level, all of those matters really involved, as Ms O'Rourke said, claims made to investors that certain kinds of investments would be excluded from a superannuation fund. So whether it be investments in fossil fuel industries, investments in tobacco industries, those sort of things. And the court found, under the existing law, has been around for decades, misleading and deceptive, that the investment screens that were purported to be applied weren't applied. In terms of, what's the impact of that been? Has that changed conduct? I mean, it's hard to be definitive on that, but what I can say is anecdotally, the feedback that we've had about those matters is that it has made some very significant change to industry practice, and that people are being, investment managers, superannuation trustees are being very cautious and very careful about the claims that they are making about ethical funds, sustainable funds, green funds and the like, because our message has been, as Ms O'Rourke said, the only reason to label funds with those kind of descriptors is because we know that so many investors want to put their money into ethical investments, if I can use that broad term, or what they can, perhaps a better way to frame it is in accordance with their values. And so those funds, investment managers and the like make representations to entice people to say, look at us, we're very responsible, we're only investing in these kinds of companies. So people put their money there, and what we've been saying, really, it's a very simple proposition. You don't have to make those kind of claims. If you do make those kind of claims, it's obviously for the purpose of enticing people to invest with you. You have to be able to sustain them. They have to be true. It's not a complex piece to understand, and as Ms O'Rourke said, it's very different to the mandatory climate-related disclosures that the new laws. That's very different. We're talking about just misleading and deceptive conduct 101.
And so those companies, that obviously it's a significant impact in terms of the fine. What were the consequences of the people involved that were undertaking that misleading and deceptive conduct?
So all of those matters, we took action against the companies themselves. And one of the things that we're constantly trying to think about in our investigations then is, are there particular people involved in the conduct itself that should be properly held to account? In these matters, the view was it was a corporate act, if you like. So we have sued the corporate entities, each of Vanguard and Mercer and Active Super, as you say.
Can I ask if is there anything preventing you from taking action against individuals in addition to the corporate entity, and what facilities you have to name and shame individuals who can pick up the business model and just move it along to another site?
There is a legal requirement under the Corporations Act and the ASIC Act that in order to hold an individual accountable for particular misconduct, they have to be knowingly concerned in that conduct. And there is a range of legal tests, if you like, that have to be made out. Do they have knowledge of it? Have they intended to mislead? Did they know that Mr Savundra will be able to answer this more articulately than I can? But it is not I think there's often a perception that you can readily hold individuals to account for what is effectively conduct of a corporation, and we very much understand the logic that says, well, someone has to be, responsible for this. But what we usually find in our matters, particularly when you're taking on large corporations, is that there actually isn't one or two individuals that are responsible for where a corporation has ended up. So if you look at something like greenwashing, there will be policies, investment committees, risk and compliance professionals, lawyers involved in clearing things. So it's very hard to find, a person or a couple of people that you can say were knowingly involved in the overall contravention by the company.
So what that suggests to people, who are perhaps a neighbourhood financial advisor, they're easy pickings for ASIC in terms of them facing consequences, losing their licence to operate, potentially facing criminal proceedings against them, not just civil. But if you can get your business big enough, you're protected from consequences, even though the faceless corporation doesn't make any decisions, it's the individuals within it. Is that the conclusion that people can safely reach?
No. And what has changed in recent times, particularly following the Hayne Royal Commission, where Commissioner Hayne dealt with exactly these same kind of questions that the committee is asking of us, is that we have a new regime now called the Financial Accountability Regime. That is a very significant new piece of law and was introduced, as I understand it, it was a bit before my time, but it was introduced directly in response to these issues. That regime covers banks, superannuation entities and insurance companies, and what it requires is for each company to give to the regulators, being ASIC and APRA, and we are co-administrators of this new regime and we're working hand in glove together. But the institutions have to provide, in broad terms, information to both of those regulators about who within them is responsible for particular subject matters within them. So who's responsible for scams, who's responsible for compliance and risk, who's responsible for legal. As I say, I'm using very broad, non-technical terms. Yeah. But the purpose of that, Ms Lawrence, is to enable the regulators to hold individuals to account, so that we hope going forward that we won't have the dichotomy that you have articulated, which is that if you're a smaller firm, it's much easier to work out who might be responsible for conduct, and in the bigger firms that's much harder to articulate. With the new financial accountability regime, we are hoping, the regulators are hoping, that we'll be able to address that very issue.
And now, so when does that accountability regime apply from?
So that's now in place. I think it's been in place since
last year.
Since last year?
Yeah.
So has anyone been held accountable under that regime?
Not yet, but we have all of the maps, if you like, and when I say maps, the maps are what the financial institutions give to us, accountability statements, thank you, Mr Longo. So it is now all in place, and it's something that is, we are engaging with institutions about on a regular basis. We're having correspondence. There's been no public outcomes as yet from an ASIC perspective, certainly, but it's a watch this space.
And is the misleading and deceptive conduct captured by this regime?
All forms of conduct that ASIC is involved with, you could, in addition, find liability under the financial accountability regime. I mean, again, I don't want to talk too loosely. There are particular legal requirements that would need to be investigated, evidence-based and the like, but it is certainly there to, as I say, to respond to the very issues that you're asking of us.
Sure, thank you. And I'll probably circle back to that.
Everyone's got lots of questions to come back with. We're going to go to lunch at 12:15, so I might just go to questions before the lunch break, and we'll return at 1:15. If I could get some quick answers to a series of sort of rapid-fire questions. Picking up on the FAR, what implications does the current ANZ situation have with compliance under the financial accounting regime, given FAR is jointly administered between ASIC and APRA? What is ASIC concerned with, and what does APRA focus on in particular with regard to ANZ?
Well, the FAR regime will be prospectively very relevant to ANZ in the next year or two, because they have committed to a range of remediation programs, the successful execution of which will be the responsibility of senior executives. And as Deputy Chair Court said, the FAR regime is designed to sheet home responsibility to particular executives for particular aspects of the business of the entity. So I think the FAR regime does have a role to play in the future, but just focusing on ANZ this week. So I think that's we'll obviously be monitoring ANZ as we do all the banks, but certainly ANZ in particular, based on our ongoing institutional monitoring and supervision.
You take on notice, so we understand better for the next time, which bits of ANZ are ASIC bits, ASIC observance, which bits are APRA observance, so that we understand how things integrate. Yeah, we're
very happy to send the committee a document, but essentially we're a conduct regulator.
Yes.
And
that's
APRA
culture.
Is a prudential regulator. There's no suggestion, I might take this opportunity, by the way, that there's no suggestion that there's any prudential issue or safety issue or soundness issue so far as ANZ is concerned. The problems ANZ that is the subject of discussion this week are to do with conduct, with the management of their non-financial risk.
Okay. Could I ask then, on the back of that, how many whistleblower complaints, and I know you have the term...
Beg your pardon, sorry, Chair, how many...
Whistleblower complaints, and I know there's a differentiation in language that's been used this morning, ROMs, which refer to reports of misconduct, to whistleblowers, and I have a whole series of questions on whistleblowing that I'd like to ask perhaps later in the day. Mm-hmm. How many whistleblower complaints, and maybe we might even get the ROMs or anything in between categorised, were made about banks, super entities and other entities supporting critical infrastructure, such as the ASX, over the last 6 months? Maybe make that 12 months, so we get a kind of sense with some dates, if there's a scale of rise or fall over that period of time.
So you interrupt you, you're talking about whistleblower complaints.
Whistleblowers, ROMs, any other sort of reports, because you referred to a range of ways in which information comes in. I think it would be good for the committee to have visibility of how much is coming in, where it's coming from, and get the sort of cumulative rise and fall of that, who it's about, and how scary they are. So can you give us something quickly?
I can give you something quickly. I don't know that it will cover all of those points, Senator. In the last financial year, we dealt with 702 disclosures by whistleblowers, which was an increase on the previous year. About 68% of those disclosures related to corporations and corporate governance, including internal company disputes. We also dealt with matters relating to credit and financial services and the conduct of licensees. That was 19%. 5% related to markets-related issues. 7% of those disclosures were referred to specialist teams for further consideration and investigation.
Okay, so come to licences, 19%. So, roughly 20%. A fifth of the whistleblowing complaints that you're receiving are about people who hold licences.
The conduct of licensees, that's right.
Which you're responsible for.
Yes.
You are the only entity that can deal with that cohort. I've had a quick look online at the Register for financial advisors. And I can see that, there's basic information there, but there's no signalling. Like if I'm just a normal Aussie and I hear the name Nicholas Macusis in the paper, or David Anderson or Simon Selimage, names now synonymous with the First Guardian and Trust. Shield Trust. I can't go on to your website and see anything about financial service licensees that tells me whether they're good, bad or indifferent. They're just there. Is that correct?
Well, if you're talking about those particular people, there's extensive information on our website in relation to First Guardian and the Shield Master Fund and the individuals
and that
involved
happens
in
after
there.
You've taken action.
Indeed.
And it would be a public announcement through a press release normally that would say, we've done all of our due diligence,
Yes.
we've done our work, we are now confident to put these names in the public place. Right. But from the moment you found out about them doing things to do your due process, the risk for Australians who are engaged through their deceptive practices continues to sort of float along. What would an effective and ethical early signalling structure be, where people could go on and go, yes, they're a financial service licence, they are currently under investigation, or there have been complaints made about with regard to, that people could actually go on and have some ownership, because we're saying buyer beware. Yeah, well, who's going to help me beware is my question.
So there's a range of answers to that, Senator. So in response to one of the earlier questions, I talked about our investor alert list. So that is somewhere where people can, certainly it's a first port of call if people have concerns about a particular companies or particular investment options and the like.
Would Mr Anderson's name pop up there before you made an announcement about him?
I don't know if his name is on that list or not. I confess I can find that out for you. But there is an issue there, Senator, about the confidentiality of investigations. And again, without wanting to sound defensive, these are some of the judgment calls that we have to make all the time. When we receive reports of misconduct, and I should also separate whistleblower reports that are treated in a very particular way, and then general reports of misconduct. So there's a strong divide there. But and I know we need to break. But in relation to our investigations, we do protect the confidentiality of those investigations until we are of the view that there is something that the public needs to be warned about. And as I said earlier, that can take us some time to work through. We do have...
So can I put it to you,
yes,
Ms Court, that we are at a moment now where there's been an awakening of awareness about risk. Hopefully today people are going to get a phone call and go, hang up.
We agree.
And you've been working on that. But I'd put it to you that Australians know that you're doing this job, and that if you've got a financial service licence, it's a big deal, and that the people who have it, dealing with your life savings, are people of integrity, and you make sure that that's the case. from Ms Lawrence's questions about, the corporate protection, the veil over all of these individuals. We saw it in banks with people providing terrible financial advice. We're seeing it again in these next iteration of how do I scam my fellow Australians. We're at a point now where Australians are going, no, we need more protection, more warning that doesn't accord with your current structural requirements in terms of due diligence and fairness to the individuals who are getting a licence. I'd put it to you that the rights of the licensees to rip off Australians are more sound than the rights of Australians to have expectations of high-quality professional behaviour from those licensees, those financial licence holders. Could I ask perhaps on notice for what a recalibration to meet the goal that I think we all want is freedom to invest safely and the right to choose for yourself how much the level of risk is. That there's a miscalibration at the moment that seems to favour the financial service licence holder against the Australian public.
Yeah, there's some big questions in there, Senator, and I think Mr Longo has given evidence earlier today about the permissive nature of the ability to invest, and so there's some big policy questions there about how do you balance these very issues that you are raising. What protections, if you like, do we put around investments? What role should ASIC play because we're not there to...
You're referring to managed investment schemes there, right? And you made that very clear about managed investment schemes. I'm not talking just about managed investment schemes. I'm talking about people who, it seems to me, go, I've got a financial services licence, let me go. I can rip off as many people as I like now under that cover of the licence. I can do that, and we're seeing people who are not sufficiently incentivised to professional behaviour and legal behaviour using that skill after a hawker gets their hands on a vulnerable individual with less knowledge than them. And this is why we have professional standards. So specifically
most financial service licensees are actually small businesses made up of readily observable individuals. So I don't think there's any particular concern about the corporate veil protecting them from their misconduct. But then there are some fundamental concepts that we need to put on the table.
Yep.
We are a risk-taking nation. We're a democratic capitalist economy. Our policy and legal settings are actually designed to encourage people to invest and to take risks. And our managed investment scheme environment is a perfect example of that. So we will do our best to protect investors, but as the Chair noted earlier today, some self-protection mechanisms may also be required. Secondly, if I may say so, ASIC can't simply say, we think that individual's a bad person or that business is a bad business. As we speak, we actually, from time to time, are dealing with defamation proceedings against individual commissioners and against ASIC itself. So we have the rule of law. We cannot be publicly shaming people unless we have a reasonable basis for doing so. So we take that duty really seriously. It's a duty of fairness in a country of rule of law. As far as holding individuals to account, it's a huge problem, a challenge to the system. For corporations, particularly of any size, they can only act through people. And when they do the wrong thing, there's usually lots of people involved. And to hold merely one or two responsible for the sins of hundreds within the corporation is in and of itself unfair. And our system is not designed to deal with that. So unfortunately, a lot of the time when corporations misbehave, they do so through the acts and omissions of present and former employees. And so occasionally you'll see from ASIC's enforcement work that we actually do commence proceedings against individuals where we think fairness and accountability requires that to happen. So from time to time we have a number of cases going involving directors' duties, for example, against individuals. But the fundamental enforcement issue and philosophical issue we face, and I take this very seriously, exercising a public duty, is I can't just sue people just indiscriminately. A lot of what goes wrong in a corporation, ANZ's a very good example. When you read the statement of agreed facts, there are lots of people involved in what went wrong at ANZ, and to pick up on one or two people, I think would have been inappropriate. So where we think individuals should be held to account personally, then we have regular meetings to discuss that, but a lot of the time you will see ASIC only taking action against the corporate entity.
I guess the safety in numbers, though, protection it remains there, and it's a very fine balancing point. I mean, I'm all for the rule of law, but the rule of law is there for the benefit of all citizens, not to be exploited as a tool of business for those who are willing to make profit at any price, including ripping off their own fellow citizens. I'm just going to table a document which I'd like to come back to after lunch. One, so that you can refer to it. It's an article by Cleona O'Dowd with regard to Macquarie's plan to repay Shield investors $320 million. It's out in the public that this is something that's likely to happen, and my questions go to why the delay. So I'll just table those now so that you can have a look at those during the break, and we'll come back with that as first question, and then I will go round again. So Senator Hume and then Senator Pocock after lunch. Thank you. Oh, then wait on. The committee will resume. Senator Hume, you have the call.
Thank you very much, Chair. I just want to go back to some of the issues around First Guardian and Shield, and particularly around the issue of the lead generators and the dodgy call centres that were being used to funnel Australians into these schemes. Can I ask, ASIC, when did you first know or hear about these lead generation schemes?
Senator Hume, the idea of sort of lead generating schemes or cold calling at a broad level has been something ASIC's been aware of, I think it's fair to say, as far back as 2005 when Choice Super became available. So it's something that has always been on our radar. And then we did a suite of work in relation to these kinds of issues, starting off in around 2020, and have done a whole range of different campaigns and education and media releases, and I can find the various information about those for you. In relation to these particular funds, if that's what the question is going to, I think my evidence would be the same as that which I gave this morning. I think it's set out in the Appendix 1 of the submission that we put before the committee when we first became aware of particular cold calling or selling practices issues around each of these funds. And I can go back to that again if you'd like me to.
No, I've got that in front of me, but thank you. So I suppose what I was trying to get to was more whether you had seen before these aggressive lead generation practices and whether they had set off alerts for you, whether it was something that you had spoken either internally about and thought needed addressing, or whether it's something that you had potentially advised ministers of or Treasury and made them aware.
Look, I might invite Ms Shaka to the table, Senator Hume. Ms Shaka's been involved with a range of these issues for quite some time on the non-enforcement side in terms of dealing with financial advisors, lead generators and the work that's been done by ASIC over a number of years on that. So if you'll forgive me, I'll hand to Ms Shaka. Are you able to take that? Thank you.
Thank you. Leah Shaka, Senior Executive Leader of Financial Advice Investment Management for the Hansard. We've been aware of these type of practices to varying degrees in the past. As the Deputy Chair mentioned, we've had a range of activities looking to address them. Some of them have been enforcement and some have been the regulatory sort of thematic space. I think it's fair to say these particular models were, how to describe them, more successful than others in the past in terms of the scale that they were able to generate.
Okay. Is it something that, having seen for a while and then seen this particular most egregious case of misuse of lead generation and cold calling, is it something that you potentially have recommended policy changes to government on? I mean, for instance, should we ban cold calling?
Yeah, so we have engaged with Treasury on the issues over the years. There were some changes to the hawking provisions a few years ago, but obviously these models have adapted, but it is something that we have engaged with Treasury on.
So, sorry, let me be a bit more specific. Have you recommended to Treasury that they recommend to the Minister that cold calling be banned?
I don't think we've been as explicit as that, but we have been engaging with Treasury even more recently around potential law reform that would look to address some of these practices.
Right. So that was more recently. I just want to get a little bit more specific. Have you spoken to Treasury about this potentially egregious practice earlier than more recently?
Yes, we have been engaging with Treasury in relation to cold calling and lead generation more recently, but I think the frequency and the nature of those conversations have escalated of late.
Okay, because clearly there is some sort of legislative or regulatory gap here that these cold callers have fallen through. And if that came to your attention some time ago, I suppose what I want to understand is what was done about it to prevent more consumers falling into that trap, because it's still going on today.
Yeah. So there's been a range of activities. I think part of the challenge, Senator, is that these models don't all look the same. So we learned this in the thematic review that we did, where we engaged with these entities. So the role they play in the broader sort of advice process differs depending on the different entities. So some we found were really engaged in the process. Others were more marketing type businesses that, you know, also marketed other products, so more generic consumer products. So I think that's part of the challenge. There's different models out there. They're not all sort of following the same script.
Was there any assistance sought, for instance, from the ACCC to use consumer law tools around this sort of misleading conduct or unsolicited consumer agreements, whatever it might be, in parallel to the advice that you were then giving to Treasury?
I don't know that we engaged with the ACCC. I'd have to take that on notice. We did engage with ACMA around some of the practices in the course of our campaign. So we certainly did engage with other regulatory bodies. I think part of, in addition to the enforcement work we did, and there's quite a raft of enforcement work over the years, looking at addressing sort of aspects of the model, we really focused on the consumer aspects, so the Just Hang Up campaign. We thought it was critical to get the message out there, and still think it is. We've just recently repeated that campaign. We think that's a way of sort of addressing the conduct, in addition to the other things that we're doing. The other thing that we did do as a part of our 2024 campaign was we issued an information sheet to those involved in these types of business models, so to the cold callers and lead generators, warning them about the potential unlicensed financial services they might be providing. So that was another aspect of it. But as I said, it's quite challenging because the models are different. Some are much more involved in the broader advice process than others.
Just on, there were freezing orders that were against the lead generator principles that were granted in February or March this year. Is that right?
The freezing.
Was there some sort of what was the order that was given in February, March this year that prevented more additional cold calling, or was there anything that was done there? I mean, sorry, I'm not explaining myself very well. Obviously, equity trustees raised some concerns about the cold callers back in about 2023, I think it was. And I want to know why it was that nothing was done about that cold calling until recently. And even then, what has been done is not a recommendation for policy change or some sort of emergency action, knowing that this is still going on. But instead, we're doing a sort of a community awareness campaign.
Senator, I might be able to assist you there, but so we've raised these issues with government for a while. As a result of the surveillance that Ms Shacker's referred to, there was enforcement action. Well, matters were referred to enforcement action. That enforcement action was taken. There's an aspect here in terms of it being whack-a-mole, so that the model changes because it's skirting around the law and our regulatory perimeter. So we need to look, for example, if the lead generator moves into personal or crosses that line into personal advice, it becomes unlawful if they're not licensed, which most lead generators are not licensed. So it requires us to look at each conversation individually, if that's available. So that is a very difficult and painstaking task to undertake. So I don't think your characterisation is correct to suggest that we did nothing. We did a lot in relation to calling generally. It has been a focus. I I guess what I'm wanting to convey is that there's an element here of whack-a-mole, which is when we take someone out, they just change the model and keep going.
So you pointed out, I thought very well, that there were an awful lot of, sort of structural gaps in this sort of sorry tale. We've got lead generators, we've got super switching hawking, we've got sort of weak oversight there, we've got losses in Shield and Guardian and Lion as well are now driving up the compensation scheme of last resort claims beyond Treasury's initial estimates, well beyond Treasury's initial estimates. And it's entirely unsustainable because it is only one component there, the financial advice sector, that is sustaining that compensation scheme of last resort, even though we've got platforms, investment providers, research houses, the auditors. We haven't even spoken about auditors yet. All of them involved in this process. It seems to be it's just the financial advisors who are kind of at the end of the chain here that are going to end up picking up the tab. And that's good financial advisors paying for the bad behaviour of a small few. I think it was 5 AFSLs, I think, did you say, that were involved in all of this? And that's out of 2,000 or so. I'm not entirely sure how many AFSLs out there now. But obviously that's going to be a problem. So I suppose what more could be done to, and I know you're doing some work with the platform and testing the laws as they are, but what more could be done, say, for instance, with the auditors, what could be done with the research houses that would make sure that this sort of sorry state of affairs doesn't happen again, and that all of the responsibility and blame doesn't fall to a small group of financial advisors that work in a sector which is, as you said earlier on, largely doing very good and important work.
Yeah. I might respond to some of those issues, Senator Hume, and let colleagues jump in if they want to. I think, though, I should just correct one premise in the question. The financial advisors here were not at the end of the chain. I very much appreciate the view that good financial advisors are at the end of the chain. But financial advisors and their firms were right in the very middle, unfortunately, of this chain. But for the financial advice received by these superannuation members, they would not have been moving their funds from, Fund A to these, very problematic Shield Master Fund and First Guardian.
I suppose, Ms. Court, just to clarify then, what I was saying was that the financial advisors wouldn't be able to give advice if the funds hadn't have existed in the first place, that they were poorly put together, that the oversight was probably inadequate of those funds, that the platforms didn't do their due diligence in putting them on, that the research houses clearly didn't do their job either, and neither did auditors. All of those things had to have been in place before the advice could even have been given.
Yes, as I said earlier, we are very much of the view, as you've just outlined, that there is culpability and misconduct in every link of this chain. I guess I just wanted to make the point that the financial advice firms that were involved in this model were remunerated very lucratively for the advice, the purported advice that was being given. But as I said earlier, I'm not trying to cast aspersions on that sector more broadly, and certainly we're very acutely conscious of the CSLR implications, potential implications that you've referred to, which is why we're doing everything we can to get money, back to investors from any of the links in the chain. In terms of where do we go from here, in terms of how do we prevent these issues from happening again? Look, I think our view on that, Senator, is there is no silver bullet solution here. In our observation, the growing pot of superannuation monies is attracting more and more dishonest brokers to find ways of getting their hands on those savings. And I think the scale of what we have seen in relation to these two funds, and as you say, there are others as well, is causing all of us, regulators and policymakers, to turn our minds to, well, how can we prevent this? And I think there are a range of potential policy responses. There's the front end with the lead generators, as we've talked about. There are, if I could say, loopholes in the anti-hawking laws that appear to have been quite deliberately taken advantage of here. So because these were solicited and not unsolicited contacts, then the anti-hawking laws don't apply. We've got the issue of the provision or potential provision of unlicensed advice by those lead generators. That's another thing that we have looked at closely over the years. But as Mr Savandra said, that is a case-by-case analysis. The only way to get to the heart of that is to look at the particular piece of advice given by one advisor to a particular superannuation member. That is extraordinarily difficult for us to grapple with. There's the duties on the platforms. What obligations are there on a platform, on a superannuation platform? As I mentioned in my evidence earlier, in our view, the superannuation trustees have failed in their due diligence. We've taken that action against equity trustees. We may win that, then those obligations will be clear. If we lose that case, it's being contested. That's another potential area then of law reform that may be required to make very clear what the obligations of platform providers are. So there are, and then Mr Longo's talked about the MIS issues and various policy options around there. So I think we have to recognise that there is not a single policy response, at least that we can think of or have thought of at the moment, that will fix these things. And, one of the most extraordinary things I have found since being at ASIC is, there are bad players out there that are determined to get access and to people's funds, whether they be superannuation or other investments. And we see that day in and day out, people that are investing their money in various schemes, either knowingly or unknowingly, and losing, their life savings. So these are life-changing, catastrophic issues for the individuals involved. We are devoting enormous numbers of resources at the front end to try to educate people, be wary, be sceptical, ask questions, get independent advice, just hang up. We've devoted enormous resources into that, and then at the back end we're devoting enormous resources into freezing funds, trying to make sure there are assets there to come back to investors and hold people to account. But I'd be lying if I said to you there is a simple solution to the intense, and as we keep saying, industrial scale misconduct we've seen across this sector.
I've only got one more question, Chair. Yeah, thank you. Which is, and it touches on an issue that you have raised now, which is MIS reform. Obviously, there is a review underway, and ASIC have made a submission on that. I'm wondering if you've had any indication that the government is going to act on your submission to the 2023 review of managed investment schemes.
I'm not aware of what the next steps might be with MIS reform. We've certainly, these issues are obviously getting a lot of attention at the moment for all the reasons that we're talking about today. The MIS reform, of course, has been in the air for a long time, and all I would say about it, it really is time for Parliament to take a fresh look at the whole regime. I think there are some fundamental issues with it in terms of its permissiveness, how easy it is to set one up and to have it registered, the insolvency regime or failure regime around MISs isn't fit for purpose, which isn't good for investors when things do go wrong. So I think there's some reasonable minds will differ as to what might need to change or what might need not to change, but my view is that there does need to be change there, and we look forward to helping Government and Treasury figure that out. Yeah.
Okay, I'll leave it there. Thanks, Chair.
Thank you very much, Senator Hume. I'll go now to Senator Pocock.
Thank you, Chair. I wanted to go back to comments you made, Chair Longo, right at the beginning about the cost of complex investigations, and clearly you are doing more of them with more success, which is fantastic. Can you give us any estimate, and you may want to take it on notice, of what the ANZ investigation has cost?
might have some data on that. Do we have that to hand?
I don't have that to hand.
So maybe on notice that would be great to know.
It's more than one investigation too.
Yes.
It's 4 matters. There were several internal teams. We instructed different external counsel teams to assist with each matter. So we're happy to take that on notice.
Do you ever raise with people who you make the kind of agreement that you have now with ANZ the question of costs, that they make a contribution to the costs that have been incurred by your organisation, by the public sector?
Yes, well, we routinely seek our costs.
So and did you in this case of ANZ?
Yes, indeed. Yeah. And there's 2 ways that costs make their way back to the to consolidated revenue, Senator. One is through litigation costs, so those are either agreed by the parties or taxed by the court, and then the other is that ASIC has and regularly does make, it's called an order, even though it comes from ASIC under Section 91 of the ASIC Act, I think it is, for firms to also pay our investigation costs. So we routinely recover significant amounts of money.
And could you give us those in relation to the ANZ case?
I can. I don't, as I say, I don't have them off the top of my head.
Thank you. I wouldn't expect you to have all of that in your head. But I wanted to go to the $240 million payment. ANZ has admitted, as I understand it, the unconscionable conduct, that it manipulated the bond event for gain, overcharged interest, charged dead people and their families, failed to help people in serious, extreme hardship, and ignored its own policies over a lengthy period of time. So very significant, and you have told us that this is the largest fine of its kind, largest agreement of its kind that you've had. Have you considered, and are available to you, any other instruments? For example, some jurisdictions have a debarment regime that has become relevant in relation to PwC, and it's recommended by the OECD. The UK have one, Canada, that where someone breaches ethical standards, they are debarred from doing business with a government. Have you any instruments of that kind available to you in relation to ANZ as a contractor to, or business, someone who does business with the government?
ASIC doesn't, although I note, I think this is public knowledge, since this incident in April 2023, I don't think ANZ have been approached by AOFM to provide any services. So that's a matter, obviously, for government and AOFM.
Yes.
But ASIC itself doesn't have that kind of power. Yeah.
Any formal power. Yeah. Would you consider making advice to the government about such power? Because when I consider the PwC breach, they made $2.5 million by monetising confidential information. ANZ have made a very much larger amount of money, potentially, which is reflected in the $240 million payment. A much larger scale over a much longer period of time, possibly, but no redress in relation to government contracting or so on. What's your view about the need for such an arrangement in relation to services to government?
Well, that's really a matter for government. I mean, the government itself, of all entities, can make its own procurement decisions. So, if I may say so, don't have to wait for ASIC to tell government not to do business with ANZ in connection with a bond issuance. It's AOFM are a sophisticated player; they will make that decision for themselves.
And they're clearly making it's reflected.
But if we're talking about a major bank, our approach, we really don't put those kinds of constraints. It's true that we license the banks, and in theory there might be some potential for conditions on their licence as to what kinds of business they might do, but that's not really an avenue that I think is very feasible.
But someone who's been burned once over some time might consider it themselves as a government, and clearly that it might affect the way they contract, and is perhaps already, we can see. I wanted to go to the figure of $240 million. How was that arrived at? To what extent do ANZ's deep pockets in relation to legal matters, how influential was that in your thinking? how much weight did you give to the avoidance of a long legal fight? What particular issues helped you arrive at 240 million?
Senator, I can answer some of that, and then Mr Longo and Mr Savandra could jump in. So the issue of penalty I would describe as is an art, not a science, and it's important to recognise that ASIC doesn't impose penalties. The federal court imposes penalties, and these, we just have to be very cautious in talking about the figure in the sense that this is a figure ASIC is of the view is appropriate in relation to the misconduct, and the court will form its own view in relation to that. In relation to the makeup of the $240 million, there were 4 separate matters, as Mr Longo has outlined, the first of which relates to the trading of ANZ in relation to the $14 billion bond deal. The $80 million penalty in relation to that, as I said earlier, if the court were to impose it, would be a record penalty for unconscionable conduct against a major financial institution in matters taken by ASIC. There was a secondary element to the markets-related matter, which, and again we've talked about this already this morning, and that was that ANZ misled the government over a nearly 2-year period in relation to the reporting of its bond trading data, and there was a $40 million penalty that is proposed in relation to that. There's a separate $5 million component as well. So the accumulated amount that we propose to put to the court in relation to that market conduct is $125 million. There are then 3 separate customer-related or retail matters, and I think, again, we've touched on these briefly, perhaps not in the same detail this morning. I think I mentioned earlier they go to, very fundamental or basic banking requirements, failure to get the interest rates right, failure to deal with hardship applications on time and charging and failing to refund fees charged to deceased estates. The breakdown of penalty proposed in relation to each of those separate matters is $40 million in relation to the hardship contraventions, $40 million in relation to the interest rates, and $35 million in relation to the failure to refund the fees charged to deceased estates. ANZ's deep pockets, I think you framed the question through that prism, have absolutely nothing to do with the decision that ASIC has made here. We had a number of investigations underway. We gathered extensive evidence. We briefed experts. We have external counsel involved, and we formed the view that these were the facts that ASIC could make out in its case, and these were the contraventions of our laws that we felt that ANZ had broken in relation to each of those matters, the most significant of which, and it's a very significant finding, that ANZ had engaged in unconscionable conduct, and that's conduct contrary to conscience, with the victim of it being, as you've alluded to, the Australian government. It's extremely serious misconduct, and it's an extremely serious penalty that we're seeking imposed in relation to it. ANZ elected to admit these contraventions. It was completely up to ANZ as to whether it sought to contest these matters or admit them. Ultimately, it has elected to admit them, and that's the documents that are now, before the court for consideration and determination in relation to penalty.
Did you take the figure of 240 million to ANZ once, or were there a series of conversations in relation to that figure?
I can't comment on without prejudice negotiations. I can't do it.
Because?
Because they're all subject to confidentiality. If the committee wanted a breakdown or more information about what are, legally protected communications, we'd have to go into a closed session. And I'm not trying to be difficult, but these things are. We have to be very careful about these if we need to make sure that other parties that might want to admit to matters are not dissuaded from doing so through public evidence. But very happy to talk to you separately.
Very similar evidence from the ATO. Perhaps we can come back to that in camera if we have an opportunity. Did you meet Chair Longo, with Mr Nuno Matias in this process?
I met him, it was an introductory meeting about a month ago, I think. I was introduced to him.
And did you discuss this at that
It was a
meeting?
high-level meet and greet discussion about a month ago.
And did it include discussion of this settlement?
It certainly, we didn't discuss the details of any proposed resolution of this matter. Sort of picking up on a theme the Deputy Chair Court was describing, at a meeting like that, I don't go into a meeting like that to have that kind of discussion. That meeting was for the purpose of meeting Mr Matos and for him to meet me and to have a sort of our first, because I meet with the CEOs and chairs of all the major banks regularly, and it was my first meeting of that nature. Mm-hmm. That would not have been the right forum to conduct anything remotely like a discussion or a negotiation that led to the result that we announced on Monday. Having said that, I did signal that I thought that situation was extremely serious and that he should expect a resolution. When I say resolution, I mean the commencement of proceedings to be imminent, but that's as far as we went.
And you are not willing or in a position to discuss the nature of the figures of discussion. Are you able to give us an indication of the period of time in which discussions around that specific figure went back and forward?
Want to give a period? Or?
I can't give that to you off the top of my head, Senator, I'm sorry.
But it was a period of time, it wasn't a single event.
Yeah, I just would have to take that on notice, Senator, my apologies.
The fine you've pointed out, Ms Court, is the largest of its kind, or I should say the agreement, yet to be ratified by the Federal Court or amended. Yes. But you could have gone further with a larger fine. What's the maximum fine you could, maximum figure that might have been settled on?
Well, again, Senator, there are maximum penalties in the legislation that would likely be in the billions of dollars. Mm-hmm. And often with these kinds of matters, we find that the maximum penalties are not particularly helpful because they are so high as to be, so high such that they clearly signal Parliament's concerns about the nature of the conduct. But when there are multiple potential contraventions, it turns the maximum into such a theoretical that it's not particularly helpful. But certainly, if you look at the statute books for these combined contraventions, it would have been many billions of dollars maximum, even more potentially.
Okay. I'm just looking, I think there's a provision since 2019, a civil penalty could have been set at 10% of ANZ's annual turnover, currently capped at $825 million per contravention.
That's right.
I understand that's the case. So it could have been a much higher fine and a higher amount settled on. And from your earlier evidence, you're watching, ASIC is watching to see that the disincentive effect actually takes root. But in the future, you have access to a much larger fine should misbehaviour continue or be repeated. Is that a fair statement?
I think it's fair to say, again, sorry if I'm being repetitive, but we don't set the fines, we put them before the court.
Thank you.
And the court will ultimately make a decision. So yes, Senator, should there be another matter that we investigate, get evidence and go to the federal court, we can submit penalties of any amount to the federal court, and any respondent to that matter can put on their own evidence and refute that. And so the court will ultimately determine that. Now, we frequently go to the court and put penalties of certain amounts, and the court frequently says, the judge frequently forms a view that he or she is not going to impose a penalty of that amount. So when a matter is when a party, like in this matter, has consented to, or admitted is perhaps a better way, admitted the contraventions alleged, I think there can potentially be a temptation to assume that those facts, as agreed, would have been found by a judge in a contested hearing. That is frequently not the case. So often when we go to matters and we contest them, and I could sort of find probably some recent examples with a few moments, you know, ASIC will put a particular position with a particular penalty. The other side will contest that. They'll put on their own evidence, bring their own experts and argue their own case. And the judge has to make that determination. It often takes many years to go through that system, and we have an uncertain result and often a reasonably low penalty, I'm sorry to say, quite frequently. So, yes, in another matter we could absolutely investigate, get the evidence, go to court and submit for a high penalty. But as I say, that combined penalty of $240 million is significantly higher, very significantly higher than anything the court has imposed.
It's lengthy though.
On a single entity. Sorry, if the court imposes it, will be, you know, by far the highest penalty that a court has imposed against a single entity for this kind of conduct.
And Senator, if I could just add, we certainly as an agency are pushing for higher penalties where we can, but ultimately we need to act as a model litigant, so we cannot just go to the court and say impose the maximum. It needs to be reasonable, having regard to the legal principles that apply to setting and imposing a penalty. I think the question was also asked about deep pockets or the size and financial resources, and that is a relevant consideration which we certainly take into account.
Thank you. I want to go to the question of individual responsibility, and that's had some discussion here this morning. You haven't gone in pursuit of any single individual, and if I read your evidence, Mr Longo, correctly, you are very uncomfortable personally with going after individuals for the reason, as you've put it, I think, it's hard to attribute action to individuals within a corporate context. However, after the Royal Commission, the power was established through the financial accountability regime, the FAR regime, was it not, to particularly, in light of that, the years of evidence considered in that Royal Commission, for the necessity for going after individuals who behave unconscionably. And when we look at ANZ, for example, we look at some, I understand Mr Paul O'Sullivan, for example, was a director for the entire time 2019 onwards, chairman of the board from 2020 onwards, still there. Mr Shane Elliott was CEO the whole time, 2016 through to 2025. Mal Carnegie was CEO at the retail division, where the customers were defrauded from 2022 to last year, retired last year with a massive bonus, $900,000 and a $2.4 million salary, I understand. Now, you're not comfortable, but the FAR Act, as I understand it, please tell me if I understand this wrongly, it gives you the function of actually knowing who is responsible along the chain of command. The FAR Act requires lines of responsibility to be stipulated in the accountability map, which is detailed in section 34 of the Act and within the accountability statement for each accountable person as described in sections 31 and 33. And that includes details of these reporting and responsibility lines for all accountable persons and their entities, and they're responsible for articulating their specific areas of responsibility. And you have joint carriage, I understand, Mr Longo, with APRA to take steps against individuals and to disqualify people where they are clearly trackable in their behaviour. But you choose, and you made it clear on 7:30 report last week, that you didn't want to do that. I am really concerned about that. I'm worried about us having to repeat the experience at great cost to individuals and their families and their bank balances and the public sector purse. This Act was passed to deal with exactly this kind of circumstance, and it hasn't been used. Why is that?
Well, a couple of points. I just want to make clear to the committee, it's not what I personally want or personally would like to do.
No, it's your legal obligation.
It's what I can do within, as a part of a regulator within the operation of law. A lot's been said about FAR. It was Before FAR, there was something called BEAR, the Banking Executive Accountability Regime, and then that was replaced by FAR, the Financial Accountability Regime. And the thinking behind that particular legislation was to help formally clarify what the accountabilities were within one of these entities, because historically there was the policy underlying this legislation was we really want these institutions to be clear about who's responsible for what, so that we can regulate more effectively, which is, with respect to exactly the point you were making. Now, within those accountabilities, I think our ultimate remedy is banning, was banning, and that's it. We can't impose a civil penalty or anything like that against the individuals. Now, that legislation remains a little untested, to be frank. We are using it in a number of respects, and I think it'll be interesting to see whether we'll be able to take real action under that legislation over the next year or two. It's relatively new. Now, putting that to one side, I think what I want to be clear about is that with serious corporate misconduct, it's often the case that there are many present and former employees tied up in that. And so it's not so easy to point to one or two individuals to say, well, the reason that trading went so wrong is because the chair of that entity wasn't there that morning overseeing what was going on. That's not going to work. So in the end, the corporate misconduct that we're often grappling with is the cumulative effect of things going wrong and wrong decisions and choices being made by many people over a period of time. That's in the nature of corporate responsibility.
Do you see
issues.
that as a board responsibility?
Yeah.
The Royal Commission talked about culture in ANZ. We're back here at culture in ANZ. Mr. Tom Seymour recently was...
It may be frustrating, but there's no way ASIC could have sued the whole board, present and former of ANZ, for the failures of that morning on the 23rd of April. The law simply doesn't work that way.
So when is it appropriate to use the powers that the Parliament has put on you to determine individual responsibility? When is the threshold?
Well, there are a range of areas where the Deputy Chair Court this morning mentioned one of them. If the responsibility, knowing involvement or engagement in particular wrongdoing, and the High Court has laid down the test in this in a number of cases, if we can establish that, then from time to time we will pursue senior executives or individuals if they've been knowingly concerned or involved in the misconduct of the corporation. But establishing that to the appropriate legal standard is a high bar. Secondly, perhaps on notice we can brief the committee. It's not as if we don't sue individuals at all. No. In a proper case, when I say a proper case, in a case where we think there's been corporate misconduct and we're able to sheet home a liability personally to one or more directors, then we will do that. But these are... I really appreciate the frustration from a broader perspective to say, well, this awful thing has happened in the corporation. You know, why aren't we holding more people accountable? Well, one has to approach that issue objectively within the existing legal framework.
Some of us at this table have had that painful experience in relation to PwC, where the little organisation of the Tax Practitioners Board did withdraw the opportunity to operate as a tax agent for two individuals in relation to acts in one case and culture essentially in the other. I just want to say how disappointing it is that we don't see that more assertively applied by you as the leader. And do you have at present any consideration of individuals in ANZ in light of these long years of misconduct?
That's the last question.
Chris, do you want to say something?
Senator, I respectfully take issue with that we don't assertively pursue individuals. We are absolutely
just my opinion.
Looking to pursue individuals. It's the most effective form of deterrence where we can pursue individuals. The issue of attribution of responsibility for corporate conduct to individuals is a vexed legal issue. It's not unique to Australia. It's a similar issue around the world. The Australian Law Reform Commission did an inquiry into corporate attribution in 2019. It's a difficult and complex issue. As Deputy Chair Court and Chair Longo said, under the law we administer, it's Section 79 of the Corporations Act, and it requires aiding, abetting, being involved in, knowingly concerned, various legal requirements, and it's easier when there is an individual who does an act as opposed to a collective group of individuals who each do part of an act. So that's a difficult problem to solve legally. Just on the FAR, just to be clear, that the obligation there is to make individuals within insurance companies, banks, accountable broadly for systems. So the accountable person must conduct their responsibilities by acting with honesty, integrity, due skill and care and diligence. And then there's this concept of taking reasonable steps to prevent matters from occurring. So it's the reasonable steps. So many times we see people, and as Chair Longo said, the FAR regime is new. It came in March 2024, but that will be challenging to enforce because many accountable executives will be able to show or point to reasonable steps. So just because the legal entity or the corporation contravenes the law does not give rise to an automatic liability for the accountable person under the FAR legislation.
I just wonder if I could get an answer to my question, though, which was, do you have under consideration any individuals in ANZ in relation to the FAR regime?
Well, the specific answer to that question is ANZ have themselves announced a remediation program. I'm not sure what they've called it, but it's very extensive. It's across the bank, and that program is very grateful to Mr. Savundra for reminding me of the test. Will be overseen by senior executives, and so the we will certainly be looking with the FAR-like lens, if that's a good way of putting it, to how that goes over the next 6 to 12 months, because that remediation program is across the bank, and the way it works is senior executives are going to be held responsible for delivering that program on behalf of the bank and dealing with the various issues that our investigation unearthed. And if they don't discharge their responsibilities, I won't try to repeat what Mr. Savundra said, then there may very well be consequences under FAR.
Thank you. Thanks so much for your answer.
Thank you. And we've run 10 minutes longer there,
right.
just so you know, we're following the line of questioning. I'm going to come very shortly to Ms Lawrence, but can I just ask a quick follow-up on your meeting with Mr Nuno Matos? Had you had discussions of these ANZ matters, these 4 ANZ matters with the previous CEO directly?
No.
So, can you explain to me why this occurred with Mr Matos? Was it at your request or was it at his?
Perhaps there's a misapprehension, but what I was trying to say earlier, I did not have a substantive discussion with Mr Matos about resolving these matters that were the subject of proceedings and announcement earlier in the week. My meeting with Mr Matos was more of a high-level meet and greet, if I could put it that way. As I said earlier, I have regular meetings, including with Mr Elliott, when he was CEO, with all the CEOs and chairs of the banks once or twice a year. And I don't remember having any direct discussion with Mr Elliott about resolving this matter. That, as I said earlier, a matter of this complexity and significance within the Commission, we have very strict governance around conversations with an entity that we're investigating, and I personally would not conduct that without appropriate internal governance. So, with the ANZ situation, those discussions were led quite independently of me. I mean, obviously I signed off, as did the other commissioners, on the ultimate result, but it's very important not to mix what the ASIC's doing with the enforcement. It needs to be very objective and very independent.
Okay, so you did indicate that you had regular conversations with the former CEO, Mr. Shane Elliott.
I'd say once or twice a year.
Okay.
Yeah.
So, and if I heard you correctly, you did not have a conversation with him about these 4 matters?
No.
You allowed that to your team? Who
Well,
from your
at that
team?
stage, the last time I met with or spoke with Mr. Elliott, I'd have to check my calendar, but sometime last year.
So if you could take on notice who from your team, if you were not having the conversation, had conversations with Mr. Elliott, and what changed with the, meet and greet moment with Mr. Matos that has led to what you would say a rather fast movement to resolution, or was that already in train?
I think there might still be a misapprehension between us as to the history here. I meet with the chairs and CEOs of the major banks once or twice a year.
Yes.
I'd have to check my diary as to whether I met with Mr. Elliott this year or whether it was late last year. But those meetings tend to be very high-level relationship meetings. Where
I understand.
Yeah.
The question is, was the topic raised?
And
did
so with
you
neither
advance
Mr. Elliott nor Mr. Matos did I have any substantive conversation about the resolution of these matters that were the subject of an announcement on Monday.
I understand that. But as a consequence of your non-depth conversation, something has given in the period, it seems quite recently.
Well,
since Mr. Matos has assumed leadership, is that correct?
I may need some help here, but as far as the trading matter goes, that had been under investigation for nearly 2 years. The other matters were under investigation for whatever period, and there were all sorts of interactions between ASIC and ANZ of an information gathering nature,
is there
Section
someone at the
19
table
examination.
who was leading?
All of that's going on as part of our normal enforcement work.
Is there someone at the table who was leading that interaction?
Well, as Chris Savundra's head of enforcement oversaw and a lot of that, as did the other Calissa Aldridge. But there's a governance structure within ASIC that oversees these investigations and then report up to the Commission.
So let me just go back to my question. Who was having the conversations with the relevant CEOs about these matters? Whether it was Mr. Elliott or Mr. Matos. Is it you, Mr. Savundra?
No, Senator, and I don't think the conversations were had with the CEOs. So it would have been through the legal teams.
So what changed?
I'm not sure what you're referring to, Senator.
Well, the matter was set to go to court, apparently. That's the direction in which you were heading. And then something's changed.
The history of this matter is actually pretty straightforward. From that perspective, there were a number of investigations and they were reaching their conclusion. And that conclusion in this case was 4 sets of proceedings, which ANZ well knew through its lawyers were coming its way. And the ANZ decided to engage with us in a way which led to the outcome on Monday.
Was that before or after the arrival of Mr. Matos? Sorry, Mr. Longo, I just want to get the clarity on here. Was that before or after the arrival of Mr. Matos? The
arrival of Mr. Matos was. I just don't see that as entirely relevant here. We would have engaged with those discussions, whoever was in. I suppose the gist of this question is: are you saying that that ANZ would not have made these admissions but for the arrival of a new CEO?
I'm unclear. You've got a better visibility.
Well,
that's my question.
I'm not sure we can comment on that.
Yeah, so I think we'd be speculating. I think it's fair to say we were getting close to being in a position, and ANZ knew we were in a position to commence the action on the markets matter, and the conversation continued from there.
And what dates are you talking about?
We'll need to take that on notice. From memory, I can't remember when the current CEO commenced.
Okay. After your meeting with Mr. Matos, was there follow-up correspondence directly with you, Chair Longo?
About this matter?
About this matter?
No.
Was there follow-up correspondence with ASIC about this matter initiated by Mr. Matos or initiated by ASIC?
We'd have to take that on notice, Senator. Yeah. I think there's, and I guess just to respond to one of your other questions about what changed, these are court outcomes. Documents are filed in the court. The only thing that changed is that ANZ chose to admit the allegations that ASIC made. So we had done a series of investigations over a significant period of time. Those investigations were coming to conclusion. Court documents are being prepared. We're working out, as I gave evidence about earlier, what are the contraventions, where do we think the law's been broken, and if ANZ elects to admit to those contraventions, the documents are in the court. Just to be clear, this is the institution of civil penalty proceedings, 4 sets of them by ASIC against ANZ. ANZ has elected to admit those contraventions.
Thank you. And I think the language you used, their decision to admit, is actually a critical moment.
Yes.
Perhaps that's the moment.
Yep.
Perhaps if you can't identify that.
But that's an issue for ANZ, Senator.
Okay. Thank you very much. We might end up going in camera at some point of time, but I'll go now to Ms Lawrence and then I'll come to you, Mr Violi.
Thank you. Look, I think you can well appreciate that we are very much trying to understand how individuals can be held to account for actions of the broader corporation. And I think you've expressed, you understand the frustration. But frankly, my constituents are saying it's just not good enough because we're seeing just case after case after case in different contexts, be it those super funds doing the greenwashing, we're hearing about Shield. Like there's so many different examples where there are issues across the financial sector and the trust that people then have with their own money being used by others inappropriately. So I just need to go a little further. So we understand that ASIC can ban someone from acting as a company director if they've been involved in serious misconduct. Has anyone been banned from being a company director in relation to any of the matters we've been discussing today? So we've had from Shield, you've got people, Paul Chiodo, Brett Spork, Ferris Mary, have they all been now banned?
Senator, in relation to Shield, there are multiple individuals that both have been and are being held to account. I think I gave some evidence earlier about the number of a number of financial advisors that have been banned as a result of their involvement here. There have been financial...
Those 3 people that I just named, have they been banned?
Certainly we have been in court against all of those individuals, I think I'm right to say, and I can correct the record if I'm wrong, in relation to travel restraint orders, freezing the assets of them personally and of their businesses, and investigations are clearly ongoing. And if I could just give you some reassurance, we are absolutely committed to holding large numbers of individuals to account for what has gone on in relation to Shield and the First Guardian matters. We have...
But is it just, so I'm clear, so is it just that because the investigation's ongoing, they've yet to be banned so they can continue operating and in the financial services sector, they can continue operating as a company director as of today?
I don't think that any of those 3 individuals that you've mentioned are able to continue in the financial services sector as we speak at the moment, but I will just, for a range of different reasons.
But not because of the powers that you have available to you in terms of the company directors?
No, absolutely because of the powers that we have available to us and the various actions that we have.
But not specifically as a company directors under the Corporations Act for company directors, it's other tools.
That's right, and I can get the details for you.
But not under the corporate. Okay, no worries.
On all of those.
And then what about in the context, like if we just wind back to 2018, when ASIC, and I appreciate this may predate many of you there, but where ASIC then had evidence that Shane Elliott, the now dumped CEO of ANZ, and other senior managers were in fact involved in the rate rigging scandal, where on 10 occasions between 2010 and 2012 there were manipulations of the bank bill swap rate. ASIC then of course fined ANZ $50 million for that. Now, we know from the discussions we've had today that there wasn't any pursuit of individuals. In that context, we know that there are of 7 people involved who were sacked by ANZ, but I don't know whether they've continued in any of these other enterprises or in any other business related to financial services. And perhaps if you do know, you could perhaps put that take it as a question on notice. But I just am curious, like if we had, this was say 2018, and we were having this exact same conversation, that we were looking to see individuals that were involved in that market manipulation, which is obviously a bit different to the things that have been considered today around unconscionable conduct. But if Shane Elliott had been held account then, what would be the discussion we would be having today? Because there was no consequences for him. He just took home yet more millions of dollars. In my understanding, he's left the ANZ, and I know they're trying to claw some money back now, but with some $70 million odd in bonuses. So he has personally profited, but equally the shareholders and others benefited from over that extensive period of time from this unconscionable conduct and predating that market manipulation. So, where is the consequences for someone like him? And then people who fall beneath him, there are people on the record in your documents, I think one of the named persons for the most recent conduct, Rakesh Jampala, is he able to continue working in the financial services sector? Is Shane Elliott allowed to continue to work in the financial services sector?
As far as I'm aware, yes.
And is that because I just want to just
just
a moment, Chair. I just want to read this. Because this really gets to the heart of it, right? ASIC has taken action against ANZ 11 times in just over a decade. We've been there before with ANZ. The bank has a history of non-compliance in market matters for misconduct in foreign exchange, continuous disclosure and the bank swap rate matter. Clearly there are fundamental issues with ANZ's risk and compliance culture that requires the board's and executives' urgent attention. And then this is, of course, a quote from your statement the other day. You then continue to say, collectively, the misconduct in retail matters occurred over many years and in our view is marked by ANZ's significant failures to manage its non-financial risk to the bank. And a third matter of most sensitive circumstances, the handling of deceased estates. ANZ failed to refund fees charged to thousands of customers who had died, failed to respond to their grieving families. These failures by ANZ likely made a difficult time even tougher. Now, I can't go back to my constituents who've been affected by all of that activity and say there has been zero consequence for those involved, for the suffering, the hardship that's caused you, the financial loss that you've incurred, be it as your shareholder or a person who's been directly impacted by not having interest paid on their accounts. We just need to kind of explain to my constituents why Shane Elliott and all the other people that we've been discussing today are not accountable. What's the consequence? Not even to be not able to practice in financial services, like not even that?
The way our system works, the way our law works, as it's currently in the legislation Parliament has passed, and the way the courts enforce and interpret that legislation, holding individuals accountable for the kind of misconduct that you very rightly described is unacceptable is very difficult. And so to hold people personally, to be able to ban individuals, stop them from earning a living for the rest of their lives, throw them in jail,
no one's suggesting that. We just don't want them involved in the financial services sector.
In some way that is tangible to the community requires a high bar of evidence and wrongdoing. So I know it's very frustrating.
Yeah, but now we're talking about a new problem with 15,000 people affected.
We'll just have one voice at a time. Yeah. So finish your answer, Mr Longo, and then I'll come back to you.
As Mr Savandras noted, the whole question of holding individuals accountable in some tangible way, whether it's going to jail or banning them from life, from earning a living in financial services or never being a director again, those kinds of outcomes tied to significant misconduct in a major corporation where there are hundreds of individuals over time who've contributed to the problem, whether through leadership failure or cultural failure, that our system does not make it easy to do that. And I know it's coming out of the global financial crisis, the books have been written about this, that you can count on your hand the number of bankers that went to jail coming out of the GFC.
So
I'm just saying. So that's in the US, the UK, and Australia.
I'm just trying to understand what is the gap that we're missing, because
Hold on,
earlier...
Ms Lawrence. Everybody's very excited about this. But if you can keep your answers short, Mr Longo, I'll give the call to Ms Lawrence for another question.
Thanks. Because earlier you did say, and I appreciate it's early days, but that the financial accountability regime, the FAR, to quote you if I may, is to sheet home responsibility to executives. So what does that then look like, given you've just put all the caveats around it?
As far as FAR goes, I'm really grateful to Mr Savundra for reminding us of how that scheme works. If the senior executive can show, remember these entities are huge. There are thousands and thousands of people that a senior executive might be held responsible for their activity, for that part of the business of the bank. What FAR does is make it clear what their accountability is, which part of the bank's business are they responsible for dealing with. And secondly, they're held responsible if things are gone wrong, but only if they haven't taken reasonable steps. So if they've taken reasonable steps to make sure everyone's doing the right thing in their institution, then that's it. You can't be taking people off, terminating their employment if they've taken reasonable steps under this legislation. Now, if we want to hold people responsible for what goes wrong in their corporation that's not fault-based, and we say, well, you know what, if you're running a business and things go wrong, whether you did anything wrong or not, you're out. That's not how our law works.
So, Chair Longo, there have been a number of people that have signed off on an NDA and have exited ANZ, for example. Have you undertaken any investigation as to what those NDAs say in terms of what their role was, as to why they were dismissed and what the terms of their departure looks like? Because it seems like ANZ were able to identify individuals involved, have taken a course of action, which included seeing the CEO off. So were you able to look into those NDAs to get us a line of sight
That's
as
a different
to,
discussion with respect.
Except that it may have some of the details that you're saying you can't get visibility to, because these people are earning millions of dollars in salary and bonuses, and their JDF says that's what they're accountable for. But you're saying, oh, but they may not have had the accountability.
Now, what I'm saying
is
is my job to apply the law as it is. ANZ as an employer, can attach consequence management to the misconduct of its employees if it's in breach of their contracts of employment or the policies and procedures of that institution. So that is a very common activity. I've no doubt ANZ may have very well, as they said publicly, had consequence management for all the individuals, bonus cuts, their employment may have been terminated. That's a matter between ANZ and its employees. ASIC's job is to make decisions about those kinds of misconduct that we think warrant investigation and court action. Now, as far as holding individuals accountable, it is a long-running frustration of the general community that they see things going wrong in major corporations, and there's a belief or a sentiment that that individuals aren't being, they're not enough number of individuals are held accountable. And my response to that is that it's difficult. It depends. It's very fact sensitive as to whether or not a court will ban a director, as to whether or not a penalty will be imposed on a company, and whether or not a director should be held accountable personally for the corporate misconduct. Now, I know it's frustrating, but we do have a track record of going after directors. Just recently, there have been a major trial for the former Star directors. There are other matters that are ongoing in the courts. So we don't shy away from commencing proceedings against senior executives or directors, but we've got to have the evidence, and the law has to support us before we take that action.
And in terms of the law, that's where we possibly could help. What are the limitations that you think the Parliament should give consideration to ensure that you have sufficient powers available to you to be able to do that job?
Well, I think some of these issues are of a philosophical nature. It's what I said a moment ago. In our standards in Australia, we don't lightly ban people from their employment. We don't lightly send them to jail. We don't lightly impose penalties on them or ruin their reputations. It's just not how it works. The way it works is we're held to pretty high standards, whether it's civil or criminal, to establish the facts and to establish the wrongdoing and the accountability. And so So if something goes wrong at a major corporation, the emotional reaction is fire everybody. Let's fire the board, let's fire all the senior executives and replace everybody. That is not how we do business in Australia. It's not how we do business.
No, I just want to make sure that people who have been directly involved in this case, in unconscionable, grubby conduct, misleading, deceptive conduct, don't get to operate tomorrow and do more of the same, putting more people, exposing more people to loss and harm. And it doesn't sound to me like we've been able to reassure people that that's going to happen.
I wonder, Ms Lawrence, if I could just intervene for a moment. As Mr Longo said, we understand the questions and the frustrations, whether we might come back to the committee with something in writing as to the various laws that we have in relation to individual accountability, the various challenges that we face in relation to those, and also give some thought to whether there would be any changes, legislative or otherwise, that we could, talk to the committee about going forward. Because, I mean, it is we hear your frustration. It's a frustration that we have around the commission table on a regular basis as well. Just to reassure you, one of the first questions we ask is about what about the individuals who's been involved here, and we have extensive examination powers, as you probably know. So one of the big parts of an investigation for us is issuing notices to individuals that we think are involved in the conduct and bringing them in, often for days, to ask them questions, put documents to them, challenge them, try to really get to the heart of their understanding, trying to prove that knowing involvement point that Mr Savandra was making earlier. I should also make the point that we also, of course, get legal advice on all of these issues. So we have external counsel. We, frequently, and I'm not talking about any particular case now, but I'm, I guess, to some extent trying to reassure the committee that the idea of individual accountability and responsibility is something that we take very seriously. We frequently get legal advice and ask for counsel's views on whether or not there's a case that we can make out under the current law. So if it's of assistance to the committee, we'd be very happy to put some thought into that, and so that we can, set it out much more clearly in terms of our answers.
I think that would be helpful, Ms Court, because there is this growing sense of frustration that you can just rip people off and walk away with the money. And that's not palatable to Australians whose hearts break when they hear stories about, their mate down the road who's just lost, their lost their retirement or investment, etc. This reminds me of a conversation we've had many times about auditors and my concern about the capacity to continue to do harm after having proven that you are a harmful person in a particular context. And this is about registration, and it's come up in the F&PA committee as well, around what is a professional, which is a fundamentally ethical description of behaviours where a person in an asymmetrical relationship has sufficient power to inflict harm on another, but chooses to adhere to professional standards, rules and regulations, and to act in the best interest of the person that they're supposed to be providing advice or service to in the case of a bank. Now, there is no profession for bankers. There is no professional association for a banker to belong to, which I wish it would give me comfort to suggest that we should have one. But we have a professional association for auditors, and we found that that has not, similarly, has not held individuals to account. But there is the point, I think, that Senator Pocock made about the TPB's response to Mr Tom Seymour and their investigations continuing to others, I believe, at PwC. Mr Tom Seymour has actually been pinged by the TPB for a failure of leadership. A failure of leadership, right? Which is not a technical description of how far or reasonableness. There's a leadership failure. If you get the big bucks and you're right up there at the top, there has to be some skin in the game for you. Don't be a leader if you can't act ethically is the baseline for me. But that this is a fundamental structural problem that doesn't seem to have, borne enough policy consideration or academic consideration, even in our context, about how the Australian people's sense of fairness can be exercised in a way that accedes to a decent rule of law application that meets community expectation. So if you can take all of that on board, because we've seen it in multiple perspectives now, and it's becoming more and more clear that, ride to the top, say you've acted reasonably, walk away with 70 million. There's a problem there. So we look forward to your response. I hope that captures the general sentiment. If there's anybody who wants to add in something else.
Just one little more to your briefing note, perhaps, because Chair Longo did reference about the director's liabilities, and I appreciate where the director has confirmed awareness of facts constituting wrongdoing a risk. I think that's quite tangible. But there is also the ought to have known. And we know that the board clearly didn't ask the right questions, and let's just leave it at the positive. But I think where they may not have that actual knowledge, but they're in the position to access the information by carrying out their full duties, I think is also something we've really got to start underscoring, because I think it's a little too easy to say, oh, we're too removed from it, when in fact not only were these same people seeing the profits coming through, but they were rewarding people with bonuses, signing that off as well, based on the actions happening. Yep. All the while these investigations were occurring, no less, which is somewhat galling and troubling that sat comfortably with them to be doing both things, because it's sort of rewarding the very behaviour that you're trying to call out as wrong. So I think we just need to go a little bit harder on the expectations of directors, and they do get paid very handsomely for sitting on their board, X number of times a year, and there needs to be some responsibility to that and accountability.
Ms. Court. I was just going to say briefly, the matter that Mr Longo referred to earlier, the matter against the Star non-executive directors and a number of their executives, was heard by Justice Lee over a number of weeks, if not months, recently, with 11 individuals that ASIC has taken action against in their individual capacity. My recollection is that issue that you've just raised about what directors ought to have known will be at the heart of that case. Yeah. And so two of the directors, I think I'm right, two of the directors have admitted that contravention or a like contravention, and the remaining 9, including executives like the General Counsel, the Chief Executive and non-executive directors, have contested that matter. So it may be that this issue that you have raised, that will be a case that does give us some clarity around ought to have known. So anyway, when we meet on another occasion, it may be that we have a decision there, and again, once we have some judicial clarity on that point, it may help in these discussions that we're having.
Could I go now to the very patient Mr Violi? We can't quite hear you. You might need to unmute.
Yes, just new technology in the electorate office, so hopefully it's working now. Thank you.
It looks very tidy.
Good, yes, and apologies to all that I can't be there in person, but a few events in the electorate today that I need to be at. A change of subject, if that's okay. Just wanted to move to crypto and digital assets and just talk through that for a little bit, and particularly around, I guess, some of the rules, regulations, litigation. So there's recently been some reports, ASIC have talked about taking a litigation-based approach to crypto and called for a comprehensive payments licensing reform to provide greater regulatory clarity for fintech firms. And ASIC has previously said that you will release an updated guidance package on this issue, and just keen to know when we can expect this updated guidance in relation in particular to information sheet 225.
Yes, we do plan to. We're very close to issuing a revised information sheet taking into account a whole range of consultations led by Commissioner Kirkland, who unfortunately isn't here today, and taking into account various developments in the law and our understanding of it over the last few years. So the industry, there are different views among industry, but I think there is a view, the majority view is that they would like more certainty about where the regulatory perimeter is and what licence they may need. So the idea with this information sheet is to be helpful in giving the market our best current understanding of what the law says and how we intend to apply it. And you can expect us to be publishing that hopefully in the next couple of months. Yeah.
And so with that, I guess, approach, when it comes to, you said, sort of that litigation-based approach, I mean, is there that risk that, I mean, it sounds like you're waiting until after products are launched and then the retail customers are exposed and then using court actions to retrospectively define the rules? And I know there's been some legal action around sort of BitTrader, Find a Wallet, Block Earner. So I'm just trying to understand there, if the regulations are delayed but you're taking legal action, how do those operations and then people that are using those assets have the certainty that they're operating within a defined scheme?
Well, I think the first point is it's not ASIC's general approach to regulate by enforcement. I think our track record is with the introduction of, this isn't directly relevant to crypto, but it gives you some background. So whether it's reportable situations or the compulsory climate risk disclosure regime, our general approach is to first let the market know how we plan to administer the legislation and release regulatory guidance. That's actually what happened here as well. The financial products and financial services regime we have at the moment didn't really contemplate digital assets in the way we've come to be familiar with them now. But having said that, there are some crypto assets that may be covered by the current definition of financial product. And so these issues really started to bubble 3 or 4 or 5 years ago, and I think you quite rightly referred to some court cases where we did test the regulatory perimeter, or where we felt that consumers were being harmed by what we were seeing, and so we took action. Now, this area has been the subject of I think 2 Treasury consultation papers with proposed law reform, and that we understand that legislation will be introduced into the current Parliament at some point, possibly this year. I'm not sure when that'll happen. Our understanding at the moment is that legislation will not, the approach they're taking will not involve revision of the law around financial products and services. So we're dealing with quite a complex area here. So even after the legislation that the government has been foreshadowing is introduced and possibly passed, there's a lot of the guidance that we'll be publishing in the next few months that will continue to be pertinent, because the underlying regime there's no suggestion that that's going to be amended or revised. So it's a complex and emerging area. I'd like to think ASIC has engaged very intensely with the market. There's been a lot of interest around crypto assets over the years and tokenisation. So we're not, our job's to administer the law the way it is and to be helpful and to facilitate compliance with it. We think that this revised information sheet that, as I say, will imminently be released, will be helpful to the market. We think that it will lead to more licences being applied for, and we're gearing up for that. And then hopefully in the meantime, legislation will be introduced into Parliament to give effect to current government policy around this subject.
Thank you. And just into, I guess, talking about the sector and the market, can you provide advice on how many years ago the sector and those in the industry had been asking ASIC for updated and clear guidance in this space?
Well, it's a bit of a history, isn't it? When crypto assets first entered the scene, their virtue was said to be that they wouldn't be the subject of regulation and that they'd sit outside official understanding. I'm obviously generalising here. That view, I think, evolved over time with some of the major players beginning to appreciate that being seen to be regulated was actually in their interests and in the interests of consumers. So I think historically that this whole subject has happened over a very short period of time. Crypto assets were, they disdained regulation. Now we're entering a period where the major players want certainty. They want to be regulated in the sense of giving investors some confidence that what they're doing is happening within a regulated framework. Now, I have to say there's a diversity of view in this sector. I'm just generalising to some extent, but our view is that the appetite, if I can put it that way, for more certainty and guidance from ASIC around this topic has certainly grown the last couple of years. And we'll do what we can to be helpful there within reason.
Yeah, perfect. Thank you. And just in regard to BitTrader, to Find a Wallet, and the block earner proceedings, had any of these businesses sought advice from ASIC on their operations under the Corporations Act prior to the enforcement commencing?
I'd have to. Chris, can you
take it on notice?
Yeah, that I'd have to take on notice. Some of these the two matters, as it happens, there are two matters in the High Court now. One of them at our instigation and the other by another entity. I'd have to look at. I'd have to take that on notice.
No, that's okay.
These matters have been going through the court system for some time, and we'll I'll have to see what the.
I understand, Mr. Longo, and I understand when it's you've got to take your time. That's no problems. Just in regards to a little bit more guidance, when will ASIC release its updated guidance package following CP 381 and updates to Info 225, which I've referred to, digital assets, financial products and services? So you're saying a couple of months. So we should expect by Christmas this year, 2025, we should have those updated?
Yeah, possibly even sooner. It's very much on our minds because it's gone to commission a couple of times the last few months. So I wouldn't like to be held to a specific date, but I certainly hope it's well before Christmas. It should be the next. It's imminent, I think, is the word we like to use in these circumstances.
I don't think Commissioner Longo wants to be confused with Santa at this point.
Yeah, well, I was going to make a joke about Christmas presents, but I don't. There's only certain people that want crypto regulation for Christmas.
Can I
just help me with that?
Yeah, thank you. So just a little bit more information in relation to that process and the info sheet. And I think implicit in your question about whether those particular entities had engaged with us ahead of proceedings or not, I think, we don't bless products or services or whether they fall within or without definitions. Of course, people get their own legal advice in relation to that. But we do, to Chair Longo's point, recognise just how complex those provisions are, the definition of derivative, the definition of managed investment scheme or otherwise, when something is or isn't a financial product is quite difficult, let alone when it's a digital asset. So we do recognise the challenges associated with working out whether you fall within or without that those definitions across Chapter 7 of the Corps Act. And that's why one of the features of InfoSheet, which is a little bit unusual, is just how many worked examples that we've given. We can't work every example, and obviously people would always need to get their own advice, but that's been part of the effort we've made, the extensive effort, the engagement that the team and Commissioner Kirkland have had to really try and understand what worked examples are the most useful. To the extent ones have been prepared, are they contested, are they agreed? Would additional ones be helpful? So that's been the time taken to try and really make sure that we are being practicably helpful with that info sheet.
And I might just supplement what Commissioner O'Rourke said. I'm just reading from my notes here. sometimes people ask for more certainty, but that doesn't mean they're going to like what they hear. We've done our best to be reasonable and sensible based on our best understanding of the law as it is, and there've been. It's a pity Commissioner Kirkland isn't here. I know he's had multiple meetings with market participants, gathering views. We've worked closely with Treasury, so I think we're hopeful that this guidance will be helpful to the market and give people certainty, but they may not like every answer we come up with every question they've asked. They may not like the certainty they're getting, but we're doing our best.
They rarely do, but at least you can give certainty, which as you can appreciate, many are looking for. And you've mentioned a few times sort of Treasury, and just keen to understand, they're obviously working, it sounds like, on some legislation, and how much you're involved in that, particularly around, as I said, blockchain, crypto, digital assets, but also are you working with other agencies like Treasury to define what is blockchain, crypto and other digital assets?
Well, the Commissioner might be able to help me with this. I think the policy strategy of the government is to regulate the digital platforms. Now, we'll put that to one side for a second. The regime under the Corporations Act that Commissioner O'Rourke was referring to, which is the fundamental aspects of that is whether something's a financial product or service, and if it is, then there might require a licence. The law reform, as I understand it, that's coming, it's imminent, introduced into Parliament, it's not going to affect that. So the definitions and the of financial products and services, the proposed law reform isn't going to touch that. And so that's another reason why we feel that issuing this information sheet is helpful, because even if this law reform goes ahead, it's not going to. And indeed, one of the reasons we sought special leave in the High Court was that the so-called gatekeeper provisions in the Chapter 7, we feel that the High Court should be asked to look at how they work. Because they're sort of like they're fundamental provisions of what's a financial product and what's a financial service, and the proposed law isn't going to affect that. So it'll be interesting to see what the High Court does with those provisions, but we think it's in the public interest that there be clarity around how those provisions work, not only with these products, but in general. I hope that makes sense.
So, yeah, it does, but I just want to clarify. So there's new legislation coming. However, you're saying it and don't want to verbal, so I genuinely want to make sure I understand this, because I know it's quite technical, but this new legislation won't actually resolve some of these issues you've got around the clarity of what is a financial service and what... Because it feels... Sorry, that's...
I think that's a fair statement. This whole area, it's really stepping back. The way the corporation is meant to work, it's meant to be technology neutral, and so we have this complex legislation. It's intended to be technology neutral. No one really contemplated what we're talking about now, or certainly not when they were writing this legislation. And so there's been a lot of thought given to this. It's going to land, we think, in the next few months with legislation being introduced into Parliament. But our understanding, based on the Treasury consultation papers, that the regulatory strategy is not to tinker with the definition of financial products and services, but to come at this through the platforms. Now, I'm just looking at my notes. Maybe one can help me further on that, but that we may have to take that on notice. The other area, if I may say so, is it'll be easier, if I can put it that way, to have this conversation once we've seen the legislation. In fairness to everybody, these are difficult issues. There were a couple of consultation papers that Treasury published some time ago now. And so I think it'll be easier, if I can put it that way, to have this conversation with legislation in front of us and the proposed explanatory memorandum, and then we can sort of see where the lines are being drawn and what the lie of the land is, if I can put it that way.
In a more practical and less theoretical way.
But I really want to stress that ASIC is doing whatever we can to be constructive in dealing with crypto and digital assets. but it is a complex area.
Okay.
Yeah, no, thank you, Chair. Look, I think that'll wrap it up, and I guess that put it on notice, Chair, that once the legislation's out there, I'm sure I'll be able to find a time to continue this conversation with some more detail, but I really appreciate
I'll know exactly what I plan to do. I'm going to get Commissioner Kirkland in the room, and I'll be happily be by his side, but it's such a pity he's not here today. He's on leave.
Yeah, no, I think we'll leave it there and we'll catch up again once the legislation's there and the Commissioner's there and we can have a continued conversation. Thank you for your time.
Thank you, Mr Violi. We should go to a break, but we're just going to push through with one more line of question from Mr Moncrieff, and then we will go to afternoon tea.
Thank you, Chair. I just want to follow up on, as raised by Ms Lawrence earlier, around climate. I'm fortunate enough to represent a few communities in my electorate that are very much affected by a changing climate, flooding, bushfire, places like Bundeena, Warranora, Sandy Point. And I just wanted to raise with you around affordability and availability of insurance, general insurance especially, and what your view on ASIC's role in that space is, and whether there's anything that you think ASIC could play a greater role in, or whether there are any market failures around general insurance at the moment.
I'm happy to start.
Commissioner
again, in Commissioner Kirkland's absence, so happy to give some general information about the work that we've done on insurance, and if it doesn't fully satisfy your inquiries, we'd be happy to take it on notice. So insurance is, along with super banking and insurance, they're kind of the core pillars of the financial system and of our responsibilities in financial services. And so we do have a lot of work in relation to insurance that's underway. And at the heart of much of the work that we do, affordability and accessibility are important aspects of that, along with our COFA colleagues, APRA and others who work on insurance as well. So we have a strong focus in insurance in the relationship with consumers, and particularly information that's available to them about their premiums, that information, and also claims handling. I think to your point about affordability and accessibility, that coming in and understanding what the premiums are, how much they've paid to date, but also if new premiums are put to them, how much they've changed and whether that's been accurately conveyed to people. That's one of our specific areas of focus for this year's corporate plan, transparency on the disclosure of premiums. The second area of particular focus that we've got this year is on cash settlements. You referred to natural disasters that including affect your community and indeed everybody's communities, and we have seen an increasing use of cash settlements associated with those, and we're concerned to ensure that they are done well and that there aren't any areas of concern in relation to them. So that's the second strategic priority that we've got in relation to insurance. And then the third is, of course, claims handling more generally, even whether it's a cash settlement or otherwise. We've seen in the past claims handling concerns. I think Commissioner Constant referred earlier to those in relation to superannuation, but similarly in relation to insurance, we've been keen to make sure insurers are on notice of our expectation, our high expectations with respect to claims handling. And so we've had a report on home insurance claims after storms. That was from and we did an update in relation to that just in June this year. And so if there's additional information on that work, on the premium work, on cash settlements or internal dispute resolution handling, they're things that we've had particular focus on. You'll be aware that the Parliament has had a very high level of interest, particularly in floods. So ASIC appeared before those parliamentary hearings a number of times and have been carefully considering recommendations in relation to those as well. So that's some of the work that we've been doing, and I think your point around affordability and accessibility is at the heart of some of them.
Excellent. I note in the submission as well, it called out improving supervision of third parties such as independent experts. Does that include local government areas? Like I know in my area there's been some controversy around flood studies done by the local governments. I don't know whether that is in your remit or on your radar.
That would be. I think when we talk about experts, I think they're those engaged by insurers, for example, to estimate the value of damage or more commercially engaged third parties rather than government agencies. But I'll provide additional information if I've misstated that.
Yeah, sorry, and just to, I appreciate you can take that on notice, but when you say that's in terms of the claims handling side, do you know about whether, in terms of writing the premiums, when it's taking into account the data, the publicly available data around areas, is that something that they are looking at?
The reference I made earlier to premiums, our focus there is really about the communications of premiums changes or increases more directly between an insurer and their customer, less around the calculation internally by the insurer. So what we've been concerned is that we're seeing instances where people, for example, say, this is the same as what you paid last year, or this is 5% less than what you paid last year, and the amount, like that denominator that they're comparing it to, isn't accurate. Actually, the person paid less, and they're now looking at a 30% increase, but they're presented as if it's the same amount. So that premium pricing, premium promises, is the area when I mentioned premiums. I'll take on notice your query, which I understand to be about premium calculation, and see if we can give you any additional information about that.
Yeah, cool, great. Cool. Yeah, so the thing I wanted to ask you about was the chess replacement project. I think you have taken action against them in relation to saying that it was on track, and obviously it hasn't been on track as much as they have said. I just wanted to get a sense of what you think the impact on the consumer has been for that, or of investors for that.
This is in connection with
chess.
ASX and the actual litigation.
Well, there's a lot happening with ASX. We'll just step back for a second. We have an ongoing ASX inquiry, which is the first of its kind, which was started in July. As far as the ASX case is concerned, that we commenced about a year ago now, just over a year ago, that's a misleading and deceptive conduct case where we allege that ASX at the time, in February 2022, I think it was, misled the market and the general community about progress it was making on chess. We now know that the first iteration of chess, that the plan to replace it, was abandoned, and there's now a new plan to replace chess in 2 phases. The first phase is clearing. They're hoping to get the clearing part done by sometime next year, around March, April 2026, and the settlement part of it in 2029. Does that sort of answer your question? I'm not sure.
I think, I mean, obviously I just wanted to get a sense of what, obviously there is going to be an impact on consumers not being able to access the new service. I just wanted to get a sense of what the extent that ASIC's view of how that is affecting the market and investors, and what the impact on the broader market is.
Well, for investors in the broader market, they just want the exchange to work, to function, and for it not to have any breakdowns. And so regrettably, there's been some incidents over the years, and so it's the resilience and of those systems that is at the forefront of our concern and RBA's. So to the consumer and the investor, they should be able to confidently trade on the stock exchange without any disruption.
So is the ASIC's concern that the current system is not working, or is ASIC's concern that they have promised a better system that doesn't exist yet?
ASIC's concern is that and this is, I think, fairly well documented, chess is old.
Yeah.
So when it was first introduced, and for quite a few years after that, I think it's fair to say it was world-class technology. But over the last 5 or 10 years, it's aged. It's a legacy system now, and it has to be replaced. Now, between us and the RBA, we've held ASX accountable to ensure that current CHESS, which is getting old and is consequently at risk of not functioning consistently and resiliently, that it will function consistently and resiliently while the next 3 or 4 years goes by while they replace it. So first concern, it's old technology, but it has to keep working until the new technology replaces it. And so that's the issue in a nutshell. The current CHESS has got to keep working until it's replaced. And there is a plan for replacement along the lines I've at a very high level just described a moment ago. But are we're concerned in the sense that this has to work. This is critical infrastructure for the country. Yeah.
And obviously that would be due to the ASX as an individual entity has a de facto monopoly over exchange.
Yeah, they do. They are. I'm not sure it's a natural monopoly, but it's certainly, for all practical purposes, a monopoly. And it's on ASX to get this right. And so we're doing everything we can as a regulator to hold them accountable for that outcome.
And just, Mr. Moncrief, I might just add, just getting to some of the tangibles of what might be the impact. I think you're trying to understand for average Australians, what might be the impact or what the feeling might be. The ageing technology, of course, as the Chair has said, reduces the reliability, so there is the resilience component. Now that could, over time, reduce confidence, which of course we worry about, because reduced confidence infuses the market generally, whether it's cash equities or there are other activities. If you have an outage, for example, so if there is an outage because the system is old and is unable to be supported, immediate direct impact, because those who participate in the system, for example, the posting of margins and things, that gets that direct immediate impact. And then over the longer term, the need to move to the new system and to do that cleanly and execute that properly, because there's a range of functions that the ASX feels that they need to be paying attention to across the board, which includes ensuring we have an alive and healthy listed market, for example.
Is there any other institution that you regulate where you would be this concerned around their ageing technology?
They're a unique entity.
Yeah.
So I think they're a unique entity. So they're a self-listed stock exchange, the first of its kind in the world. They are, for all practical and legal purposes, a monopoly. So we're very dependent on their service and functioning, remaining resilient and reliable. There's a complex regulatory architecture around ASX. So we've been talking a lot about the banks today. ASX has its own regulatory architecture. So, for example, FAR doesn't apply to ASX, a bit counterintuitively, but it doesn't. It's just the way the system is designed. In the last 12 months, some very significant legislation has been passed by Parliament. One piece is called Competition in Clearing and Settlement, which I might get Simone to talk about in a bit more detail, but essentially that creates a role for the ACCC where there's a dispute between ASX and an entity it provides a service to, where they can't reach agreement on the price to pay for that service, because remember they're monopolies, so and that gives us some powers, additional powers in that space around competition. And then there's market infrastructure reforms, which are really quite complex and unique, and they give special powers to the Reserve Bank and ourselves that if there's a major problem at the ASX, it creates a resolution regime where the Reserve Bank can step in, given the financial firepower to help with that. So we're talking about an entity that's really unique in the Australian economy, because we rely on it heavily, obviously, as a public market for the trading of equities, and that's everyone's super, right? So there's no shying away from the fact it's critical infrastructure, and I think what we've seen in more recent times, certainly the last 5 years, is an intensification of supervision and regulation around the ASX, and that's only going to accelerate, I think, particularly with all the concerns around chess. The incident last, the 20th of December, which Commissioner Constant handled. So I think it's a big subject. I think we place where we've done a lot of, we've imposed licence conditions a few months after we started in October 2021. There's been a series of expert reports. There's been, the Reserve Bank has raised very significant concerns around governance and stability with the ASX. So, and now we have this inquiry, which we're hoping we'll be able to publicly report in the first quarter next year. So, long story short, we working very closely to make sure ASX continues to function reliably, but it's an entity that will require a lot of attention in the coming years to get it back to a position where regulators and the market can have the fullest confidence in its operation. At the moment, that confidence has been shaken, is the way I would put it. Simone, did you want to add on the market infrastructure?
I'd simply add that we, at the time when we announced the inquiry, for example, we stated that it's unprecedented. So this is an unprecedented inquiry because of our concern about the failings and some of the breadth of the failings, alongside our sister regulator RBA, who have publicly downgraded elements in terms of observability of operational risk readiness, for example, and that by nature of the function of the ASX, which is so complete in terms of the plumbing of the Australian clearing and settlement, nature of our role, nature of the failings, that we were taking this unprecedented step to commence this inquiry. So I think that gives some, further veracity to our level of concern and the seriousness with which we take our role and the seriousness with which we see and understand the critical infrastructure of ASX.
Thanks.
Thank you. I note that the Department of Home Affairs list critical financial services and infrastructure as matters of interest to them. Are you aware of the Home Affairs interactions at all with the ASX at this point?
We've been handling that too, but we've certainly been engaging in a whole of Commonwealth, whole of government approach, and that includes Home Affairs. Referring to cyber security?
Well, it's a threat to every piece of critical infrastructure, isn't it? And the ASX, in its perhaps compromised state, where you've described confidence has been shaken, is obviously perhaps a target for those who would wish ill to the Australian economy and the Australian people.
I can respond to that, Senator, and then share the response perhaps with Deputy Chair Court as well, who's been working with Council of Financial Regulators on some of the geopolitical considerations, because that's the right thing to do as a Council of Financial Regulators. We absolutely see the critical infrastructure role of the ASX. We absolutely at ASIC, but also at RBA, who have those lead roles when it comes to, for example, observation of operational risk, etc. Absolutely understand that critical role and that link of the plumbing into the infrastructure. There has been Home Affairs should be better placed to respond to some of the questions about some of the cyber testing and the approaches, but absolutely ASX is within that net and that consideration. And again, as when I gave such a strong, I think, response to Mr Moncrieff about understanding the criticality of the system and our role, the cyber and the operational risk and the risk of incident and the central nature of this to security, that is always part of that picture and on our mind. And I don't know whether Deputy Chair Court has anything to say about the Council of Financial Regulators and the Deputy's work that's going on geopolitical readiness.
Well, I need to confirm that the ASX is one of the entities that we are considering through the work of the Council of Financial Regulators in relation to cyber risk, absolutely.
Thank you very much. The committee will take a break now and resume at 3:25. And for those who are following along at the break, there will be chocolate biscuits for those who are in the room. Thank you very much.
Got the right people. You happy for me to proceed? Yep.
Yeah, I suppose.
Okay, great. You released your report into particularly governance arrangements in relation to AI just under a year ago, in October 2024. And in that report, you mentioned that there's been a rapid acceleration in the volume of the use of AI, but that largely the way that licensees use AI was quite cautious, particularly in terms of its use in direct interactions with customers. I am interested in whether, sort of 12 months on, I assume that acceleration is still continuing, and whether that you, I guess, have any further advice on the use of AI across the sector, and particularly whether there are specific areas of concern where you're seeing the use of AI increase that might be a risk, particularly to consumers.
Okay. We released Report 798 nearly a year ago, which was based on sort of a surveillance of 23 licensees, and it sounds like you've read that report, yes, so I won't try going over it again. We haven't refreshed that work.
Okay.
Yeah. I'll come back to what our planning might be there. And then in April, we released a market integrity update 166, outlining, amongst other things, the findings of a recent review into the current and planned use of AI by 40 market intermediaries. I don't know whether you had a chance to look at that.
I haven't, no, but I will. Can you just say
ASIC
that again?
It's Market Integrity Update 166. We'll send it to the committee. ASIC observed that AI is primarily being used by these intermediaries for information generation, and that 71% are expecting to expand their use of AI in the next 12 months. Clearly, the safe and responsible use of AI is on everyone's minds. We've talked a lot about banks. About a month ago, I gave a speech at the ABA conference, Better Banking, where the main theme of the speech was AI. And so I don't know whether it's helpful I can just give you the gist of what I said.
That would be very useful.
So what the speech says is there's been a couple of surveys done in Australia over the last 12 or 18 months, and I haven't got it in front of me, but essentially the surveys conducted by major consultancies suggest that Australians' confidence in AI is declining, not increasing, and people don't trust the technology. That's a broad generalisation, but the speech refers to the research that points to that. And the idea was, in this speech, was to say to the banks, look, if anyone's going to get AI right, you should be able to get it right, because you're great users of technology, and anyone who's a bank customer knows that there's the virtual assistants. So whenever you log on, there's a chatbot there trying to help you. So I think the Commonwealth Bank in particular has really invested heavily and been a leader in this area. So long story short, I think in the banking sector at least, we're seeing a lot of recognition of the potential benefits of AI for customers. Now, I think as we said earlier today, we get information from a variety of places, and that includes the consumer groups. I think there's some mixed feelings in the general public about whether those virtual assistants are working as well as they should. At that conference, I gave the story of we're getting some feedback that people ask the virtual assistant, can I speak to a human, please, and they get hung up on it. So there's still a way to go, but I think it's fair to say that the use of AI, for example, with scam detection, fraud detection, customer service generally, I think it's a technology that does have a lot of upside for customers of banks. So we'll have to see how that goes. More broadly, ASIC is using AI to some extent. We're using Copilot. A lot of our staff are using Copilot. We have a lot of governance around the use of Copilot. So it's a big subject. I'm not sure what our planning will be for next year as to what level of resources we might put into tracking what the sectors we regulate use of AI. It sort of seems to be everywhere, but what ASIC's particular interest is going to be, we'll have to wait and see. The other aspect of AI, other than its obvious potential to analyse data, we talked a lot about data today, and we get data from various sources, and obviously these technologies can help us analyse that data and draw inferences from it. So aside from that, the other area that we're thinking about is whether our existing powers are sufficient to do investigations into AI technologies, into the underlying code. So it's a bit early to say whether we think there'll be a need for additional powers there, that we've done some work with Treasury to understand that. So I think all that's ahead of us. We need to, our existing powers are pretty good, I think it's fair to say. Whether they are extensive enough to deal with investigating or inquiring into potential AI issues that cause harm is another matter. I might just stop there. It's certainly an area that all the commissioners and ASIC as a whole is trying to lean into, like everyone else, trying to figure out what the technologies mean for us and how we can use it and what the issues are.
Thank you for that. Do you have does ASIC have an understanding of how widespread the use of AI is, particularly in decisions about credit by banks? So loan applications, etc.
Can you help me with that, Kate? Do you happen to know?
I think we have ad hoc. So we do have regular engagement with the banks, the big banks particularly, but also with some of the smaller ones a little bit less frequently. And emerging issues and use of technology are covered in those discussions. But that isn't sort of systematic. Like if we do a surveillance, we can look and get a more sort of across the board view rather than just hearing what's raised with us. So I think I'm not aware of that prevalence. To your question, how prevalent is use of AI in credit decisions, I'm not aware that we've got anything granular on that. If we do, we'd be pleased to share it with you.
And it may be that APRA may have that data as well,
okay.
Given that they are close to credit decisioning as part of the standards work they do.
Okay. And you, I suppose, might not have the answer to this either, but you do note in your report that you hadn't seen evidence of, in the process of making those credit decisions, the use of AI bringing in some of that third-party data like social media activity, etc. Is that something you would seek to keep an eye on over time? Do you think that's a risk that some of those practices we've seen overseas might start to creep into the decision-making of banks here?
Well, I think the use of AI by banks obviously creates the potential for conduct issues and consumer harm, or certainly not meeting consumer expectations. If we see that, I think we'd be interested. But as Commissioner Constant says, and Commissioner O'Rourke, this is early days for our sort of really understanding to what extent certainly the banks are using AI. But there's a lot of investment going on across a range of fronts along the lines I suggested. How successful it'll be and whether it raises other issues remains to be seen.
Okay. And in terms of the insurance sector, does ASIC have any understanding of how AI is being used in the insurance sector?
Not in particular. There are a couple of cases we're running at the moment that I call pricing promise type cases, I think one's against IAG and the other one's Perpetual. I think there are two. Yeah, and they're not necessarily AI cases proper, but what we're interested in both of those cases is whether the insurance companies the two entities have kept their promise about premium discounts or bonus arrangements. I think we all get insurance renewal notices, and we're often told by insurance companies that we're being rewarded or we're getting the benefit of some discount. So we call that pricing promises. Now, underneath those promises are essentially algorithms that calculate the premium and presumably support the promise, that the assurance that the policyholder is getting when you're asked to renew. And so we're running two cases where we're litigating those issues where we think the algorithm, I'm not sure I'm putting it too simply, got it wrong. Sarah, do you want to help me with that?
It would suffice to say, we have civil penalty proceedings in court at the moment against IAG, as Mr Longo said, because we're concerned that loyalty discounts that were promised were not delivered. But sitting behind that issue for us was that an inability by IAG to explain, at least to our satisfaction at the time, as to how and whether those discounts were applied. So there was a bit of a black box mechanism. This is, again, all before the court, all allegations, but what we were concerned about was a bit of a black box mechanism sitting behind those promises and an inability to explain to our satisfaction how the pricing promises and the discounts had been delivered on. So that's a live matter now. We've had a number of other cases, Senator, in relation to pricing promises, but that's the one, in insurance, but that's the one that has that particular element that Mr Longo was referring to.
Mm-hmm. Okay, thank you. And then just finally on this, one of the other things you note in the report is that across some entities in the sector, AI is being adopted at a much more rapid rate than their governance can keep up with. I'm just wondering if you could give us some specific examples of where those governance gaps exist.
Well, what we're referring to there is where the technology or an AI-like technology is used, but it's not used in a way within a governance framework where there's been a proper approval process.
Okay, sure.
Or whether there's been an assurance mechanism to make sure that whatever the result is of that technology is correct. Can you help me with that, Simone?
I think one of the key principles, and this is not just for ASIC as a regulator, I think most regulators taking this approach is that concept of explainability. So when we're thinking about governance, it's about understanding, the impact before it's introduced. So it's at the top levels of an organisation that the guardrails are there that are clear, the bright lines about what are the rules of introduction, what are the rules of implementation, but also what are the rules of assurance, and as this changes. And so that concept of explainability, that not just at top levels of governance being able to explain, they may not know every piece of AI within every piece of software, for example, but they know that these are the rules within which it will operate, for example, the human in the loop element. But also that there is assurance, which also flows up to governance, that results are explainable. Because the concept being that when those results are used, when that application is used, a human that is accountable for that has to be able to explain that and be able to explain the assurance. So that's the role of governance. It is both the people at the top and the committee or whatever structure oversees that, and the rules and frameworks, the bright lines within which, of course, like every regulator, we also want to see AI developed and deployed for productive benefit, especially where it brings benefit for consumers.
Okay, great. Thank you.
Thank you. And now I'll give the call to Ms Jarrett.
Thank you. I'm going to just circle back to a couple of topic areas that were mentioned earlier. I just want to go back to the scams quickly, because you said your focus was investment products, investment areas. But given you are the regulator on the conduct of banks, help me understand, is there role for ASIC in terms of guiding or regulating the banks who do play a role in this space? So, for instance, if I get a text and it says my account's overdrawn and you need to put X amount of dollars in, and I sillily go bang, bang, bang and give them my money, that goes to an account somewhere, right? And so is there a world there that we need to look at more closely in terms of banks and their role in protecting consumers?
Thanks, Ms Jarrett. So certainly there is a role for ASIC in relation to engaging with, dealing with, taking enforcement action in relation to banks and the way they engage with their customers, but predominantly the way that role is currently being contemplated is through the Scams Protection Framework. So we have a range of existing laws, of course. So if a bank was involved in misleading a customer to that effect, acting unconscionably. We've got the case I mentioned earlier against HSBC, where we feel that they failed their licence obligations to act efficiently, honestly and fairly because they had not proactively, the allegation is, not proactively acted to stop losses to their customers from scam activity. So ASIC very much has a role there. And then through the Scams Protection Framework and the banking code that we are expecting will eventuate down the track, as I mentioned earlier, there'll be a number of granular obligations on the banks in relation to, and there's a range of principles that are included in the Scams Protection Framework that go to protecting consumers, educating consumers, disrupting scams. And so we will have a role, should the government decide that we should, in relation to enforcing the obligations of the banks and where they fall short under that regime.
Okay, that makes a lot of sense. And at we don't know timing yet of when those codes are likely to come to fruition, do we?
No, I know that Treasury is working hard on those codes, and I also anticipate there will be a number of rounds, or at least one round, but I suspect potentially more rounds of consultation on what those obligations are. Okay. The banks have done work, as have other industries, the telco industry in particular as well. They have done a lot of work on scams and trying to, work out best practices. There's an industry-based code that the ABA has led that has put together a range of obligations, and then, the Scams Protection Framework and the banking code to come will no doubt pick up a lot of those obligations and potentially go further, but there'll be extensive consultation, I would imagine, between consumer groups on the one hand and industry on the other as what those enforceable obligations that will sit within the banking code should be.
Yeah, okay, we'll have to watch that space carefully. Mr Bioli picked up on crypto. I just want to follow on with a couple of other questions, and you may not be able to answer them given, is it Commissioner Kirkland who had responsibility? But I understand that there is a growth of new digital assets and that we're seeing in Australia more crypto asset related managed funds. Even I read in one of your reports exchange traded funds, and my question is there a huge uptick in this? Is this something that has a little more urgency around it than where we're currently thinking?
Oh, that's a good question. I think the data on to what extent consumers or investors in Australia are interested in this activity, I don't know whether anyone's got any current data. So I couldn't tell you right now whether this is a growing sector.
I was just going to say that surveys suggest between 10 and 30% of Australians hold or have held crypto assets as we speak. So clearly growing, if nearly a third of Australians have got assets.
Yeah, and there are 427 digital currency exchanges currently registered as of April with Austrac.
Okay.
So it's definitely a non-trivial part of the investment environment. Whether it's urgent to regulate it more quickly, I think is a different question.
Yeah, I haven't given it a lot of thought. It just strikes me that if it's moving quickly, it might be something to jump on. But the other thing is, when you talk about the 427 digital currency exchanges, would the majority, you may not even know this, but would the majority of those be from Australian companies, or would a lot of those be from overseas?
Well, if they're operating in Australia, they'd be required to be registered with AUSTRAC as
registered, but ownership might be elsewhere, right?
It could be domestic,
it could be
international.
Anywhere. Yeah. Okay. And IOSCO, I understand, Mr. Longo, that you participate in OSCO and they're doing a lot of projects in this space. Is there anything happening there that we want to be
IOSCO
tuned into?
Internationally is doing a piece of work around what the consumer protection standards or principles should be around this activity. And I think that piece of work was kicked off about a year ago. I'm talking about the international part. Yeah. And I don't think we've published anything yet coming out of that work. So IOSCO isn't necessarily a standard setter, but it has, because of the diversity and range of its members, the work it does lays out principles. So I'm not quite sure where that's going to land, because there's, I think it's fair to say there isn't an international consensus around what to do about this topic. The Europeans have gone in a certain direction, and I think the US, obviously, under the Trump administration and the new leadership of the SEC, have taken quite a different approach to the previous leadership of the SEC to this topic. And Australia, I think, is probably somewhere in the middle. And so I think that's why I think IOSCO will probably be a little bit cautious about exactly what sort of principles or standards it'll in the end publish. Regionally, the ASIC and the New Zealand regulator have co-chaired a working group with help from the SFC, looking at sharing information within Asia, within the APAC region, to do something about scams. So that's more about crypto. You're asking about scams. Crypto scams or crypto? Scams in particular.
Scams, okay.
But the crypto work is more global. Okay. So but sometimes the two get mixed up.
Yeah. And just while we're on IOSCO, are there, obviously there's a number of projects and priorities that they have. Are there any projects or priority areas where we are considered sort of in the lead, or where we're falling behind, or where we should be, like, taking the baton and running hard?
Yeah, I don't think we're falling behind in anything. I think the issues and priorities of IOSCO pretty much reflect the issues and priorities within Australia. I think there's one area where I'd like to claim some leadership, and that's around private-public markets and the role of non-bank financial institutions. Mm-hmm. And we indeed chair, one of our senior colleagues chairs the relevant working group, I think it's C4 or something, that is trying to hammer out principles that would govern pre-hedging, for example. So there's some work that we're actually leading, and that should be reported on, I'm hoping, in the coming months. But that's a good example of where an ASIC executive is actually chairing the relevant committee that's doing the work and holding the pen, so to speak. Yeah.
And you mentioned also, in response to Senator Whittaker, that they're doing work in the AI space. Is that correct? They are. Yeah. And do we know what the focus of that is? Is it the...
Well, that's a good question. I think the part of it is getting a grip on what people are actually doing and how the technologies are being used and applied, and then coming up with views about what the principles or standards of regulation might be.
Right.
So IOSCO historically has done some really good work laying out high-level principles on particular activities, and then domestic individual countries then use that to make their own laws, so to speak. Yeah, so I think in the AI space we can expect IOSCO to come up with some, I hesitate to say exactly what it will be for the reason I gave a moment ago, and that is AI regulation. There doesn't seem to be a global consensus about how that's going to be approached, and I think IOSCO as an international body will want to reflect that. It won't want to be. It'll want to reflect a consensus, not a diversion.
Well, they've got a lot of organisations they can tap into.
That's right.
That's for sure. So, and another question in relation to IOSCO, and I'm only asking because I'm looking at it thinking, what is it that's happening around the world that we as a country can benefit from in terms of protecting protecting consumers and facilitating the growth in our, investment communities and businesses. So, is there anything being done in the space in relation to some of the issues that have come up today, like greenwashing, individuals being held more to account, maybe in the insurance sector in terms of more transparency, etc. Yeah. So just the issues that are clearly of importance to the committee. Is there anything IOSCO is doing there?
Well, there's very wide-ranging work. Did you want to look at there's consumer education, there's climate risk disclosure work?
Yeah, I think I was just going to start at least with the climate risk before colleagues might help with some of the other ones. I think we do have, that's based on international standards promulgated by the IISB, the climate disclosure, and I know IOSCO's got working groups as well that assist in thinking about how they translate for securities regulators, and we have executives who attend that work. As to the other topics, individual accountability and others, I'm not sure if others might be able to assist on that, but yeah.
Just on the investor protection front, IOSCO's published a roadmap for retail investor online safety, and that's looking at engaging with social media companies and search engines to combat online financial harm against retail investors. IOSCO's also launched a iScan, which is a new investor alert portal.
Oh. Okay. Can I just say, Ms. Jarrett, that we're quite happy to share with the committee our current work program with IOSCO. There are 7 or 8 active committees. We're not equally active across all the committees, because as much because of resources as because of the work of every committee isn't directly relevant to Australia. But there is one aspect of the international engagement that I'll highlight that is often not highlighted, and that's IOSCO really promotes mutual cooperation and information sharing.
Yep. Okay.
So there's there's a series of MOUs that are regularly used. So we have a team within ASIC that provides information to other IOSCO members at their request, and that we request. So it's a two-way street. But that information sharing is quite significant for some of our enforcement work.
Yep. And I'm assuming there's a lot of data privacy issues tied up with all of that in discussions and frameworks to adhere to.
Well, a lot depends on what we're asked for, and under our current legislation. So there's legislation that's designed to facilitate some of that information sharing, and some of it is dealt with through the MOU. But it's just another feature of our work. So about a third or a half of our international work is that.
Okay. And is it right to assume that when IOSCO, so you talked about the investor alert portal, like if that is something that we think would be really good for consumers here in Australia, that would form part of your work program going forward? For instance, I'm not saying that specifically, but if that's, I'm just trying to understand how the process works.
So ASIC has an investor alert portal at the moment. I think this is about connecting those globally. So IOSCO has created as the global coordinator, so we can feed in, and so can other peer regulators feed into effectively what becomes a global portal.
Right, I understand. Okay. That's it.
Thank you. If I can return briefly before moving on to other matters to let you know that people who have been listening to this hearing are paying attention. I'm going to table a document that's been forwarded to me for you to have a look at, which is a classic investigation about super. Just so it's on the public record, and if people can see this today, they'll get an idea of what it looks like. And this is a plug for English teachers. So one of the things that I used to say to all my students going into exams when they had to do analysis was you're looking at the language, the layout and the graphics. And if we look at this document when you get it before you, just want to indicate at the very top, it says from, check now in bold print, then info@news.updatenow.uk. Interesting. It's come from overseas. The subject, very, very nice. You are invited to a complimentary super review. The date, 18th of September. And they're at it early, just before work time starts, 8:45, here it arrives in. Now, at top it says super experts is the graphic with, star-like bursts coming out from it, and begins with, highly identified Dodgy superannuation risk underperforming super fund in the blue to draw your eye to it. 60-second quiz for those who are a bit interested. It's a real lure to get people in. See if you qualify for our free performance review. When you read further down, there's an interesting way to engage people. Superannuation talk, not sexy but important. Just below that, they've got a few errors in their expression. Your balance has been eating away at fees rather than by fees, and that your might not be on track rather than you might not be on track. So it's interesting the level of care that's been paid to the ad and then the lack of textual clarity and correctness as you go down further. But when you get to the bottom, it starts to talk about fees, how well your super is performing, how does my super fund stack up, and then the final lovely lure, start your free review. I expect this is a classic form of invitation. Is that fair to assert, Ms Court?
Yes, it is.
Could I draw your attention to the very bottom blue panel? It says copyright Acquirely Proprietary Limited. Now, I've had a look at Acquirely. About us, we are experts in digital customer acquisitions. This is a company in Melbourne. Our team are driven, passionate professionals that use the latest technology to power client performance. We're dedicated to delivering engaging, relevant and personalised content to consumers to achieve the best possible results for our clients. Now, the client is not the person who's getting the invitation. Indeed. The client is somebody related to info@news.updatenow.uk.
Yep.
I'm just interested in what you think about this particular invitation, and does privacy@acquirely.com.au have any responsibilities for offering what appears to be financial advice?
Well, I agree, Senator. It's exactly the kind of social media feed lure that I was talking about earlier. It's just using slightly different language than that which I used. Compare your super, do a free super health check. This one is dud performing superannuation, and also designed, it would appear, to result in the same solicited contact, so that you press on the start free review or see how my super fund stacks up, and then straight away you are then moving from unsolicited contact into solicited contact, and that means that you at least arguably avoid the anti-hawking legislation. It's very deliberately targeted.
So people would have no idea when they collect that start free review that they've actually transacted
Indeed.
an agreement to let somebody talk to them and give them information, and that is the beginning of where they become at risk because they've agreed to allow this to happen to them.
Yeah, it's absolutely what we've seen again and again and again in the matters we've been talking about for a big part of the day. These people clicked on these links with good intentions, thinking they were doing the right thing, having no sense that they were effectively soliciting contact from someone that was going to do a sophisticated hard sell on them.
Now, if these people were having dinner and somebody knocked on the door, or breakfast if it was 8:45, somebody knocked on the door and said, "I'm here to help you with your superannuation," I suggest Australians will feel quite confident in shutting the door.
Indeed.
Yet, at this distance with the digital and with the phone, we seem to be more inclined or less suspicious about this sort of engagement. So do you have any observations to add to what you've said today in this court in terms of warnings for Australians?
Well, I think this is a good example, Senator, of the whack-a-mole that we were talking about earlier. So, we've taken significant action to close down numerous kinds of sites, ads like this, but they will continue. This one's coming from apparently from a UK address. They're not limited to people in Australia. I think the message needs to be to try to, as to some extent, of course, that you've been doing through the committee today, trying to make people aware that this is a risk, trying to make people wary, trying to make people understand that their superannuation is a significant and precious asset to be treated, obviously, very carefully, and to be aware, which is by no means to try to suggest that any of the investors in the matters that we've been talking about have done anything wrong. They have been, in our view, misled by a very sophisticated and intentional scheme, which has made a whole lot of people very wealthy. But we need to be conscious that this kind of conduct is going to continue, and there will be ads like this and pop-ups like this in social media feeds, no doubt for months or years to come. And we need to get the message out there in every way that we can to make people, aware of the risks.
This Acquirely says that they are very experienced in permission-based marketing.
It's shocking.
What powers do you have to investigate Acquirely and other entities like it, or what sister regulatory entities do you have that can cut this off right at the start?
So, Senator, of course we have powers. We can have a look at this email. We can do a company search of copyright acquired. We can go to the website as you have. We can try to find out the individuals behind this. We can add it to the 28, 29 current investigations that we already have underway in relation to this spread of matters we've been speaking about today. So we can do that. There may be individuals associated with this company that are already banned or that we're in the process of taking action against. But, I need to be candid with the committee and clear to anyone listening to this that ASIC is not going to be able to stamp out all social media advertising that looks like this. We have to find other ways to educate people, to disrupt. We can put this on our investor alert list. I mean, we do have tools, absolutely, but it is a game of whack-a-mole where people's superannuation monies are, or people seeking to deprive people of their investments and their money. So I think we just need to be realistic about the tools and resources of a regulator to be able to intervene on every ad of this kind.
And thank you for taking that, and we'll be interested to see what happens with it. But also to Australians listening or watching, or people reporting on this, don't click on a superannuation check. Shut the door on somebody who wants to talk about your superannuation at your front door unsolicited, and hang up. 3 things. Stop them at the front door, stop them on your feed, and stop them on the phone. Just do not let them get near your superannuation. That's the clear message. Can I go to whistleblowing? Thank you for your report. I'm going to refer to page 28, section C of your report to us. There's quite a detailed articulation of whistleblower protections. I'm going to go first to your training resources uplift that you've described, where you engage a specialist whistleblower liaison. I've asked about whistleblowing many, many times over the course of hearings over many years here. I'm very interested to see what has changed in the way that you are receiving whistleblower information, and I'm hoping that it will be somewhat trauma-informed, because by the time people get to ASIC, they've often had an extraordinarily challenging or sometimes damaging experience. Mr. Savandra.
Thank you, Chair. So that is right. We've employed a specialist whistleblower and witness liaison officer. She is a clinical psychologist by training. I should stress our role in relation to whistleblowers is not, we're not a support agency for whistleblowers. We're not resourced to do that. Certainly we're there to administer the law in relation to whistleblower complaints, ensure that if there is whistleblower victimisation, we take action. But the purpose of employing that specialist resource is so that we can take into account the situation that a whistleblower might be in and communicate in a more understanding way, understanding that there might be a clinical context involved. So we've done that. In terms of our approach to whistleblowing, it hasn't changed dramatically, but certainly that is one of the areas that we have sought to strengthen so that we can communicate in a more effective and possibly a less legal way with people who are wanting to raise or blow the whistle to ASIC.
Thank you. In terms of protections for whistleblowers in the Corporations Act, I notice at 121, paragraph 121, you state it is also against the law for a person to cause detriment, harm or threaten a whistleblower for reporting misconduct or because they suspect the person has reported or may report misconduct. And you give a couple of examples. Employer cannot sack, demote, discriminate against, harass and intimidate a whistleblower because they've reported misconduct. Or as a supplier or contractor to a company, the company cannot threaten a whistleblower's contract or business arrangements because they've reported misconduct or if it expects that they have. Can I ask, how does that articulation stand up in reality with regard to recent reports about whistleblowing from both the ANZ and, in recent days, the ASX? And I want to table 3 documents for your consideration.
Senator, I'll just respond briefly on the ASX. I think we may need to take that on notice in the sense of that you're referring to the article, I think, during this week.
Yeah, so there's 3 articles that are coming to you. One is in the Australian by Miss Cleona O'Dowd. And there are some extremely concerning allegations about behaviours at the ASX. But, for example, in this article, Mr Halstead raised concern on several occasions about ASX's obligation to submit an IBM report to ASIC and its failure to meet recommendations of the IBM report to ensure there was no repeat of the November 2020 outage. And Mr Halstead says he's about one of 100 ASX staff made redundant as a result of a company restructure. Always hear these things in terms of, there could be a HR dimension, but there's been reports made. Whistleblowers are telling me that they are reporting to you failures at the banks and failures at the ASX. there's reports here about the Chess Replacement project, which has been the subject of questions from this committee on many occasions, including today. And Mr Longo, you're on record saying that the Chess Replacement project must be managed effectively and transparently. Failure to do so can lead to a lack of confidence in Australia as a market to attract investment. But we've got comments here that Mr Halstead alleges when Mr Samur became his manager, restructure would lead to his promotion to Chief Technology Officer of the market. And Mr Samur tells Mr Halstead that he won't get the CTO job, would instead be offered a role as Head of Engineering Markets. But if he did not accept this role, he would consider to be treated as resigning. So there's a whole lot of manipulation of these contractors in this instance, or employees.
So
What's your view, Ms Constant?
I would respond by saying, aware of the article, read the article with interest. I think we're unable to comment at this time and need to take that on notice in terms of what response we can make. Of course, also the team within ASIC are aware of the reporting, and we'll consider what response we can make on notice.
I think, Senator O'Neill, I'm sure you recall, so there are particularly strong confidentiality protections around whistleblowers that do preclude us able to either make comment or even confirm whether or not whistleblower reports have been received. So I just sort of put that on the record. We're conscious of the issues you're raising and conscious, obviously, of whistleblower issues, but we're just not able to say very much about them because of those legal requirements.
What's the consequences of, Mr Mason I quoted from just then, but there's a second article on September the 16th where he cites legal action by Mr Daniel Corman and his company Scrum Data, lodged in the federal court on Friday, who alleges that the ASX sacked him just months into a 3-year contract after he made disclosures about possible misconduct or possibly improper state of affairs that represented a danger to the Australian financial system. Now, it doesn't actually say whether they were internal disclosures or disclosures to you. So can we sort of unpack, you've clearly identified that you're following procedures and you can't disclose, but if somebody discloses to their company, how out of order is the kind of behaviour that Mr Human is asserting happened to him?
Senator, I'm loath to try to give any commentary on the newspaper article and what's alleged. I think as you... So moving away from the particular example, as you noted and read out, I think the paragraph from our submissions about what the law is in relation to whistleblowers, the obligations on companies when when people blow the whistle internally. I probably can't take it much further than that. The submission sets out the obligations on companies in those circumstances.
So there's been a strengthening of the requirements to provide what's often called in these rooms a speak-up culture, where people are encouraged to whistleblow, because it actually can lead to incredible efficiencies and profit increase if problematic behaviours, practices, structural impediments are identified within entities. So what does it mean when it says here that whistleblower laws also create civil penalty provisions in addition to the existing criminal offences for causing or threatening detriment or victimising a whistleblower and for breaching whistleblowers' confidentiality, and give protections for whistleblowers in limited circumstances if they disclose to a journalist or parliamentarian after they have reported to ASIC or APRA their concern about substantial imminent danger to the health or safety of one or more people or the natural environment or matters in the public interest after 90 days. How does that operate, and how many cases of that kind have come before you with regard to whistleblowing?
Do you want to take that or do you want me to?
I'm happy for you to.
So, Senator, the what that paragraph means is that ASIC can take civil proceedings in the court seeking the imposition of pecuniary penalties where a company breaches the laws that you've read out. So in addition to criminal offences, there are now civil penalty provisions that enable that to happen. In relation to, we have had a recent matter, whistleblowing matter in the court, where the court did impose a civil penalty of $7.5 million in relation to the whistleblower contraventions of the whistleblower protections. In relation to the number of matters we've got more broadly, I'd have to take that on notice, Senator.
So if you could take that on notice and
Yes.
give a sense of, which sectors are operating in that way.
Mm-hmm.
And in the case that you've just identified, obviously, clearly that's a public matter and is now concluded. So could you give a shape and form to what that was about?
I can. So the matter itself was against Terracom Limited. Thank you. And that was a case that we filed in court in February of 2023. The allegations in the matter were against Terracom for breaching anti-victimisation provisions in relation to an employee who had alleged that the company and certain of its officers and employees had colluded with the coal testing laboratory in relation to, or the allegation was to falsify certificates of coal analysis, in effect. So what we were investigating and what the case was about was not the allegations about the certification of the coal certificates, but the actions of the company against the person who was whistleblowing at the time. So that matter was resolved in April of this year.
And in terms of the fine, did you say $7.5 million?
Yes, the order was that Terracom pay a penalty of $7.5 million, that's right.
You go on in your... do you think that was an adequate deterrent in terms of other companies abusing the speak-up culture that they assert publicly, where they basically say they love to support the whistleblowers internally but then sack them or dismiss them or demote them or hound them out in some other obtuse and often damaging way?
I think, if I'm right, again, Mr Subandra might be able to correct me if I'm wrong, I think that was the first civil penalty for breaches of the whistleblower protection, so that was an important outcome. And I think a penalty of several $1 million does send a message to companies that the whistleblower protections are important and to be taken seriously. Whether or not there would be a more significant penalty in another case, I mean, we'd have to see the facts and circumstances of another case, but it's important that there is on the record a contravention of these laws and the imposition of a penalty.
And I know you talk about enforcement and compliance on pages 32 and 33 and give some further shape to that.
Yes.
But you also make some observations about monitoring compliance with the whistleblower protection regime. How are you doing that? What is your capacity to do that? Are you interacting with any professional bodies in auditing, in the research houses, with trustees, with the banks, with any other financial institutions? Who are you monitoring with regard to whistleblowing?
So we've done a number of surveillances in relation to whistleblowing policies. Senator, we've released, for example, we've looked at the whistleblower policies and arrangements from a range of institutions. We've issued questionnaires to a number of companies to make sure that they're taking these obligations seriously. We have done a number of communications to try to help companies understand what their obligations are under these important laws. So to assist companies to understand sort of who is a whistleblower under the law, how a whistleblower is able to access the legal rights and protections that are available to them. And we've got an information sheet in relation to that, so put out for whistleblowers. Particularly, we've also got a regulatory guide called Whistleblower Policies that we have put out, and that's directed at entities who must have a whistleblower policy under the Corporations Act. So it tries to help them understand what best practice is, what good practice is for implementation, maintenance and management of those policies. We put out a media release calling on Australian CEOs to review their whistleblower policies, and we've also put out guidance for company officers and, just to pick up one of your questions, company auditors on the whistleblower protection regime. And then finally, we released a couple of years ago now a report called Good Practices for Handling Whistleblower Disclosures, and that set out a range of requirements that we considered firms with stronger whistleblower programs have. So that set out, as I say, a list of requirements and guidance to best practice in whistleblower policies and implementation.
I won't take you back to the ASX allegations, but on the public record, Mr Hullman says that the ASX, at the time that he was blowing the whistle, was using ungoverned Excel spreadsheets to misrepresent delivery progress, that is to ASIC and to the RBA, despite governance controls in the ASX delivery framework and a clear star playbook. These are really very serious matters that are being alleged here. We'll have more questions as the matters proceed in public, and we'll be interested in your views. I'm going to go to Ms Lawrence.
Thank you. I'll just need to do some rapid-fire questioning. There's no thread, so don't look for one. And I could just probably do really, really tight yes, no and brief comments if I can, just so I can try and cover some ground. So these are some examples of questions I get from constituents that I'm hopeful we've got just a clear answer we can give back to them to help me write my replies. So on superannuation, there are some superannuation companies when people apply to become a member of, that they fill out all the paperwork, disclose who their employer is. It's very clear that they may be a white-collar worker, but then their insurance defaults to blue-collar worker, which of course is set at a higher rate. And then it's the onus is on that member to look for the paperwork in the mail, to fill out more forms, send it all back in, which of course is not the thing that's on people's minds. So what can I respond to people about their rights to, you've done the right thing when you entered all the information the first time. The onus should be on surely the superannuation to work through with the insurance company what the appropriate setting is, given you entered it the first time. Why is the onus on the consumer to have to duplicate the effort and time to correct the record, which invariably favours the insurance company? It never, add a savings to the consumer.
A short form response for your constituents would be that whilst we'd need to see the specific facts to understand what rights, responsibilities and level of detail. From ASIC's perspective, one of our most acute focuses has been on member services in superannuation, model agnostic, but member services in superannuation. And as part of that, a focus on insurance in super, particularly at pivotal times. So when somebody's onboarded and, for example, are ticking insurance options and choosing those options, or equally at the end of life when someone has passed away and those who are grieving are trying to claim the death benefits. So we absolutely are calling out the trustees' responsibilities for service to those members at those points in time. Also, the trustees' responsibilities to engage with the insurance providers or other third-party providers that are part of the process, and insurance in super is something we've been really focused on. And finally, the need to ensure that processes are as digital as possible, as simple as possible, rolled into one process, and that at top of house trustee level, they're looking at these processes from the member perspective, including if they need to go back and forth and providing information, seeing it that way rather than the in the moment, and tracking and staying on top of those services.
Mm-hmm. Thank you. Are banks allowed, where they've got an account with a customer, to have no fee or low fee accounts, to then just advise the customer your account fee has increased?
Yeah, we've been doing quite a lot of work on fee-free or low-fee accounts, and I'd draw your attention to a report we did called Better and Beyond, which was about access to low and no-fee accounts. We have been looking at both that question of if someone's in there, when that might change, like where they might be flipped into a different account. And for us, what's really important is also where people are defaulted at the beginning. And we've been really encouraging banks to think about, for cohorts of people who are more vulnerable, for them to be defaulted into bank accounts which are no or low fee.
So the banks can shift the goalposts, though, on the customer, like without that choice?
I'm not aware of that being something that is able to be done.
Yeah.
The Banking Code of Conduct would be the place to have a more detailed look at access to what rights someone might have in those circumstances.
Sure, thank you. The ASIC reports notes that reimbursements or compensation of customers for scams is generally quite low, ranging from 2 to 5%. Do you have a reason why you see the rates being so low?
I think that was the same report that I spoke about earlier with Ms Jarrett, and you're right, that was a report from April of 2023.
Yes.
We found a range of reasons for why reimbursement rates were low, and it was one of the issues that we called out and took up with the banks. We found that there was a marked discrepancy between the banks, as in fact some of the banks' remediation percentages were even lower than the 2 to 5%. So that was.
And which banks were they?
I have not got it in front of me. I'm sorry, I didn't bring the report with me.
Could you take that on notice, Ms. Cook?
Yeah, I can absolutely take that on notice. So that was one of the issues that we called out, was that there was it seemed to us there was a significant discrepancy, or that was an unsatisfactory state of affairs, that consumers were getting such a small amount of remediation. So we did go back and review those findings a year or so later to see how the 4 major banks had gone in implementing the various recommendations that we'd made. And, you know, as I say, there has been some progress, and that whole issue about rectification, remediation between banks, their customers and other parts of the ecosystem that may also be involved in the losses, like the digital platforms, potentially telcos, are all part of the issues the Scams Protection Framework is going to be hopefully resolving for us all.
And from the Haynes Royal Commission, are there any outstanding monies still owed to customers by banks? And if so, which ones and how much?
That is a very good question that I'm going to have to take on notice. I think that the remediation programs, the very significant remediation programs that arose out of the Royal Commission, have been finalised, but I can. There will be people at ASIC who will know that and will certainly be able to advise what the current status is.
Particularly given they're reporting their billions of dollars of profits, I think it's perhaps time they return that money, some of that money, to the people it's owed to. Then, if I can jump to a different subject. The buy now, pay later. So a couple of years ago, you were reporting that around 20% are suffering harm from that, about 1 in 5. I won't have time to explore this, but just for a baseline so we can go into further discussions at another time. What would be the measure now? Has it improved? So I think you gave me those figures back in 2022. So in 2025, have we seen an improvement in subsequent to the introduction of regulations around it?
I think as you've alluded to, there is a new regulatory framework that took effect from June 2025, so quite a recent. The new provisions of the National Credit Act that apply. So I suspect it's a little soon, based to draw any causation from those alone. Perhaps there are other drivers that have changed for better or for worse the outcomes that you're referring to. I don't have immediately to hand stats on those harm levels.
Just on notice. Thank you.
Yeah.
Then I noted from your report you've had. Maybe not from a report, from something else I've read through your website, that you've had some success with 4 defendants pleading guilty in relation to a pump and dump on Telegram. And I was just wondering, in the context, I appreciate that one was probably quite helpful that they actually listed the chat group as ASX Pump and Dump Activity Group. But where we've got Telegram obviously having dark web or whatever they call it, chat groups and so forth, how do you feel ASIC is positioned to be able to really continue monitoring? Is it just through monitoring the activity that's happening on the ASX and then trying to find where it's coming from, or do you actually have sufficient powers to investigate apps like Telegram that are obviously offshored?
We have real-time market surveillance of all trades across the ASX, and we have a team in our markets area whose job it is to watch, monitor and do surveillance on a daily basis in relation to any trading that we have concerns about. So those matters get elevated very quickly and investigated where appropriate, and we are able to use all of our compulsory powers, including our search warrant powers. So frequently in insider trading matters or markets-related issues, we will issue search warrants, we'll recover people's devices, and that will include often chats, chat rooms and that kind of information. So that is critical evidence in any investigation or criminal prosecution of these kind of matters.
And that's just for the specifics of that type of case, but obviously we have the broad range of market monitoring. We have an Artemis system, which we can talk about at another time. And it's an opportunity for us to reinforce the importance of the reporting that we receive from entities, which has been some of the enforcement action that's been taken recently. So we have that information, have that picture of the market and can bring the data points together.
Excellent. And lastly, if I may, I appreciate we don't have an exact number about the range of 10 to 30% of Australians potentially holding crypto. And then AUSTRAC is registering cryptocurrencies, which is to give some public confidence to those, I don't even know what you call them, products that, or assets, I think it is, isn't it, that are, not undertaking criminal activity or money laundering. But I did note you've got the case on foot with Block Earner and the Earner product, and I just wonder how we can give assurance and support people who are venturing into what is clearly a very high-risk area of investments. I think I was reading Block Earner offers loans of up to $5 million in 24 hours. Clearly people can be highly exposed in this space, and I'm just wondering where you feel ASIC is at with providing consumer protection.
I said earlier in the day that we've to tread an objective path. Now, I think you made exactly the right points. I think everyone knows that trading in cryptocurrencies and any activity associated, investment activity or related activity, is likely to be very risky, and so I think that's still the case. It's not prohibited. Investors, consumers can be exposed to these products, but there are risks. It's not like dealing with an Australian dollar denominated loan or transaction.
Would you describe it as a legitimate, how would you describe it? I mean, I've heard some people describe it as a Ponzi scheme. How would you describe it?
Well, I think it's a highly risky, speculative investment. I think it's a sector that's evolving. As I said earlier in the day, we're seeing more regulation of this sector. They're looking for more certainty. But I think it's something that consumers need to be careful about. It's a speculative, high risk sort of investment activity, and so that's really all we can say. It's not unlawful to invest in these activities, but you need to go in eyes wide open, I think, is the way I would put it. Yeah.
You did disclose on 7:30 that you banked with ANZ, but are you going to disclose that you happily trade in crypto?
I'm very happy to confirm I have no exposure whatsoever to crypto.
Me neither.
It's a complicated area. It's a new area. People get very excited about it. But I think one thing we can agree on is that it is a risky speculative activity, and
I'm not sure what people are buying. That's what I can't put my finger on. Chair, I would love another day. So,
well, Let's see what Santa might bring you.
Thank you. Thank you so
Fantastic.
much for your time and for your candour with the responses. Appreciate it, and people listening do too. So thank you.
Thank you, Ms Lawrence. I'll go give the call now to Senator Pocock.
Thank you, Chair. I'm conscious that my questions stand between us and knock off, so I'll try not. I have got a few. I just wondered if you have any perspective to offer us on the robustness, the integrity of trading in Australian carbon credit units, and whether you're doing any work on ACCUs and the nature of the market.
Yeah, I can. I think Commissioner O'Rourke and I both can. So yes, we are doing some work on that space in terms of them being a financial product and within our purview. It does not go. It goes to market integrity and nature of them as a financial product, and also work with the ASX on the outlook for the market and ensuring that if the market goes, because it is something that is seen as useful and relevant, that the infrastructure and the rules accommodate that. When it comes to integrity of the units themselves, however, and you're probably well aware of that, that is not something that ASIC regulates. Of course, that's Clean Energy Regulator and all the other people in that chain. So for us, it is in that financial product sense.
You don't hold concerns about the way that is operating as a financial product?
We don't hold concerns from the perspective through which we see the product, but just really reiterate it, that's not the integrity and the underlying and the different classes that roll up to having a carbon credit and the way they're applied, etc. That is not our monitoring.
Outside your ambit.
Yep.
Thank you. We've had conversation today about the maturing of our superannuation system, which I've found really interesting, out of the accumulation phase for many Australians now and into holding sizable assets. And many people unaccustomed to having an asset that they can draw down overnight if they want to, or move, as we've said, possibly into risky other places. I've had recently in my office people from what they call member profit schemes or funds, industry funds essentially. They give their profit to members, they're not for profit, and they point me to the very uneven regulation between industry super funds and others, and they talk of a grey zone in the superannuation sector. How inclusive do you feel the regulation of super is across all the kind of different types of funds?
Yeah, so the super regulation doesn't differentiate actually between retail and industry funds, and at ASIC we're at pains to be model agnostic and focused on impact on the member, the conduct and disclosure for the member. So vis-a-vis our work, that is not something that would concern us, that level of difference or that grey area. And I go further and say, when we do our surveillance work, which at the moment we're focused, for example, on member services, we always bring within the net of our surveillance, our close surveillance, a representative sample which has industry funds and retail funds and some newer funds and some smaller funds and some bigger funds, again, because we're at pains to make sure we're looking agnostic across the system. So that is not something that we would identify as concerning us. Of course, we have to keep applying our work and the rules that way, that is agnostic, and we work backwards from how is the conduct impacting the member, what is the disclosure to the member, regardless of the fund type.
So you don't have an overview at all about risk being greater in any part of the super terrain?
Okay, sorry, a different question. I won't traverse the ground. I won't traverse the ground we've talked about today in terms of platforms and choice products and responsibilities in those. Obviously, you've heard from, it would be detrimental to all the evidence, for example, that Deputy Chair Court's given in that space, so the need to enforce the obligations in that regard. When it comes to the funds that you're describing, retail versus industry, again, we are model agnostics and there's no particular difference that we would identify between the different fund types. So if we're thinking about a MySuper product, which is the nature of your question, as opposed to a choice, a MySuper product, there's nothing that we would identify. We don't look to distinguish. In our surveillance, we'll find some industry funds and some retail funds that have better or poorer practice.
Okay. Thank you. You've mentioned as a panel a number of regulatory challenges that arrive from the Shield and Guardian experiences and potential further challenges that may become evident if your legal case with the equity trustees fails. Are you intending to put these challenges and possible remedies in writing to government, to us, or publicly? I'm just thinking, we've had a lot of discussion here. Is there an opportunity to pull it together and talk about what needs to change?
Yes, there is that opportunity, Senator. As I said earlier, we have been taking a range of the issues that we have uncovered or encountered through the course of the investigations that we have been doing, and we're certainly writing those down and taking them up, making sure Treasury is aware of them. We're engaging with APRA also, and we'd be very happy to do so, with the committee as well. It's a critically important area, and as I said earlier in my evidence, I think unfortunately there's no one simple solution. There's not a silver bullet here, but there may well be a range of legislative tweaks or gap filling that may well be appropriate, and we'd be very pleased to engage more about that.
As you do that, can I ask you to give consideration also to the ATO, especially with single touch payroll, more of visibility there when you give us that response? Back to you.
Yeah, I really welcome the kind of response that you're talking about. I think it would be really helpful to us. Yeah. This may reflect my ignorance about Shield and Guardian and so on, but we've talked a lot about the trustee responsibility. Is there responsibility also at the level of Macquarie, the role that kind of, do you call that the choice platform? Like, I don't know if we've talked so much about that level. Is that also important?
Macquarie is the trustee.
It is the
Macquarie
trustee.
Superannuation is the trustee. So when I'm using the word trustee and platforms in relation to the Shield Master Fund, I'm referring to Macquarie Superannuation and to Equity Trustees, are the two superannuation trustees that had that fund available on their platform.
Right, okay, thank you. I wanted to go to page, an issue that's been raised in relation to scams. There was a bill introduced in November 2024, I know there's been discussion today, yes, which imposes significant fines of up to $50 million on banks, social media platforms and so on if they don't take reasonable steps. Yes. I'm sorry if you have already addressed this. That's and I was not at all fussing with my notes, but how has that fine system worked? Is it having an impact? Do you feel it's going well?
Senator, the Scams Prevention Framework is the piece of law that I was talking about earlier with Ms Jarrett. So there has been the Scams Prevention Framework Act commenced on the 21st of February of this year. It's not, while the Act has been passed, there is still some work to do to make it operational, and the work that needs to be done is designation of the relevant sectors, and that's reliant on ministerial instruments as I understand it. So there needs to be a designation made of the banking sector, of the digital platforms sector and of the telecommunications sector, and then once those sectors have been designated, industry codes are going to be developed that will impose a range of, as I said earlier, very granular obligations on each of those industry participants. Once those are in place, the framework will be operational. There are some high-level principles set out in the Act itself, and just again, that Act is for the ACCC to administer, not for ASIC to administer until ASIC becomes designated and the banking sector becomes designated. So so whether or not the ACCC could take action now under that framework, under that Act as it currently stands, I'd probably defer to them. They'd probably be grumpy for me answering on their behalf and telling them they should be doing something that they shouldn't be. But I think the important point about that framework is that we need the next step, which is the designation of the sectors and the making of the codes, and then that will make very clear to industry, including the banks, from ASIC's perspective as to what their obligations are, and then we may get to penalties down the track.
Okay, great, thanks. So plenty more water to flow under the bridge there.
That, yes.
I wanted to then go to the question of auditors and conflicts of interest for auditors. And there's been some discussion about this in relation to, for example, the Big Four and whether they are appropriately on the board of a company which they have previously, when they previously worked in the Big Four, and one of the company they worked in is then its auditor. You follow that?
I think yes,
sorry,
Senator, yes.
Put it probably in a confused way.
I'm handing over to Commissioner O'Rourke.
Yeah, so I'm just interested in what's happening there, what you're doing around conflicts of interest around auditors, how that work is unfolding. You're going to publish in October, I understand.
Yeah, that's right. No, thank you. And it is an area that we've identified as complementing prior streams of work in relation to audit, which we have had the opportunity to talk about in this committee and otherwise before. So we have a long-standing program of audit file reviews, financial reporting reviews that we've looked at over the years, and independence might be one of the aspects of that. But we did identify about a year ago that it's worth thinking specifically about conflicts and independence. So we did write to all the auditors that we have email addresses for, and all the CEOs of the audit firms, to say that we were having a look at this area of focus.
Could you provide that correspondence on notice to the committee?
Yeah, no problem at all. Pleased to. So within the Corporations Act, there's both very specific requirements with respect to independence and conflicts, but also some general ones as well. And so what we did was do some data. We've got some staff members who are very capable at data programs. So we did a large-scale data matching with both internal data and external data to look across reports and relationships, to your point, to do some matching to identify whether there are areas of conflicts or independence that we could narrow in on. We let people know that we were going to be doing this work, and then we did that next level. We used our compulsory information gathering powers with those particular auditors to sort of examine more closely whether it be relationships, the relationship as in people's relationships or professional relationships, audit versus non-audit fee, that issue around the size of fees. There are also auditor rotation requirements that are very specific, so we've got to have a look at those. Long association, even if they don't move from the company to the audit firm, if there's very long association as the auditor, even if they appropriately rotate the auditors signing the thing, if the firms have very long associations, then there's questions there. So those were some of the areas that we have had a look at and have identified, whether we can take action against some of those. So it is work that's coming to fruition. We look to publishing it. Our goal is by the end of October, so about 6 weeks away. And we'd be pleased to go into more detail about each of those elements. Like I said, there's quite specific ones, and then there's the more general ones. There's also obligations to report to us that we have, I can just foreshadow, found disappointing levels of compliance with. So there's quite a few different aspects there. At a future hearing, we'd be pleased to go into some more detail.
Great, yeah. Look forward to that.
Maybe some material on notice about any action that you've taken before you come to the report publicly.
Yes, happy to do that.
Because one of the things that we discerned in previous hearings is that the first thing about conflicts of interest is people have to actually identify it before they do anything about it, and that seemed to be a very big problem. This is a very different sort of relationship mapping exercise that's going on here, Senator Pocock, from what we've seen before. Please continue.
Last thing, just going to Terracom and the whistleblower, I'm just curious, and you may not know the answer because it wasn't your job. Your job, as I understand it, is to make sure that entities follow appropriate and ethical practice in relation to whistleblowers. But I just wonder what happened to that whistleblower. Did they get any financial compensation, or because they often get totally, their lives and their families get bowled over by the business of blowing the whistle. Do you know what happened to the whistleblower? Did they get a portion of some kind of financial settlement, or were they just in a separate box?
That they weren't part of ASIC's action, Senator. And just to be clear. So our obligation is to enforce the laws as they stand in relation to whistleblowing.
Thanks very much, and thanks for all of your answers today. Much appreciated, and all your hard work.
Thank you. I was going to ask Audit slightly different questions from me with regard to the inspection of audit. We've discussed this on many occasions. In the US, the PCAOB, often called peekaboo, undertakes random audit in addition to risk-weighted audit. What are you doing with regard to randomised audit selection and
thank
observance?
You. And we're very conscious of the recommendations that were made by your sister committee, I think, in relation to this issue. So, like I said in response to the earlier question, we've had that specific deep dive on conflicts and independence. We've had a very strong focus on registrable superannuation entities, because it's the first year of audited financial reports there. But then our underlying ongoing work on audit file review has continued as well. So in 24-25 we looked at 15 audit files as part of that program, 5 for super entities and 10 otherwise, and the report in relation to those will be made available as one of those reports coming through in October. We have decided in 25-26 to increase the number of audit file reviews and to have a mix of both risk-based and randomly identified ones in response to the recommendations that we've had and queries that we've had. So it's going to be a blended approach and a larger number of file reviews. I would draw your attention, we've done this before, to the distinction between the Australian and the American systems. We don't have any audit responsibilities in relation to the firms. So the program that the PCAOB has is firm-based, whereas we are looking at particular files because we register auditors, not firms. So there are important distinctions. There's obviously much significant distinctions in terms of resourcing and otherwise, and sole action of a regulator versus a wide range of activities. So lots of differences, but in response to your specific question, we have proposed to increase the number of file reviews and change to include some randomly identified based activity. And the third piece, I think you'll also be pleased to hear, is in moving to naming which firms are the subject of those audit file reviews.
Thank you. That will be of interest. Finally, because we're going to run out of time, not because of a lack of interest, there's more to do, but I'd like to ask about the dynamics of public and private capital markets. You released a discussion paper in February of this year on the dynamics and noting the decline in public market listings and the rapid growth in private market investment. What are your concerns with this trend? What do you consider to be the factors driving it? And is this happening in other jurisdictions as well? And what can we learn from any first movers in other places?
It's a wide-ranging piece of work, Chair. The level of listings in Australia, there's been a level of concern about that. We're not alone, the same in Singapore, UK, US. So there's a whole piece of work around what we can do to encourage public markets. So I'll put that to one side for a second. In the private markets, we're particularly interested in private credit, and you can expect imminently we will publish a bit of a progress report on our work with private public markets, probably as early as next week, which will focus on private credit, and we'll have more to say about the subject in general probably during November. We'll publish an update, and there will be a piece of work around public markets which I'll ask Simone to give you a bit more detail on. There'll be a report on data and transparency. We're concerned about that we just don't know enough about what's going on in the private market space, and we think we're an outlier there, and we'll have a bit more to say about that later in the year. And the third report is probably something we'll publish imminently, and that's a piece of work we've commissioned on what's happening in the private credit space. But as far as public markets go, I'll ask Simone to give you a taste of where our thinking is going in there.
Yeah, so, and in further answer to your question, the concern comes out of our role. We're required, of course, by law to promote confident and informed participation in markets, and we are the conduct and disclosure regulator. So if you work backwards from that, public markets, a decline in listings, a decline in public markets is, of course, of concern because that is where you get the best participation. The simplest access to markets, and we are a nation of investors. I think something like 40% of us have, or more, have investments outside of super and the home. So that's great. We're proud of it. So the best way to get that access is through the public markets because there are those mature tools. There's the disclosure, there's the market clearing, there's the constant price discovery and mature participants to help you face into the market. So our analysis on the decline in markets is to understand whether there are idiosyncratic factors in Australia different to the global trend. And as the Chair has said, we've been reminded at every point on this journey, global trend. There are some differences in Australia. The rise of superannuation, for example, which is so significant, on track to be the second biggest pool in the world of pension savings. But that doesn't account for the decline in public listings. When we looked at global factors and domestic factors, and we'll have more to say about this at the end of the year, but something we have said publicly is there is not much that's come back to us that suggests it's the regulatory footprint. We had to ask that and make sure that it wasn't particularly, are the things ASIC's doing that are the big driver here.
So you're not the brake?
Now, there are things that we can adjust. We've got some good ideas, actionable ideas, to use the Chair's words, and we've put some of those in place already. And that ranges from ensuring there's competition in clearing, and there's been an announcement in that regard recently, yes, right through to some simplification and streamlining in the IPO process. Yeah. But to be really clear, this isn't just about decline in IPOs, although the numbers are clear over the past decade of that decline. This is all about companies staying on the boards also. So it's not good enough to come onto the boards. It's about ensuring, and this is the last thing I'd say about public markets, the one unifying theme is probably that around the world, and Australia is no different, companies are seeing private markets as increasingly the place for growth. Now, I don't want to destroy confidence there. That's the opposite of what we want to do. So we need to get behind what's driving that growth. But it should be that the public and private markets, they complement each other and are both opportunities for growth, and rather than cannibalising. So that's a theme. We'll have more to say at the end of the year in November when we produce. We've got an academic piece that's extensive on this. It's gone deep into this and looking around the world and these potentially structural changes. We'll be completing our list of the things, the actionable ideas we've taken in the public markets, and then in the private markets. This is about ensuring that confident, informed is on the basis of knowing there's good conduct and knowing there's good disclosure. And as the Chair's touched on that's both looking at the rise of private credit and indeed some of the products that have flowed into some of the platforms, for example, we've talked about today. Some of those are private credit, right through to generally where do we sit globally in terms of disclosure about private markets investments. So we've been doing some benchmarking. We do not want to be setting a global bar or a new norm when this isn't about adding to the regulatory burden. We just want to make sure that the approach to disclosure and information that we have is consistent with global standards for the size and risk of our market.
One of the things I love about coming to Canberra is there's a sort of culture of people thinking carefully and being nice to one another and abiding by the law. But the reality is, there are many people who are looking for a place, any gap to exploit. Where there's money, there's people who are looking at how they get it by illegal means, unethical means. In this space between public and private, what are the risks to Australians as we speak before these reports come down?
So we should not be alarmist. Private markets, when done well, including private credit, are good for investors and good for borrowers. And absolutely we're committed to there being growth in the economy, the productivity agenda, and ensuring capital flows, including where banks may not be best placed to provide that capital, including that credit. The right investors may be private investors. And indeed, we have very large superannuation funds who are, for example, sophisticated private investors. The risk is, though, as I said, that the public market is a mature market in terms of those tools of, on the price side, the price discovery and the marking to market that you constantly get. On the terms and disclosure side, we have continuous disclosure. We have clear standards of governance and listing rules. So those mature tools that more quickly get to that confident, informed participation, they're not there in full in private markets. Of course, there are company responsibilities, directors' duties, etc., that flow, but and there's a level of reporting, but it's not the same. Now, we're not saying they need to be the same. We just needed to check where there are gaps. Are the gaps still appropriate for the size of growth which you point to, which in some segments, there are some segments of private markets tripling over a handful of years at the same time as we're seeing a flatlining and indeed a decline over a 10-year period in public market listing numbers. So it's about checking whether those differences are still appropriate given that growth, given that importance. And the final thing to say is we think that growth is structural. So we are on record as already saying whereas the public market, it may be cyclical, it may be associated with liquidity, the volume of liquidity in the world, and when there is or isn't a premium for liquidity that you get from being a listed stock. In the private market, we see this as structural, like most jurisdictions we've talked to see it as structural. So is the gap appropriate? And that's the question we're looking to answer, and if not, what would be the right response from the conduct side or the disclosure side?
Look forward to further information about that as we proceed. Thank you very much for your evidence today, Commissioners. I just note, Mr Gregson, you've been beautifully behaved through the entire day.
Thank you.
And I hope you had a good rest. Thanks for being here, even though we had no questions for you. That concludes today's hearing. Thank you to all the witnesses who appeared, to Hansard and Broadcasting for their assistance. And I can advise that responses to any questions on notice should be provided to the Secretariat by the 9th of October, and the committee stands adjourned. Thank you, colleagues.